12 12 ಅಲ್ಲ ಪಲ್ಯ ಹೋದಿಲ್ಲ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮ್ಯಾನ್
My lords, this is a 26 matter, my lords. This court has passed a judgment relating to the same issue. my
Fresh
lords.
matter?
No, my lords. It's not a fresh matter, my lords. It may be taken up on orders, my lords.
No. Yes. What is the urgency? What is the grave urgency?
My lords, there is an urgency, my lords. The BDA is coming. BDA is coming to vacate my possession, my lords.
BDA is coming to vacate.
Yes, my lords.
Is it an acquisition matter or what?
Acquisition matter, my lords.
Matam date could yavuga. There's an interim order or not?
No, my lords.
No interim order.
No interim.
For consideration
It may be
interim
taken up for filing or for orders only, my lords.
final hearing.
Yes, my lords.
Oh. Which planet you come from? From which planet you come from? You are 2026 matter. There are matters from 2013, 14.
This court has passed an judgment, my lords, on the same issue.
Mister, when did you file the petition?
26.
In which month?
This year,
July.
Not July.
Huh?
February, March.
Matta, you want a disposal so quick? The other matters waiting. Yes.
25 matter, not acquisition matter.
Consideration of interim prayer and Hakim.
Because in 2003, my lord, this honorable court directed the MUDA not to interfere with the land because of lapse and part of the payment of compensation.
Told Yathon date. Yeshne isudu.
At 25, 25,
26.
at 25.
Yav layout adu.
MUDA, Devanur Badavan.
Devanur.
Where, my lord, they have on part of lapse and payment of the compensation, they approached this honorable court.
Final notification is issued or not?
No, final notification issued, but because they have not paid the compensation, my lord.
Award is passed.
Award passed, my lord. They have not paid the compensation. They approached this honorable court. Then, my lord, this honorable court passed the order because of non-payment of the compensation. Already notification became lapsed, and so directed the MUDA to not to interfere with the land. Among 1 acre 3 guntas, my lord, they utilized 18.
There's already an earlier judgment on the same ground, on the same facts.
Please, my lord.
What do you on date? Yes, Shishi.
My lord, fresh matter, my lord. Pretty township.
What do you? Huh?
Pretty township matter.
Yada?
Township.
Kodi. Yes.
Serial number 32. I pay for petition.
Please wait.
Lord, may I make a
Which year? Third. Good.
My lord, fresh matter for tomorrow.
Fresh matters. Good. Yes.
I'm grateful.
Lord, may I make a mention?
Yes, Harshvardhan.
There are one batch of Lord 3 matters Lord for B group. My colleague is Lord there for
Yada?
one Lord one batch of Lord 3 cases. Lord for Lord B group Lord for tomorrow Lord if your lordships can accommodate.
There's nobody here.
I'm sorry, my colleague.
What's his name?
Madam Archana Murthy Lord. I'll ask her to
Anjan Murthy.
Archana Murthy Lord. I'll ask her to Lord submit.
Archana Murthy. Anybody by name Archana Murthy? There's no one here.
I'm sorry, my lord. I will ask her to present, my lord, if it can accommodate for tomorrow, my lord. I was.
Yes.
My lord, one mentioning, my lord. My lord.
Page number 4, serial number 16 to 20.
My lord, one mentioning.
Page number 6, serial number 27 and 28. Page number 8, serial number 29. Page number 9, serial number 30 to 33.
Serial number 32, my lord.
32.
Next week. I inform the other side.
Learn counsel for the petitioner seeks time list on so and so.
13th August. Page number 10, serial number 34 to 39. Page number 11, serial number 40 to 45.
Number 41, my lord.
41.
Respondent 1 and 2.
I am for the petition.
What's your name? Vijay Kumar. Serial number 41 ನಲ್ಲಿ office is directed to delete the name of Mr. Basavaraja HT as the counsel for R1 and R2 and continue the name of Mr. NG Vijay Kumar. Learn counsel for the response 1 and 2 seeks time list on so and so.
13th August. Page number 12, serial number 46 to 52.
Serial number 52, my lord. I pay for the petitioner. May I request for 2 weeks, my lord?
Learn counsel for the petitioner seeks time. September could list on so and so.
2nd September.
I'm grateful, my lord.
Page number 13, serial number 53 to 55.
Correct.
List number 1 for
My lord,
non-compliance first
my lord,
line.
one submission, my lord, one for a posting, my lord, one memo. My lord, your lordship had given one direction in a BDA matter for the respondent BDA to file a report after survey. In this matter, the survey report is also ready and notices were also issued and survey is done, my lord. Now the other sides who are coming and disturbing in this litigation are trying filing OAS and multiple OSs. Therefore, this matter may be taken up on Monday, my lord.
Which year?
26,
In
my
which
lord.
year
Your lordship has altered interim order only on 27th. There is a interim orders granted by your honor, and the survey is also
This is
completed, my lord.
2026 matter. We'll not
Yes,
take it up out of turn.
my lord. Your
We'll give.
lordship has given a directions to file a report in which the report is also ready, my lord. That's the reason, my lord.
What is the next date of hearing given in the case?
My lord, 3 months, my lord, in the contemplation that notices should be given. Notices are already given and the report is also ready, my lord.
Already date ಕೊಟ್ಟಿದ್ರು date ಕೊಡ್ರಿ.
Monday, my lord. Monday. Oblige, my lord. Oblige.
Serial number 34, my lord. Request for an adjournment for Monday, my lord. Instructions to withdraw. I'm seeking instructions for withdrawal of the petition.
ಇದ್ಯಾವ್ದು ಹಿಯರ್ ಮಾಡಿತ್ತಲ್ಲ ಇದಾಗಲೇ.
Withdraw ಮಾಡ್ಕೋತೀನಿ that ವಿಶ್ವಭಾರತಿ matter. Withdraw ಮಾಡ್ಕೋತೀನಿ. Monday ಹಾಕೊಂಡು ಅವ್ರ secretary ಇಲ್ವಾ ನಾನು.
The learned counsel for the petitioner seeks time. List on Monday. Monday. Yes.
My lord,
List number 1 for non-compliance.
my
Serial
lord,
number 1,
I
Mohammed
appear
Niaz.
for the petitioner
Mohammed
in serial
Niaz.
number 10, my lord. My apologies for the
Mohammed
inconvenience,
Niaz.
my lord.
I am for the petitioner.
Yes.
Well, in this case,
Office objections.
well, in this case, my lord, clarification is whether respondent land acquisition officer, my lord, comes under state or central, my lord. I stated in the cross title, my lord, it's National Highway Authority of India. Urgency is, my lord.
What is the relief sought for?
My lord, this is without my due process of law, my lord, my private land, my lord, acquired my for wide road wide.
So should you not impede the proper parties? Will the compensation be paid by the land acquisition officer?
Special land.
Who will pay the compensation? Who should pay the compensation? Who has to pay compensation, mister?
National.
Huh?
Special land acquisition officer.
Office objection raise ಮಾಡಿದ್ರು if you don't apply your mind, I don't know how. Who should pay the compensation? Land acquisition officer.
National Highway Authority, my lord.
It's the government of India.
Of India. Union of
ಮತ್ತೆ ಎಲ್ಲಿ ಮಾಡಿದ್ರ ಪಾರ್ಟಿನ? ಯೋಚನೆ ಮಾಡೋದಿಲ್ವಾ? What have you sought for? You sought for compensation.
Yes, without my lord, without acquiring my property.
But then you have to impede proper parties, mister. File an application to impede proper parties.
Kindly have it tomorrow, my lord. The urgency is, my lord, my property, my lord, they have kindly see the photograph.
You want compensation, isn't it?
Yes, my lord.
We'll get you the compensation, but you add proper parties.
My lord, they are in the, at present, my lord, they are in the premises, my lord. Without acquiring my property, they are demolished my residential houses, my lord. That is in danger. They are admitted in their own admission, my lord. Kindly see, my lord.
It's already demolished.
Demolished. Half of the property is demolished, my lord.
Then what will you do with the remaining half?
My lord, kindly see the annexure P, my lord. For the moment, my lord. Their own admission, my lord. Survey inspection has been done. Spot inspection has been done. Survey has been reported, my lord. Survey report has been placed, my lord. Kindly see, my lord. Last para, my lord. In this regard, the office of surveyors made spot inspection and submitted report as per the survey report, extent of 71 square meter in survey number 207 of 112 of Belur village has been acquired, my lord, in access to the land for National Highway 75, and the road work is completed, my lord. As the time of payment, the compensation only for the structure value is paid, my lord.
Pending complaints of office objections and also impleading necessary parties, the respond number 2 is restrained from demolishing the any portion of the house belonging to the petitioner in property bearing number
207, 12 and 11, my lord. Commercial property also demolished, my lord.
property bearing number
207 bar 11.
property building ఏమైతే situate in survey number 207 bar 11, 207 bar 12 and 207 bar 1A, 1J2.
Yes.
Your house is situated on 3 survey numbers.
House is situated in, my lord, 207 bar 11, my lord.
207 bar 11 ಅಷ್ಟೇ ಕೂಡಿ ಸಾಕು.
207 bar 1J2 is a commercial property. That is also in danger, my lord. That kindly see the photograph.
Sir, you have produced the photographs of the house.
No, last photograph, my lord. Annexure R is the commercial building, my lord. That is also not edge of the taken edge. That is also in danger, my lord.
No, but you said only 71 square meters.
Square meter in survey number 207 bar 12, my lord. House is in 207 bar 11. That is 5 cents.
They want to acquire 71.
All three.
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ನೋಡಿ 71 square meters in survey number 207 bar 12 of Biliyuru.
Of Biliyuru village. The same, my lord. House is situated in 207 bar 11.
11 ಗೊತ್ತಿಲ್ಲ ಕೇಳ್ತಿರೋದು ಬರೀ 207 bar 12 ಅಲ್ಲಿ ಮಾತ್ರ.
House is 207, my lord.
ಏನ್ ಮೇಡಮ್ ಆಯ್ತು ಎನಿ ಸ್ಟ್ರಕ್ಚರ್ಸ್ ಇದು ಎನಿ ಹೌಸ್ ಬೇಡ ಎನಿ ಸ್ಟ್ರಕ್ಚರ್ ಸಿಚುವೇಟ್ ಆನ್ ಸರ್ವೆ ನಂಬರ್ 207 bar 12 of Biliyur village, Bantwal Taluk, Dakshina Kannada.
207
till the next date of hearing. Yes.
207 11, my lord.
11 ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ ಅಲ್ಲಿ.
507 ಇದೆ ಸರ್. 5 cents ಜಾಗ
11 ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ ಅಲ್ಲಿ. 71 square meters in 207 bar 12. That is all they say.
ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಡಾಕ್ಯುಮೆಂಟ್.
ಎಲ್ಲಿದೆ ಪ್ರೊಡ್ಯೂಸ್?
RTC ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಅನೆಕ್ಸ್ ಕನ್ವರ್ಷನ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
You not produce the notifications.
ನೋಟಿಫಿಕೇಶನ್ ಪ್ರೊಡ್ಯೂಸ್
ಎಲ್ಲಿ ತೋರಿಸಿ ಇದ್ರಲ್ಲಿ 207 ಅಲ್ಲಿ ಎಷ್ಟು ಅಕ್ವೈರ್ ಮಾಡಿದ್ದಾರೆ?
ಇಲ್ಲ ನನ್ನ ಪ್ರಾಪರ್ಟಿಯನ್ನು ಅಕ್ವೈರ್ ಮಾಡಲಿಲ್ಲ.
ತೋರಿಸಿ ಎಲ್ಲಿದೆ ನೋಟಿಫಿಕೇಶನ್?
ಅವಾರ್ಡ್ ಕಾಪಿ my lord. Kindly annexure H.
Where is the notification?
Annexure J, my lord.
Annexure
J, page number 43. ಅದರಲ್ಲಿ ಬಿಲಿಯೂರ್ ವಿಲೇಜ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಸೆಕೆಂಡ್ 44 ಅಲ್ಲಿ ತೋರಿಸ್ತದೆ ಕೆಳಗಡೆ. 207 1A J 1J1. It is government land. ನನ್ನ ಪ್ರಾಪರ್ಟಿನ ಅಕ್ವೈರ್ ಮಾಡಲಿಲ್ಲ.
One Kalsma till the next date pending complaints of office objections and also adding necessary parties. The respondent number 2 is directed not to demolish any constructions existing on survey number 207 bar 11, 207 bar 12 and 207 bar 1A, 1J2. A1 J2 of Biliyur village, Bantwal Taluk, Dakshina Kannada. Till the next date of hearing. List on date code. Mr. Adun Melaki, Mr. Shobhit N. Shetty is directed to accept notice for respondents 1 and 2.
28th August. For orders matter serial number 2, Vinayak B.
For the petitioner.
R2. For called memo of retirement filed by the learned counsel for the respondent number 2 is accepted. Office is directed to delete the name of Mr. K. Krishna. Na? Yar file madru?
Murgesh Charan.
K. Krishna. Alla memo hakkidaru. Murgesh Charan. Office directed to delete the name of Mr. Murgesh V. Charati as a counsel for R2 and continue the name of Srimati Poonam Patil. Office is also directed to delete the name of Mr. K. Krishna.
Please.
You ready, na?
No, this, no, in this is been interested by NOC. They say objections are filed.
Counsel for the respondent number 2 seeks time list on so. Somshekhar.
13th August. Serial number
Sachin
3,
BS.
Somshekhar KM.
Just now I received the report of the commissioner, court commissioner.
Yeah, report is too bulky, is it?
Report is been filed yesterday only.
It's not at
Yaragappa,
Kutappa.
whom do you represent?
Court commission.
Court commission.
Court commissioner, huh? What does the report say?
My lords, if you see the page number 14, my lords, annexure
Huh?
B, I have sketch ಮಾಡಿದ್ದೀನಿ, my lords. Opposite to the petitioner land, it's a vacant land. my lords. The Gori and the Masjid is situated in 782, 795 and 796, my lords.
So in opposite line, there
It's
is a,
vacant.
there's a stray of, there's a line of sites.
Which is vacant. my lords.
There are sites opposite to the site allotted to him.
ಹೌದು.
They are all vacant.
On site
And
ಎದುರುಗಡೆ.
beyond that is the masjid.
ಹೌದು.
So the masjid is not in front of his house.
No.
Your Lordship, kindly see the
not
page,
masjid, my lords, it's
page
dargah.
14,
It's a dargah.
page 14 of the sketch produced by the court commission.
Page
14,
last
annexure B. In the commissioner report, page 14.
Page 14.
Annexure B, my lord.
Bande.
ನಂದು 763 petitioners land ಅಂತ ಇದೆ.
Hmm.
ಆ ಲೈನ್ ಅಲ್ಲೇ 784 ವೇಕೆಂಟ್ ಅಂತಾರೆ, 783 ವೇಕೆಂಟ್. 782 there is an Agori.
782?
Gori.
Gori. ದರ್ಗಾ ಬಂದು 795 and 796 ಅಲ್ಲಿ.
ದರ್ಗಾ ಮಸ್ಜಿದ್ ಬಂದು 795 and 796. ಆ ಲೈನ್ ಅಲ್ಲೇ 782, 783, 784 also occupied by them also. It belongs to Gori and Masjid ಅಂತ.
783, 784 ಯಾರು ಗಲಾಟೆ ಆಗಿದೆ?
Pass it over. It's colleague ಬರ್ಬೇಕು. It's held up in another court.
The
Placed
report submitted by the court commissioner is accepted. Copy, the court commissioner submits that he has served copies of the report to the learned counsel for the petitioner and the learned counsel for the respondents. Full stop. The learned counsel for the respondents is directed to ascertain as to whom the site bearing number 783 and 784 is allotted. And 782, 783 and 74 is allotted. Yes, list on yavat helti.
That's next week.
Fees banta. You got your fees? You need anything more?
Enough.
List on yavat.
That's next week. Need.
13th August.
Please.
Serial number 4,
Oblige.
Vasant Kumar HT.
My lord, in this matter, affidavit is ready.
This court has directed the council to file affidavit.
Affidavit is
Non-filing
ready, my
of
lords.
affidavit.
Not filed affidavit also, my lords.
I have sent it for signature, my lords. A short
Learned
accommodation.
counsel for the respond number 1 and 2 seeks time to comply the order dated 23/2/2026. And last time yaru bande illa ನೀವು?
Last time I was there, my
There is
lords.
nobody here.
It was passed over, my lords, at that.
Nobody came. List on yavat.
Next week, Thursday, my lords.
13th August. 13th August, serial number 5. PM Sidmalappa.
Memo for retirement ಯಾರ?
I filed that.
You have filed.
Please, sir.
Notice ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ, ಅವ್ರು ಬಂದು ಫೈಲ್ ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ.
ತಗೊಂಡೋಗಿದ್ದೀರಾ? ಬರ್ಕೊಳ್ಳಿ. A memo of retirement is filed by the learned counsel for the petitioner, which is countersigned by the petitioner. In that way of the matter, the memo of retirement is accepted and the learned counsel for the petitioner is permitted to retire. Office is directed to delete his name from the causes and show the name of the petitioner. List on date code. This Rajaram.
20th August, serial number 6, Rajaram S.
I am the petitioner, my lord. This LAC appeal was dismissed on the basis of delay, my lord. The award was not passed, my lord. Hence we fail a writ petition.
Writ petition ಹೆಂಗ್ ಬರುತ್ತೆ?
The award
You did
passed.
not file an MFA.
My lord, MFA file ಮಾಡಿ maintainability ಆಗಲ್ಲ ಅಂತ ಹೇಳಿ dismiss ಮಾಡಿ.
ಎಲ್ಲಿದೆ?
ಇದು ಈ ಕೇಸ್ ಅಲ್ಲ, my lord. Similar matter.
ಎಲ್ಲಿ ಕೊಡಿ?
Judgment. Similar matter dismiss
ಕೊಡಿ,
ಆಗಿದೆ.
ಎಲ್ಲಿದೆ ಅಂತ? Should not come armed with everything. When you go to warfare, you will not say, I left my sword in my house. ಯುದ್ಧಕ್ಕೆ ಹೋದಾಗ ಕತ್ತಿ ಮರ್ತೋಗಲ್ಲ ಅಲ್ಲ? ಕತ್ತಿ ಮರ್ತೋಗ್ತೀರಾ? So you should come prepared. You are saying that in some matter it is decided. Which matter?
I kindly pass over, my lord. I will
Pass over.
Serial number 7,
Sundaresh HC.
They appear for petition in this case. Notice await ಅಂತ ಬರ್ತಾ ಇದೆ R3.
List after service of notice to respondent number 3. Yes.
Serial number 8, Sundaresh, 8 also same.
We should list after service of notice to respondent number 3.
The interim order ಇದೆ, kindly be extended.
Interim order ಇದೆಯಾ?
Interim order.
Interim order granted. ನೋಡಮ್ಮ ಇಲ್ಲಿದೆ. The extent to the next date. Serial number 8 ಅಲ್ಲಿ IA 1 of 26 is allowed.
Serial number 9 for hearing on IS, Kevin Narasimhan.
I appear for the petition.
I appear for the respondent
Any
number 1,
objection?
filing my objections to the amendment application.
Oh. Yes, what is the amendment sought for?
Seeking for a separate prayer of declaration of a final
Yes,
notification.
file the application. So please allow him to make submission.
Yes. My lord, initially this writ petition, my lord, had been filed in view of the fact, my lord, that my property was demolished high-handedly by the Bangalore Development Authority.
Oh.
Now, seeking a declaration that such a demolition is illegal, my lord, the writ petition came to be filed. My lord, belatedly, that is, my lord, in the year 2025 December, they filed their statement of objection stating that the property in question
IA
stands
for
acquired.
amendment ಎಲ್ಲಿದೆ?
The objection was filed on 8/12/2025, my lord, where they said that the land in question that falls in survey number 88 stands acquired.
So what was the petition initially
The
filed for?
petition initially, my lord, was seeking a declaration that the demolition that was undertaken by the Bangalore Development Authority was illegal. And my lord, for consequential relief, that they must restore the property back to its original shape.
But how many times you want to amend the petition? You already
My lord.
amended once.
No, the amendment was because, my lord, during the pendency of the writ petition, third-party rights were created by BDA. To implead him, my lord, I had filed an application, impleadment application was allowed, and that is where the amendment took place.
Yes, Mr.
Filing my objections. saying
Barkol. What is your, do you have any serious objections?
the petitioner claims that he was not aware of the said or the notification. However, my additional statement of objections, next read at page number 38, my lord. Petitioner was made aware in the year 2013 itself regarding the said final notification which dated back to 1979.
No, but he's not challenging the notification.
It is challenging
My lord,
the
I'm-
notification by the amendment.
I'm seeking, my lord, the land acquisition has lapsed because in their layout plan, my site doesn't figure at all.
46 years, my lord. Seeking the appropriate remedies to approach the civil court. Seeking declaration.
Yeah, the IA 1 of 26. Chha, where is IA 1 of 26? IA 1 of 26 ಅಲ್ಲಿ ಏನು ಕೇಳಿದ್ರೆ ಓದಿ
My lord,
ನಿತೀಶ್?
please, my lord. My lord, I am seeking one paragraph to be inserted in prior column, my lord, to seek a declaration that the acquisition proceeding stands lapsed as far as the property in question is concerned. Page number 3, my lord, of my application. 2/7/2026, my lord, application is filed.
ಇದು IA 1 of 20, Mr. IA, where is IA 1 of 26? Should have IA. Extension of interim order. Barkol, IA 1 of 26 is filed by the petitioner to amend the writ petition to incorporate additional facts and additional prayer. Full stop. It is stated in the application that the petitioner had sought for a declaration that the demolition undertaken by the respondents on his property, demolition undertaken by the respondents is illegal. And the petitioner, in his petition, stated that the demolition undertaken by the respondents on his property, demolition undertaken by the respondents on his property is illegal. And the petitioner, in his petition, stated that the demolition undertaken by the respondents on his property, demolition undertaken by the respondents on his property is illegal. and sought for a direction to the respondent number 1 to restore the demolished structure and pay compensation of rupees 5 lakhs. The respondent entered appearance and filed its statement of objections, but it did not produce any documents to show that the property of the petitioner was acquired. Thereafter, respondent number 2 was impleaded. Full stop. The respondent number 1 then filed an additional statement of objections, where for the first time it contended that the final notification was issued on 10/9/1979 in respect of the land bearing survey number 88/2 of Khatri Guppe village. Petitioner claims that he was never aware of the final notification, but was under the belief, based on the endorsement issued by the respondent number 1, that his property was not subject to any acquisition proceedings. Full stop. The petitioner contends that the statement made by the respondent in its additional statement of objections has given rise to a cause for amendment of the writ petition. Full stop. The petitioner therefore seeks to place on record additional facts to challenge the final notification, and also seeks for a declaration that the final notification dated 10/9/1979 has lapsed. Full stop. This application is opposed by the respondent number 1, who contends that the fact of acquisition of the property of the petitioner was mentioned in the
Year 2013, my lord, annexure
in the year 2013, when the statement of objections was filed.
No, the petition itself was filed in 2017. 3 years prior to him filing the petition itself, he was made aware of the acquisition.
How was he made aware?
By sending the Himbara, my lord, if I may take your lordship to
ಎಲ್ಲಿದೆ ಕೊಡಿ.
my additional statement of objections, page number 38.
This application ಇಲ್ಲೇ ಇದೆ ತಡಿಯಪ್ಪ. Additional statement of objections is filed on 1911. When was it filed?
8/12/2025, my lord.
Is 1911 ಯಾವ್ದು ಇದೆ additional statement of objections? ಕೊಡಿ, ಯಾವ್ದು? Nine 12/2019.
8/12/2025, my lord. An additional statement.
Not in the page number 38, annexure R8. Himbara dated 21/10/2013.
Page number 38, is it?
This is addressed by the BDA to the petitioner.
Please read.
ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಉತ್ತರಹಳ್ಳಿ ಹೋಬಳಿಯ ಕತ್ತಿಗುಪ್ಪೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 88/2 ರ 31 ಗುಂಟೆ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರದಿಂದ ಬನಶಂಕರಿ 3ನೇ ಹಂತ ಬಡಾವಣೆ ರಚನೆಗಾಗಿ ದಿನಾಂಕ 10/9/1979 ಅಂತಿಮ ಅಧಿಸೂಚನೆಗೆ ಹೊರಡಿಸಲಾಗಿರುತ್ತದೆ. ಅದೇ ಜಮೀನು ಈ ತೀರ್ಪು ಅನುಮೋದನೆಯಾಗಿದ್ದು ದಿನಾಂಕ 10/3/1982 ಸ್ವಾಧೀನಕ್ಕೆ ಪಡೆದು ತಾಂತ್ರಿಕ ವಿಭಾಗಕ್ಕೆ ಹಸ್ತಾಂತರಿಸಲಾಗಿರುತ್ತದೆ. The last 3 lines. ಸದರಿ ಜಮೀನು ಪ್ರಾಧಿಕಾರದ ಸ್ವತ್ತಾಗಿರುತ್ತದೆ. ತಾವು ಸಲ್ಲಿಸಿರುವ ದಿನಾಂಕದ 27/9/2007 ಹಿಂಬರವನ್ನು ಪ್ರಾಧಿಕಾರದಿಂದ ನೀಡುವುದಿಲ್ಲ. ತಾವು ಸಲ್ಲಿಸಿರುವ ಹಿಂಬರವು ನಕಲಿ ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ ಬೋಗಸ್ ದಾಖಲೆಯಾಗಿರುತ್ತದೆ ಎಂಬುದಾಗಿ ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿರುತ್ತದೆ.
Yes.
In the year 2013 itself, the petitioner was made aware that
This application is opposed by the respondent number 1, who has filed a detailed statement of objections contending inter alia that the application is belated, misconceived, and lacks bona fide, and is therefore liable to be rejected. Full stop. It is contended that the respondent number 1 had filed its detailed statement of objections and additional statement of objections, along with which an endorsement dated 21/10/2013 was enclosed, which was in response, full stop. This endorsement was in response to an RTA application filed by the petitioner on 24/9/2013, whereby the petitioner was informed about the acquisition of land in survey number 88/2 of Khatri Guppe. Full stop. It is therefore contended that the petitioner has slept over his rights from the year 2017 till date, and therefore the application for amendment of the writ petition is not bona fide, but is an attempt to protract the proceedings. Full stop.
And I have filed my rejoinder and specifically
stop.
stated that it has not been served upon me.
The
In fact, my lord, it was also served upon the predecessor in title of the petitioner as well. Mr. Vasu.
It is therefore contended that the application filed by the petitioner is not bona fide and is hence liable to be rejected. Next, by consider submission made by the learned counsel for the petitioner. The learned counsel for the petitioner reiterated the above, submitted that the amendment sought for is necessary to fully and finally adjudicate the cause of the petitioner. However, the learned counsel for the respondent submits that the application is not bona fide, but is an attempt at protracting the proceedings. Full stop. He contends that the petitioner was fully made aware of the acquisition in the year 2013 itself, and therefore the application now filed is not honest and bona fide, and hence is liable to be rejected. I consider submission made by the learned counsel petitioner and the learned counsel for the respondents. Next para. Respond number 1. Next para. The petitioner has claimed that the acquisition initiated by the respondent has lapsed, and therefore wants to bring on record facts in support of this contention, and has sought for a prayer to declare that the acquisition has lapsed. Full stop. The petitioner, when did you purchase this property?
My lord, I purchased in the year 2011, my lord, 9/5/2011.
And then how are you entitled to claim this relief?
My lord, there were series of transactions that had taken
Correct,
place.
but after the acquisition, how are you
My
entitled
lord, this was, my lord, never, my lord, implemented. I have been given khata, my lord.
Acquisition of
sanction
law
plan.
is a subsequent purchaser cannot
Lapsing
raise.
is something, my lord, that I can seek. I may not
That
be able
also
to,
you
my lord.
cannot seek is the law.
My lord,
That also you cannot seek is the law.
I have this, my lord, as a prayer. My lord, I'll also, my lord, assist my lordship on the aspect that lapsing, whether I
I'll
can
give
be
you the
able.
judgment. Kodre, the V. Chandrasekharan was the state of Tamil Nadu, and Delhi, NCT Delhi. Kodre. Kodre ಅವರು.
ಅವ್ರು ಹಾಕಿರೋ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ನಮ್ಗೆ ಬದಲಿ ಹಂಚಿಕೆ ಪತ್ರ ಅಂತಾನೂ ಇದೆ ಲಾರ್ಡ್ಶಿಪ್ R2 ಗೆ. ಕ್ರಯ ಪತ್ರ ನಮ್ಮ ಹೆಸರಲ್ಲೇ ಇದೆ.
ಕೊಡಿ. ಇದು ಕೊಡಿ, ಆಮೇಲೆ ಅದು ಕೊಡಿ. NCT ಡೆಲ್ಲಿ ಕೊಡಿ. ಮಾನವ ಧರ್ಮ ಅದೇನೋ ಇದೆಯಲ್ಲ ಕೊಡಿ. ಕೊಡಿ.
ಬದಲಿ ನಮ್ಮ ಹೆಸರಲ್ಲಿ
ಅದು ಕೊಡಿ, ಚಂದ್ರಶೇಖರ್ ಅದು ಕೊಡಿ. ಶಿವಕುಮಾರ್ ಜಜ್ಮೆಂಟ್ ಕೊಡಿ. ಏನಾಯ್ತು? However, the petitioner is a purchaser who has, a purchaser is a person who has purchased the property long after it was acquired, long after it was notified for acquisition. Full stop. Therefore, in view of the law declared in Chandrasekharan versus State of Tamil Nadu and the judgment of the apex court in Shivkumar and others versus Union of India 2019 Part 10 SEC 229 and the judgment of Judgment in 2023, Part 19 SEC 549 and 2012 to Part 12 SEC 133. The petitioner cannot challenge the acquisition on the ground that it has lapsed. Therefore, the amendment sought for is ex facie not maintainable at the instance of the petitioner. In that view of the matter, IA 1026 is rejected. Yes. This for preliminary hearing in B group on date code.
14th August.
Interim order.
Interim order granted at least extent till the next date.
Serial number 10. Archana K.
KM Archana.
Archana K.
For the petitioner, my lord, senior is indisposed, my lord. Kindly may be taken up on the next date. Senior is indisposed due to health reasons, my lord.
The Lord Counsel for the petitioner. Yeah, the IA for direction in who has filed?
My lord, we have
What is the
filed.
direction? To conduct survey and submit a report to this court. What survey? This for preliminary hearing in B group on date. IA 1024 shall be considered along with the main petition. This for preliminary hearing in B group on date.
14th August.
Say Nagarajappa.
Petitioner. The site was, my lord, allotted. The Sarvam Vishweshwaraya layout.
An amendment,
Amendment during, my lord, we have filed a writ petition in the year 2025. My lord, even the BDA has not disclosed. This was, my lord, the site which was allotted to me was, my lord, disposed of by the BDA by way of a public auction. I sought for, my lord, impleading the person who is.
But what is the amendment that you are seeking for?
Amendment to, my lord, to quash the allotment letter made in favor of the third party.
Notice ಹೋಗಿದೆ impleading ಮೇಲೆ.
ಈಗ ನಮಗೆ 22 ನಲ್ಲಿ ನಮಗೆ ಗೊತ್ತಿದೆ. They have not disclosed even their statement of objection. The site was disposed of to a third party. When we are litigating in respect of my site.
But should you not implead that?
I filed application for impleading amendment and all, my lord. Three applications.
ಎಲ್ಲಿದೆ? IA 3 for?
IA 1 for, my lord, amendment of WP filed. My lord, IA 3 for stay, my lord, that may be considered along.
Where is the application for impleading?
My lord, first IA 2 for 26.
That is for amendment.
Amendment.
IA 1 of 26.
Sorry, my lord. IA 1 for.
Notice ಹೋಗಿದೆ IA ಮೇಲೆ?
ಇಲ್ಲ ಹೋಗಿಲ್ಲ.
Issue notice on IA 1 of 26.
Respondents.
Issue notice on IA 1 of 26. 2 of 26 and 3 of 26 to the proposed respondent. Yes.
Please.
IA 1 of 25 is allowed anta madam.
Please. Serial number 12, Manjunath Reddy.
Manjunath Reddy.
Lord, appearing for petitioner in WP 2690 of 2026. This is Mira Judicial Employees House Building Society.
Yes. What happened?
Said you this. No, my lord, we seeking leave to file an affidavit on behalf of the society with document. Whatever the doubt, my lord, the other side expressed, we wanted to get it clarified through that affidavit, my lord. That the affidavit, let they can take, we will survey a copy on them. If they want to have a comment on that, let they can have a comment on some other day, like tell us, my lord, what other riders to be imposed. We are ready to take care of the society in all respects.
Why don't you place on record that affidavit?
Affidavit, my lord, they are giving. My colleague is giving now. It is now. Copy is supposed to be.
No, you were never asked to file any affidavit.
The vendors to the society, the sale deed dated 7/7/2026. They have given a sworn affidavit, thereby, my lord, acknowledging the receipt of the entire sale consideration amount of 3 crores 10 lakhs from the developer. And, my lord, they also, my lord, stated that, my lord, they have absolutely no claim, right, title, possession over the property in question. They have conveyed the same in favor of the society. The property is now, my lord, the absolute property of the society. All declaration, my lord, they have made.
No, but then the money has not gone from
my
the
lord,
society.
that they have, my lord, stated in the affidavit that entire consideration they have received.
In fact, no consideration was transferred. No consideration have been transferred between the developer and the society, my lord.
Yes.
Lord, I have.
Therefore, the sale deed was executed by the developer in lieu of some other arrangements made with the society.
What was the order passed on the last date?
My lord, order passed by lordship may kindly go to 23/7/2026 order, my lord. There are 5 objections, 8 doubts have been expressed. Can I read it, my lord?
Yes.
The learned counsel for respondent number 5, however, submit that the site the sale deed executed on so and so is not in accordance with the order passed under section 68 of the Karnataka Cooperative Societies Act. He submits that vendors of the sale deed had purchased the property from the developer. Therefore, the vendors are bound to reconvey the sites to the developer, and the developer shall thereafter convey the same to the members of the petitioner society. He also contends that consideration for the sale deed is not parted by the petitioner society, but it is by the confirming party. Therefore, the sale deed cannot stand the test of law questioned before any court. He therefore submits that sale deed executed in favor of the petitioner society cannot be accepted. A perusal of the sale deed either executed in favor of Ramesh Babu and others would show that it was executed by the developer Mr. Lakshman on 25/8/2023. Said Lakshman is stated to be an aggregator who had aggregated the agricultural land for the purpose of formation of the layout for the petitioner society so that it could register the site to its members. In that view of the matter, this court is presently of the opinion that sale deed had to be executed in favor of the developer and not in favor of the petitioner society. Absolutely, there is no contract of transfer inter between the society and the developer. Some arrangements have been made. In that arrangement, my lord, it's a very triangular site consisting of larger extent. It could not could not have been.
I
Anyhow, my lord, we
have strong objections, my lord. Please see, I'll just filing a convenience compilation because there are 3 writ
That's
petitions.
fair enough. I mean, this affidavit you want to controvert or not?
Yes, my lord, I definitely
Then you
want
file
to.
whatever objections you
Yes,
want.
my lord. My lords may give me 2-3
An
days time.
affidavit is filed by the learned counsel for the petitioner. Affidavit of
My lord, the
secretary of the petitioner society is filed.
and also joint affidavit filed by the purchasers. Now they are retransferred in favor of the society.
To sustain the sale deed dated 7/7/2026. Executed in favor of the petitioner society. The learned counsel for the respondent number 5 submits that the respondent number 5 has serious objections against accepting the affidavit filed by the secretary of the petitioner society, in charge secretary of the petitioner society. Full stop. Hence,
2 days time, my lord. I file it by Monday, my lord.
made one sentence again. Affidavit is filed by the same is taken on record ಅಂತ ಹೇಳ್ಬೇಕು. List on ಯಾವತ್ತು?
Monday or Tuesday, my lord.
Take whatever date.
Tuesday.
Monday ಇಲ್ಲ. Thursday. Next Thursday.
13th.
Yes. Tuesday ಇಲ್ಲ. Thursday and Friday ಮಾತ್ರ.
14th ಆಗ್ಬೋದು.
14th.
18th ತುಂಬಾ ದೂರ ಆಗತ್ತೆ.
14th, yes, next. 14th, yes, next.
Number 13, CM Nagbhushan.
CM Nagbhushan. ನೀವು ಯಾರಿಗೆ? Whom do you represent?
In seal number 12, he is the petitioner. 12.1, I represent the petitioners. My lord. In seal number 12, directors have filed.
KC Annegowda ಅಂದ್ರೆ ಯಾರು? You are the director. ನಿಮ್ದೇನಿದೆ ರೋಲ್? ನಿಮ್ದೇನಿದೆ ರೋಲ್?
They have challenged the order of disqualification passed.
That is okay, but only so far as execution of the sale deed is concerned. How are you concerned? 14th, yes, next. CM, Mr. CM Nagbhushan.
They have to file objection KDB. They have not given me a copy.
Not filed.
Madilla.
ಇದೆಲ್ಲ ಅಕ್ವಿಷನ್ ಆಗಿದೆ ಅಂತ.
KDB objection ಆಗ್ಬೇಕು ಅಂತ ಅವ್ರು ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. Unless they file an objection, I can't make any submissions.
Here vacating stay.
Vacating is filed by my lord, the respond number 5. Lord, the issue, my lord, is.
Respond number 5 is filed vacating.
Yes.
Be passed over, my lords.
Here, what is challenged?
Lord, the prayer, your lordship, kindly see the prayer. My lord is seeking, my lord, injunction order, my lord, in the High Court under 226. Acquisition proceedings are not challenged.
I'm not seeking injunction, your lordship.
Lord is ultimately, my lord,
And
if
is
lordship,
not
my lord, see
acquired.
the.
They are trying to.
Land is not acquired.
Not acquired. That's why I made a submission to your lordship.
Ah.
Unless they file an objection, I can't make any further submission.
Is the land acquired? Why don't you file your objections?
Lord, we'll file it, my lord. There's no difficulty in filing. But thing is, my lord, there are two survey numbers. One is survey number 74 of Bandi Kodigali, and one is, my lord, survey number 158, my lord, which is allotted, my lord, in favor of the fifth respondent herein. Lord, the survey number 158 is no mail, my lord, connected to, my lord, survey number 74. 74, my lord, we acquired.
No, 150?
158.
158.
That is no way, my lord, connected to, my lord, survey number 74. Lord, if survey number 74 stay quarter, we don't have any objection. My lord, 158, my lord, is nothing to do with, my lord, survey number 74. My lord, they.
No, but the respond number 5 has been allotted in 158.
Yes, my lord, we have been executed lease come sale and also allotment. They've started constructions, my lord.
No, 158 is carved out of which survey number?
That is independent, different survey number, my lord. Altogether, that is different.
My lord, the preliminary notification has 74 and 158 separately, my lord. 158 has 10 acres.
He says that 74 itself is a government land which measures some.
That is, Lord, the 74 we're not disputing. That is government entire, my lord. The 74, Lord, we have acquired 41 or 44 acres. Lord, 74, my lord, is larger extent of land. Lord, we have not acquired entire land, my lord. The survey number 158 is, my lord, different. Altogether is different.
Our submission, your lordship, the allotee of 158, claiming that this is also allotted, yeah, they are trying to put up a compound on my land, which is not acquired, your lordship. And
Lord, purely civil dispute as to identity.
Please, why don't you give the final notification sketch code?
Kindly see the, my lord, final notification which is produced, my lord, by, my lord, my learned friend, my lord, in his application
My
for vacating.
application for vacating stay was not put up on the previous occasion. It's there. We've ensured that
Where
it's
is the
put up.
final notification sketch?
Lord, the sketch,
None
my lord,
application, my lord. My
may
application
pass, my lord, the layout plan, my lord.
If my lords were to kindly take my application, all of that is there, my lord. Final notification, preliminary notification, award, the layout plan, all of it is there.
Application. Lord, the plot allotted, my lord, is 150. That is P3 on the left hand side, yellow mark, my lord, yellow color, which is yellow. That, my lord, is total extent is 4.64 acres. At P3 plot, my lord. After formation of industrial area, we have, my lord, this survey number is 158. Out of that, my lord, we have allotted 3 acres of land to, my lord, to the fifth respondent. Lord, that is no way, my lord, connected to, my lord.
My lords may kindly see 74 is on top.
Please tell us, please wait. Where is his property?
Then the top 74 ಮೇಲ್ಗಡೆ ತಾವು ನೋಡಿದ್ರೆ
ನಾನು
74 ಅಂತ ಮೇಲ್ಗಡೆ
your lordship may permit me to survey sketch ಆಗ್ತಾ ಇದ್ದೀನಿ ತಮ್ಮ ಮುಂದೆ.
ಕೊಡಿ ಅದೇನು told. The Land Council for the petition has placed on record a survey sketch. So the same is taken on record. Yes. ನಿಮ್ದು ಯಾವ್ದು ಸರ್ವೆ ನಂಬರ್?
ಅದರಲ್ಲಿ ನಾನು ರೆಡ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಲ್ಲ 22 ಬ್ಲಾಕ್ ನಂಬರ್ 20 22 24 and 4 23 ಇದೆ.
That is 158 ತಾವು ಅಲ್ಲೇ ನೋಡಿದ್ರೆ ಮಧ್ಯದಲ್ಲಿ ಇದೆ. 158 is they are not also claiming, my lord, 158. The block, my lord, what they are saying, 74 is subdivided into blocks.
We don't want an inch of survey number 158.
So 158 ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಅಲ್ಲೇ ಇದೆಲ್ಲ ಸರ್. ಬ್ಲಾಕ್ 22 ಪಕ್ಕ ಇದೆ. ರೆಡ್ ಕಲರ್ ಬ್ಲಾಕ್ 22 ಪಕ್ಕ ಇದೆ, ರೈಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್.
158.
Yes, that is they are not claiming that land. Not at all claim.
Compound ಹಾಕಬೇಕಾದ್ರೆ they claim it is acquired and it is allotted to me ಅಂತ. Your lordship will kindly say probably your lordship appoints a ADLR. Let him survey and put it. I have no problem.
Lord.
Let them identify this 22.
KDB can't have an objection for it.
See, if 22 is not acquired,
First,
Can't obviously allow
Lord,
it.
first of all, Lord, whether Lord, we have to see whether, Lord, this land, Lord, 74 is acquired or not. If acquired, Lord, he has to challenge the acquisition proceedings.
is
He cannot
right.
claim, Lord, the land which is,
What
Lord,
he's
is already
saying
acquired.
what he's saying is it is not acquired.
Lord, he is saying that, Lord, it's not acquired. Our case is that, Lord, it's acquired. Even, Lord, 74 is also acquired for 158.
Objection, Your
That's
Lordship,
why
I will answer it.
we'll file it. But, Lord, in so far as 158 is concerned, Lord, that is nothing to do with, Lord, survey number 74. Is, Lord, whole, Lord, contention is that, Lord, survey number 74, Lord, is only claiming survey number 74, not, Lord, 158. Lord, we have allotted land, Lord, to the fifth respondent, Lord, in survey number
22
1.
is survey number or block number?
Block, Lord, the survey, Lord, what happened, Lord, Lord, as a, Lord, already submitted, survey number 74 consists, Lord, larger extent of land, which is government Gomala land. It's a government Gomala land. Lord, while, Lord, acquiring the land, Lord, giant measurement was conducted, and, Lord, as per giant measurement, Lord, the blackwise, Lord, as per the actual possession of, Lord, the persons who are holding, Lord, the land as on the date of issuance of notifications, Lord, blackwise, Lord, given blocks, that is, Lord, 20, 24, 23, 22.
So you make a statement that survey number, block number 22 is also acquired. Will you
That
make
will make, but, Lord, that is apart. Lord, 158 is nothing to do with this, Lord.
Correct, but our 158 and 22 are lying adjacent to each other.
That is true. That is.
If 22 is not acquired, if the allotee in 158 is trying to encroach into 22, what is wrong in asking him, passing the
Lord,
relief?
even assuming for a moment, Lord, they're claiming, Lord, survey number 74, black, Lord, 22. If it is acquired, how can they claim it, Lord? It's the KDB property. That I'll make my stand clear, Lord, on that, Lord. Whether 22 is acquired or not, Lord, what?
You make a statement, it is acquired. Whether this block 22 is also acquired on the statement on Madi.
Please, Lord, I'll make.
Then we'll consider what should be done.
Please.
May I just make one submission, man, because this intermod is troubling me more than anything else.
What you want?
Manoj, may kindly see, as far as the petitioner is concerned, now he says yes, categorically he says 158. I have nothing to do with 158. 158 was, Manoj, subject matter of an RFA before this honorable court itself, which was settled.
Yes.
Now the issue is this, Manoj. If Manoj, senior would say that yes, I have nothing to do with 158, that may be recorded, because for me, what's happening is, Manoj, the police is now getting involved in this.
Yes.
They come onto my compound and put they write basically WP number so and so is there. This is a stay. Now I'm being troubled because of that. My lords, may kindly just see my application which I filed for vacating stay. Everything is there in that, Manoj. I have produced the final notification, preliminary notification. I've also produced, Manoj, the award copy as well, where, Manoj, the award has been collected by completely different people.
Yes.
Because that itself shows that yes, these two lands are completely different. Now, my lords, may kindly see, because the layout plan itself shows where is 158, but, Manoj, the 74, which is why, Manoj, it may be clarified saying that this intermodal, as far as intermodal is concerned, it's only in 74. The difficulty is this, Manoj. What I pointed out on the previous occasion is in paragraph 11 of the writ petition, they say that see 18 acres is fine in 74. This now, as far as the respondent number 5 is concerned, we are now trying to attempt to identify our land in 74 is what they say.
We'll do one thing. We'll appoint an ADLR.
Please.
Let him identify the limits of this block 22 or 23,
Lord,
24.
Lord, before that, Lord, I have submission, Lord. I'll file my objections before, Lord. Now, Lord, the court, Lord, wants to know whether, Lord, this land is acquired or not. If it is acquired, Lord, question of, Lord, appointment of ADLR does not come, Lord, because, Lord, the land is, Lord, vested with the state government.
The
And
question would be, if it is acquired,
then, my Lord, if it is not acquired, then, my Lord, question comes whether, my Lord, we have the
notificational. If it is acquired, notification your ಹೆಸರು ಬಂದಿದ್ಯಾ?
ಬಂದಿಲ್ಲ.
ಮತ್ತೆ?
Lord, there's no RTC standing. Lord, let him show single document to Lord before this court. Lord, he has, Lord, RTC standing in his name before initiation of acquisition.
Your Lordship, I have produced the RTCs. That apart, Your Lordship, two
let him
two special
let
deputy
him show, my Lord.
commissioners.
RTC ಇದೆಯಾ?
Annexure D1, Your Lord, page.
ಓದಿ ಯಾರ ಹೆಸರು ಇರಬೇಕು?
Page
ನಾರಾಯಣ್ ಗೌಡ
25. Page 25.
ಯಾರ ಹೆಸರಿದೆ?
B.R. ಕೃಷ್ಣಪ್ಪ. ನಮ್ಮ ತಂದೆ ಹೆಸರಲ್ಲಿ.
Your Lordship, kindly see the date of, my Lord, the RTC.
It ends in 2000.
85-86 ಇಂದ 85-86 ಇಂದ 99 2000 ತನಕ ಇದೆ ನನಗೆ.
That is the whole crux of the matter. Lord, acquisition was taken place, Lord, in the year 2006 and, Lord, 8. Lord, RTC, Lord, stopped in the year 2000, in the year 2000. Lord, from 2000, Lord, 2008, Lord, there was no RTC.
ನಿಮ್ದು RTC ಎಲ್ಲಿವರೆಗಿದೆ?
1999 was the last Lord.
ಮತ್ತೆ
ಅದಾದ್ಮೇಲೆ ಅವರು ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಬಿಕಾಸ್ Lord the Lord they were Lord in the survey number 74 though Lord land is Lord 297 acres Lord grant is made for 500 acres. There's no physical Lord land. There's no land.
Right or wrong?
That is
an RTC up to
Lord, we are not
99,
at all
2000.
disputing. Only Lord, our request is Lord to Lord restrict the interim prayer with respect to Lord survey number 74, not Lord survey 158. If it is Lord encroached upon Lord block 22, Lord that is to be Lord independently Lord.
Correct, but then if 22 is not acquired,
acquired,
it is then what should happen? How can anybody disturb his possession?
That is true, Lord. If it is not acquired, we can't, Lord. Now, Lord, we cannot, Lord, disturb him. If it is acquired, Lord, ultimately, Lord, is Lord.
Then we'll say that this is only in respect of block number 22 and survey number 27.
Lord, may I just make one submission?
Whatever
Lord,
interim order that is granted
please.
is only in respect of block number 22 and 24 and not whatever site numbers, block
so
number
that,
150.
just so that my lords has some clarity, my lords, we kindly come to page 47 of my compilation.
Yes.
Now, my lord, as far as RTCs are concerned, yes, they have no entry. That's a different aspect. If my lords were to kindly see serial number 18 for survey
18
number
of what?
74, my lord, this is the final notification, my lord.
Page number?
Page number 47. No mention of any blocks or anything as such, my lord. 41 acres was completely acquired insofar as survey number 74 is concerned. It shows Sarkari Jaga.
There is also Lord individual's name, Lord given Lord
47.
40. If my lords were to kindly see Sarkara.
Adar kelagade
In 41
individual
acres.
adar kelagade
Now, is he
individual
claiming inside this? Is he claiming outside this?
That KDB has to clarify.
Correct, my lord. No, as far as they are
Survey
concerned.
number 44 is 374 acres.
Please, 374
so therefore,
acres.
government should say, because the boundaries given is in respect to the entire 74.
Please, my lord, this is only 41 acres.
No. Look at the boundaries.
ಇಲ್ಲ ರಿಮೈನಿಂಗ್ 74 ಕೂಡ ಇದೆ my lord. It is not for the
ಎಲ್ಲಿಂದ
entire.
ತೋರಿಸಬೇಕಲ್ವಾ ಅವರು ಯಾವ ಕಡೆಯಿಂದ ತೋರಿಸಬೇಕಲ್ಲ 74 ಅಲ್ಲಿ.
Please, no, my lord.
If ಅವ್ರದ್ದು ಇಲ್ಲ ಅಂತ ಅಂದ್ರೆ perhaps I think that they have to clarify.
I understand. So if my lords were to record saying that they have nothing to do with 158, because I'll just show 158
No, I
also.
can't say that by way of an interim order. Let them clarify whether the property claimed by the petitioners is acquired or not.
My lords may kindly come to 55.
Demand
my lord.
counsel for the
My lord,
respondent.
55, just 55, one last page, my lord. Because at least if you have some, my lord, some common ancestry or some, my lord, common predecessors, I understand. This is completely different. 158 is completely different. They have nothing to do with it. It was, my lord, subject matter of an RFA, compromised in an RFA. 55, my lord, serial number 55 itself.
Correct. ಅಕ್ಕಪಕ್ಕ ಇದೆಯಲ್ಲ
ಅಕ್ಕಪಕ್ಕ, my lord, not as per the
158 and 74 are, sorry, 22 are lying adjacent to each other.
Not as per, my lord, because if my lords were to kindly see the sketch again, not as per this, my lord, because my site is here. This is 74. It can never be akkapakka here.
You please have a look at the sketch that he has produced.
Which he has produced, my lord. Please, that note that.
ಅದ್ರಲ್ಲಿ ಏನಂತಿದೆ?
My lord, here
158 and 22 are lying adjacent to each other.
My lord, this I don't even know of which year this is, my lord, because this appears to be something. Honestly speaking, my lord, I am not able to make out head or tail as to how, because if this is the case, if 74 is here, how, my lord, under 158 another 74 comes, I'm not able to understand.
ಕೆಳಗಡೆ ಕಾಯಂ ಗುತ್ತಾ ಹೂವಿನಾಯಕನಹಳ್ಳಿ ಗಡಿ ನಿಮ್ಮ ಸ್ಕೆಚ್ ಬನ್ನಿ.
Please.
ಕಾಯಂ ಹೂವಿನಾಯಕನಹಳ್ಳಿ village boundary.
Please.
Correct.
Please.
Now you look at the property that you are claiming and the property that is found in the sketch.
Please.
Correspond ಆಗುತ್ತೆ ಸ್ವಲ್ಪ.
If my lords were to kindly see, we are here, my lord.
That is right. You compare this with that. ಹೂವಿನಾಯಕನಹಳ್ಳಿ ಗಡಿ ಎಲ್ಲಿದೆ ನೋಡಿ, ನಿಮ್ಮ ಲೇಔಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ನೋಡಿ.
My lord, if it is below this, my lord, because if it is below this, if 158 comes here, 74 ideally should come on top.
Baba, why don't you have a look at 135?
I am, my lord. I'm trying to make out.
135 ಎಲ್ಲಿದೆ ನೋಡಿ. ನಿಮ್ಮ ಲೇಔಟ್ ಪ್ಲಾನ್ 135 ಎಲ್ಲಿದೆ?
ಕೆಳಗಿದೆ ಇಲ್ಲ.
ಇದೆಯಲ್ಲ?
135 is here, my lord.
25. 135 ಮೇಲ್ಗಡೆ 24 ಬರುತ್ತೆ. 22 ಬಂದು ನಿಮ್ಮ 158 ಗೆ ಇದಾಗುತ್ತೆ. ಲ್ಯಾಪ್ಸ್ ಇದು ಓವರ್ಲ್ಯಾಪ್.
I think, my lord, what they're trying to make it look like is this block is supposed to be here, at least from what I'm trying to understand.
134 mele, 135 mele,
Oh,
that strip goes all along the
that is
road
what I'm trying to, I'm presuming that they're saying that the strip comes here.
and it goes through that yellow portion also.
This yellow portion is what they show.
Ah. So therefore, this has to be examined. Yeah, I think. The learned counsel for the petitioner is placed on record a village map, the survey map of survey number 174 and contains that the property allotted to the respondent number 5 in survey number 158 overlaps the property belonging to the petitioner in block number 22 of survey number 74. Full stop. Therefore, it is imminent that an objection is filed by the that a statement of objection is filed by the respondent number
Not
2 and 3, clarifying whether block number 22, 24 in survey number 74 is also acquired. Full stop. Yes, Yavak Marthiri.
10 days, 10, 15 days.
10, 15 days, he is screaming on the top of his voice.
But you have to get instructions.
Yavatant ಹೇಳಿ. Next week.
Next week. Please.
It may be clarified that the intermod is only insofar as the block, my lord, because
Now, after looking at both the maps, there is some, it's very dicey.
my lord, with all due respect, I wouldn't say it's dicey, my lord, because I understand what my lord is trying to point out over here, saying that this strip may be here. But I'm not able to understand, my lord, how 74 comes here on top and
That
how
they have to
they go into this block.
They have to, that is their layout plan.
Oh,
Yes, next.
Interim
Interim
order extended, my lord.
Interim order granted early is extended to the next. Pradeep, ವಾಪಸ್ ಕೊಟ್ಟು.
Serial number 14, 13th August. Serial number 14, Vannikatti Deepak.
Paper petition, Your Lordship. On the last occasion, Your Lordship had directed us to
26 and 2 of 26 is allowed.
deposit the amount before the respondent authority. We have deposited the same along with 20% penalty, and we have
Okay,
placed.
what is the issue?
It's pertaining to
Late
allotment
payment,
of
my lords. Delay payment. Site was allotted, my lords. There was a delay payment, so we have
So
cancelled.
how much was the balance?
My lords, only 25% were paid, my lords. Remaining complete amount were paid by them. My lords had directed me to verify.
ಯಾವ layout?
Flat, my lords, in Chandra layout, my lords. 3 BHK flat.
ಮತ್ತೆ ನೋಡಿ ಕ್ಲೋಸ್ ಮಾಡಕ್ಕಾಗಲ್ವಾ?
Let's secure the instruction. As far as the oral instruction is concerned, my lords, flat has been allotted to someone else immediately after cancellation. I need to secure the records also, my lords, whether it is true or not, my lords, and also I will file my objections.
Who is in possession?
We are in possession of it.
Possession ಇದಾರೆ ಅಂತಲ್ಲ. But how will you get it vacated?
I'll seek instruction with regard to that, my lords.
The learned counsel for the response seeks time. The learned counsel for the petitioner submits that as directed by this court. With an order dated 18/6/2026, the petitioner has paid the entire amount.
Along with
interest.
Along with interest.
At 21% ಎಷ್ಟು?
21%.
At 21% per annum. The learned counsel for the response seeks time to secure instructions. List on?
Next week.
ಕೊಡಿ ಯಾವತ್ತು?
14th August.
ಕವಿತಾ ದಾಮೋದರನ್.
Serial number 15, Kavita Damodaran.
I filed an application. Inadvertently, I had made a mistake in mentioning the respondent number 2 name, my lord. It was supposed to be a task force. I had mentioned something else. Page number 5, my lord. In mentioning the respondent number 2's name, there was a mistake, my lord. I'm asking for the deletion and impleading the proper party. Deputy Superintendent of Police Task Force ಅಂತ ಆಗ್ಬೇಕಾಗಿತ್ತು.
ಬರ್ಕೊಳ್ಳಿ. IA 4 of 26 is filed by the petitioner to implead a proposed respondent in place of respondent number 2. The learned counsel for the respondent number 2 has no, for the respondent number 1 has no objection to implead, to substitute the respondent number 2 by the proposed respondent. In that view of the matter, IA2 of 26 is allowed. Sorry, IA4 of 26 is allowed. And the proposed respondent is ordered to be brought on record in place of respondent number 2.
Under IA number.
Current counsel for the respondent number 1 is directed to accept notice for respondent number 2. Counsel for the petition is directed to amend the cause title.
I have it ready, my lords. I'll file it now.
Do whatever you want.
My lords, in the connected matters, my lords had granted in interim order, my lords. This is a matter where
The
the
order passed on IA4 of 26, IA3 of 26 is unnecessary and the same is rejected.
This is a matter where PDA has issued notice where the BBMP is the property comes under the BBMP. Have taken the building sanction plan and the tax is paid to the BBMP. In spite of that, the BDA has issued the notice. In connected matters, my lords has granted me an interim order, minutes.
The copy was served just now, madam.
Copy of the petition served yesterday.
No, yesterday it was served.
Copy of the writ petition.
No.
Why?
There was a correction. Hence
Why did you not serve it? Why did you not serve the copy of the writ petition?
Hard copies were served now. Yesterday they mailed the soft copy.
There was a correction supposed to be made to respond number 2. Hence I couldn't give it, minutes. This is a similar matter, minutes where
Counsel for the petition submits that this court in similar facts and circumstances had granted an interim order in WP number 22602 of 2026 and therefore prays that an interim order may be granted in this petition also. In view of the aforesaid submission, interim prayer as sought for in this petition is granted. Counsel for the respondent list this petition along with WP number so and so, so and so. ಇವಾಗ ಯಾವ್ದು ಹೇಳಿದ್ನಲ್ಲ ಅದು.
WP 220602 of 2026.
22602 of 2026. Yes.
Grateful, minutes.
Serial number for preliminary matter, serial number 16. Divetej, AB.
My lord, I'm appealing for the petitioner. Kindly pass over the matter, my lord.
What is the matter about?
Matter about land acquisition matter, my lord.
Thank you. I can make out from the cause list it is a land acquisition matter.
My lord.
What are the facts? Mandamus,
My lord, it is a writ of mandamus, my lord. Where
yes,
land acquisition proceedings.
AG is directed to accept notice for response 1 and 2. Emergent notice to respondent number 3.
My lord, there is urgency in this matter. Kindly pass over matter. I will argue on the matter.
What urgency?
My lord, they're trying to alter the nature of this property, my lord. Award has been not passed. Compensation is not given, my lord.
No, what is the relief that is? Mister, you are seeking for a direction to grant compensation. Please read the prayer.
Yes, my lord.
To pass an award pursuant to the preliminary notification, final notification, to determine, pay and disperse the entire compensation together with statutory benefits. When did you buy this property, Mister?
My lord, since 1666, it's in my ancestral name, my lord.
No, this property is an ancestral property belong to you.
Yes, my lord. I am the legal heir of Yellappa, Mr. Yellappa.
It is contended by learned counsel for the petitioners that even after the final notification was passed in the year 1991, no steps are taken to pass an award. But the respondent number 3 is trying to form sites in the property of the petitioner. Stop. In view of the aforesaid submission, comma, the respondent number 3 is restrained from undertaking any developmental activity in the properties described in the schedule to the writ petition. At the same time, petitioners also restrained from putting up any construction in the property in any manner whatsoever or change the nature of the property in any manner whatsoever till the next date of hearing. List on date code.
Grateful, ma'am.
Shankar ST.
17, Shankar ST. Serial number 17, Shankar ST.
Shankar. General Award. Yes, Mr. Dildar Shiralli. Sorry, AJ na yaar HCGP has drafted accept notice for R1. Mr. Dildar Shiralli for respond number 2 and 3. Consent award.
Yes, madam.
Close ಮಾಡ್ಬೋದಾ? Madam, consent award. Yes.
Serial number 18.
Sir, HCGP and Dildar Shiralli are permitted to file memo of appearance within 10 days. Mr. Narayan Bhatt.
Appeal for the petitioner, my lord.
Huh?
My lord, I had sought for an award, my lord, under section 28A. My lord, that was rejected on the ground that earlier award is a consent award. My lord, if your lordship peruses the document, my lord, it cannot be treated as a consent award because, my lord, the landowner was dead as on the date of the preliminary notification. And, my lord, subsequently, my lord, an award came to be passed in the name of consent award on 18/9/2012. Your lordship gets it at page 104. From the signature. In the award, my lord, there is no.
Signature, we will not look into it, whether it's a consent award or not.
My lord.
Where is the award?
Award is at Annexure D, my lord.
This is the award.
Annexure D is the award. It does not contain any date. Then, my lord, your lordship may kindly go to page 94. ಮೇಲೆ ಹೆಡ್ಡಿಂಗು ಭೂಸ್ವಾಧೀನ ಜಮೀನುಗಳ ಒಪ್ಪಂದದ ಪರಿಹಾರ ಮೊತ್ತದ ಗೋಶ್ವಾರೆ. ಅದರಲ್ಲಿ ಡೇಟು 18/9.
Why don't you read the preamble of the award?
My lord, 82, my lord.
Please read.
ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಮತ್ತು ಭೂಸ್ವಾಧೀನಾಧಿಕಾರಿ ಕಂದಾಯ ವಿಭಾಗ ತರೀಕೆರೆಯಾದ ನಾನು ಭೂಸ್ವಾಧೀನ ಕಾಯ್ದೆ 1874 ತಿದ್ದುಪಡಿ ಸೋ ತರೀಕೆರೆ ಕಸಬಾ ಹೋಬಳಿ ಯಲಕೆರೆ ಕತ್ತೂರು ಜೋಡಿ ಗೋವಿಂದಪುರ ಗುಡ್ಡದ ಬಸವಹಳ್ಳಿ ಅತ್ತಿಗನಾಳು ಸೋ ಬೆಟ್ಟತಾವರಕೆರೆ ಗ್ರಾಮಗಳಲ್ಲಿ ಜಮೀನುಗಳನ್ನು ಭದ್ರಾ ಮೇಲ್ದಂಡೆ ಯೋಜನೆ ಪ್ಯಾಕೇಜ್ 2ರ ಅಡಿ 329.32 ಎಕರೆ ಜಮೀನು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳಲು ಕೋರಿದ್ದು ಅದರಂತೆ ಬೂತ್ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಳ್ಳಲಾಗಿದೆ. ತರೀಕೆರೆ ತಾಲೂಕು ಸೋ ಹಳ್ಳಿಗಳಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಸೋ ಭದ್ರಾ ಮೇಲ್ದಂಡೆ ಯೋಜನೆಗೆ ಭೂಸ್ವಾಧೀನಗೊಳ್ಳುವುದು ಅವಶ್ಯವೆಂದು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಚಿಕ್ಕಮಗಳೂರು ಇವರ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋರಲ್ಲಿ ಭೂಸ್ವಾಧೀನ ಕಾಯ್ದೆ 4(1) ಅಧಿಸೂಚನೆ ತಯಾರಿಸುವಂತೆ ನಿರ್ದೇಶನ ನೀಡಿರುತ್ತಾರೆ. ಸದರಿ ನಿರ್ದೇಶನದ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಗೆ 4(1) ಅಧಿಸೂಚನೆ ಪ್ರಸ್ತಾವವನ್ನು ಸಲ್ಲಿಸಿದ್ದು ಜಿಲ್ಲಾಧಿಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ರಂದು ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಲಾಗಿದ್ದು ಸದರಿ ಅಧಿಸೂಚನೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪತ್ರ ಸೋರಲ್ಲಿ ಪ್ರಕಟಿಸಲಾಗಿದೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸರ್ಕಾರದ ಪ್ರಕರಣ ಸೋಂತೆ ರಾಜ್ಯ ಪತ್ರ ಸೋದಲ್ಲಿ 6(1) ನೋಟಿಫಿಕೇಶನ್ ಪ್ರಕಟಿಸಲಾಗಿದೆ. ನಂತರ
page 84.
ಮೇಲ್ಕಂಡ ದರಗಳು ಜಮೀನಿನಲ್ಲಿರುವ ಮರ ಮಾಲ್ಕಿಗಳಿಗೆ ಒಳಗೊಂಡಂತೆ ಫುಲ್ ಸೆಟಲ್ಮೆಂಟ್ ದರಗಳೆಂದು ನಿಗದಿಪಡಿಸಿದ್ದು ಈ ದರಗಳಿಗೆ ಒಪ್ಪಿಕೊಳ್ಳದಿದ್ದವರಿಗೆ ಭೂಸ್ವಾಧೀನ ಕಾಯ್ದೆಯಂತೆ ಪರಿಹಾರವನ್ನು ನಿಗದಿಪಡಿಸುವಂತೆ ನಿರ್ದೇಶಿಸಲಾಗಿದೆ. ಸರ್ಕಾರದ ಪತ್ರ ಸೋ ಪತ್ರದಲ್ಲಿ ಈ ಕೆಳಗಂಡ ಅಂಶಗಳನ್ನು ಗಮನಿಸಿದಲ್ಲಿರಿಸಿ ಸೂಕ್ತ ಪ್ರಸ್ತಾವನೆ ತಯಾರಿಸಲು ನಿರ್ದೇಶಿಸಿರುತ್ತಾರೆ. ಮೇಲ್ಕಂಡ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಹಾಗೂ ಸ್ಥಳೀಯವಾಗಿ ಇನ್ನಿತರ ವಿಚಾರಗಳನ್ನು ನಡೆಸಿ ಜಮೀನು ವರ್ಗೀಕರಣ ನಿರ್ಧರಿಸಿ ಅದನ್ನು ಅವಾರ್ಡ್ ಚರ್ಚಿಸಿ ಬೆಲೆ ನಿಗದಿಪಡಿಸಲು ಕ್ರಮ ವಹಿಸುವಂತೆ ನಿರ್ದೇಶಿಸಲಾಗಿದೆ. ಈ ಬಗ್ಗೆ 25/4/12 ಮತ್ತು 26/4/12 ಹಿರಿಯ ಸಹಾಯಕ ತೋಟಗಾರಿಕಾ ನಿರ್ದೇಶಕರು, ತೋಟಗಾರಿಕಾ ಅಧಿಕಾರಿಗಳು, ಮೆಸ್ಕಾಂ ಅಧಿಕಾರಿಗಳು, ಸೋ ನಿಗಮ ನಿಯಮಿತ ಇಲಾಖೆಯವರು ಮತ್ತು ಮೋಜಣಿದಾರರೊಂದಿಗೆ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿರುತ್ತೇನೆ. ಸ್ಥಳೀಯ ತನಿಖೆ ಮಾಡಿದ ಸಮಯದಲ್ಲಿ ಈ ಕೆಳಗಂಡ ಅಂಶಗಳನ್ನು ಗಮನಿಸಲಾಗಿದೆ. ಸರ್ಕಾರದ ಪತ್ರ ಸೋ 21/3/12 ರಂತೆ ನಿಗದಿಪಡಿಸಿದ ಪ್ಯಾಕೇಜ್ ಮೊತ್ತದ ಒಪ್ಪಿಗೆ ನೀಡುವ ಕುರಿತು ಭೂಸ್ವಾಧೀನಕ್ಕೊಳಪಡುವ ಎಲ್ಲಾ ಭೂಮಾಲೀಕರಿಗೆ ಖಾತೆದಾರರಿಗೆ ನೋಟಿಸ್ ಅನ್ನು ಜಾರಿ ಮಾಡಿ 20/6/12, 22/6/12 ಹಾಗೂ 23/12 ಒಪ್ಪಂದದ ದರ ನಿರ್ಧರಣೆಯ ಕುರಿತು ಸಭೆ ನಡೆಸಲಾಯಿತು. ಸಭೆಯಲ್ಲಿ ದರ ನಿಗದಿಪಡಿಸುವ ಕುರಿತು ಕೂಲಂಕುಷವಾಗಿ ಚರ್ಚಿಸಲಾಯಿತು. ಕೆಲವು ಭೂಮಾಲೀಕರು ಖಾತೆದಾರರು ಒಪ್ಪಂದ ದರಕ್ಕೆ ಒಪ್ಪಿಗೆ ನೀಡಿಲ್ಲವಾದ್ದರಿಂದ ಭೂಸ್ವಾಧೀನ ಕಾಯ್ದೆಯಂತೆ ಸಾಮಾನ್ಯ ಕ್ರೈಮೈಲು ಐತೀರ್ಪನ್ನು ರಚಿಸಲಾಯಿತು. ಉಳಿದಂತೆ ಒಪ್ಪಿಗೆ ಸಮ್ಮತಿಸಿರುವ ಎಲ್ಲಾ ಭೂಮಾಲೀಕರು ಖಾತೆದಾರರ ಒಪ್ಪಂದ ದರದಂತೆ ಪರಿಹಾರ ಪಡೆಯಲು ಒಪ್ಪಿಕೊಂಡಿರುವುದಾಗಿ ಲಿಖಿತವಾಗಿ ಸ್ವಾಧೀನ ಪಡೆದುಕೊಳ್ಳುವ ಜಮೀನಿಗೆ ಒಪ್ಪಂದದ ತೀರ್ಪು ಕರಾರು ಪತ್ರ ಫಾರಂ ಡಿ ನಮೂನೆ 10B ಯಲ್ಲಿ ಸಹಿ ಮಾಡಿ ಅಭಿಪ್ರಾಯ ನೀಡಿರುತ್ತಾರೆ. ಅದರಂತೆ ಒಪ್ಪಂದ ದರದ ತೀರ್ಪು ನಿಗದಿಪಡಿಸಲಾಗಿದೆ. ಇದರ ಸಿಗ್ನೇಚರ್ ಸ್ವಾಮಿ, ಇಟ್ ಈಸ್ ಡೇಟೆಡ್ 18/9/2012. My lord, the landowner was dead much before 4/1 notification. Now your lordship may kindly see the stamp paper and form number D and.
That will not, why should we go look into all those things?
My lord, it is after 1 year.
So what?
My lord, if it is a consent award, before passing the award, my lord, there must be a consent.
No, the award only says it is consent. The award itself says it is consent.
My lord, award is prior and consent is later.
So what?
My lord,
so what?
My lord, consent should, first there should be a consent, then there should be an award, my lord.
Is it your case that this is a general award?
My lord,
this cannot be a general award.
My lord, according to me, I did not give consent. My lord, they have obtained signatures. This is a fraud, my lord, played on the landowner is my case.
Yes.
My lord, if your lordship is pleased to consider this, my lord, your lordship may consider it. Otherwise, my lord, your lordship may relegate me, my lord, under 28(3). My lord, I may seek a reference, my lord, to the court.
I will not grant you liberty. Notice of the award was issued to you.
Illa. He was dead. Landowner was dead. Award came to be passed.
Yes.
Award came to be passed by including my name as consent award in 2012.
Yes.
My lord, consent is 2013, after 1 year.
Yes.
That is my case, my lord. It is fraud has been played, my lord.
You received the money.
My lord, it is a pittance, my lord. It is a pittance.
What to do?
My lord, 1,000 rupees per tree. My lord, this honorable court has held 7,000, my lord, as on the date of that award.
Yes. What to do?
My lord, then I may be. My lord, if it is a fraud, my lord,
yes,
it is vitiates everything, my lord.
Yes. There is nothing.
Then I will withdraw, my lord.
Do whatever you want.
For appropriate remedy.
The petitioner has filed a memo to withdraw the writ. After arguing for some time, the learned counsel for the petitioner seeks liberty to withdraw this petition to pursue any other alternative remedy. In view of the memo, the petition is dismissed as withdrawn. Bimbadara.
19. Bimbadara.
I appear for the petitioner in this matter, my lords. My lords, it's a writ of certiorari, my lords, seeking quashing of the notification, my lords, seeking to acquire the land, my lord, for the purpose of widening of Sagara Haveri highway. Sagara Haveri road, my lords, which is now regarded as a highway. My lord, the basic ground on which, my lord, the petitioners are challenging the acquisition is this, my lord, the final notification, that is the declaration under section 19, my lords, has already been time barred, my lord, since it exceeds the period of 1 year from the date of preliminary notification. Lords, in the connected set of writ petitions, my lord, this honorable court has.
He has directed accept notice for response 1, 2, and 3. 1, 2, 3, 4. Till the next date of hearing, the file notification bearing number so and so, dated so and so, bracket annexure Z, and all further proceedings pursuant thereto are stayed, insofar as the land of the petitioner is concerned.
Public. Deeply.
20th August. Serial number 20. Narendra.
For National Highway, my lord. My lord, this is with respect to deduction of GST from the compensation, my lord. My lord, only one submission is, my lord. Let there be order without imposing cost, my lord. Without imposing cost.
No, cost will be imposed. How much was the amount of GST deducted in that case?
ಅದರಲ್ಲೂ 26 lakhs ಇತ್ತು, ಇದರಲ್ಲೂ 20
Madam, GST.
Either
Ayat
26 lakhs. Connected
50,000 is a pittance for you people.
That too, my lord,
Is the
ordered to recover from the
Salary in the name. There should be a black mark in your salary slip. There should be a black mark. Yes, next.
It's also similar matter. my
Next
lord.
is also
Huh?
similar. Number
Next
21.
matter also similar matter.
Similar.
21 also same. ಇದು ನೋಟಿಸ್ ಆಗಿಲ್ಲಲ್ಲ
ಆಗಿಲ್ಲ.
21 ಅಲ್ಲಿ ಕೊಡಿ. HCGP is directed to accept notice for respondent number 1. Mr. N. Kumar is directed to accept notice for response 2, 3 and 4. Same order.
My lord, in both the matters, permit me to file wakalat, my lord.
Mr. N. Kumar, HCGP and N. Kumar are permitted to file memo of appearance within 10 days.
Wakalat, my lord, in my case.
Memo of appearance ಹಾಕಿ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತಿದೀವಲ್ಲ. Yes. Memo of appearance ಆಗ್ತಿರೋ ವಕಾಲತ್ ಆಗ್ತಿರೋ everything is left to you.
22.
Anirudh.
No, sir. Petitioner, my lords. My lord, this is the matter of the KDB acquisition of Nice Road, my lord, Sompara village, my lord. Recently, on 29 July, my lord, the division bench of this court in the writ appeals, my lord, there were hundreds of writ petitions filed, which was all allowed insofar as petitioners are concerned. All the batch matters were challenged by the writ appeal and it has been...
Lord, respondent number 4 with Nice authority
ಯಾರು?
notice has to go for them. Nice authority.
ಯಾರು ಇದಕ್ಕೆ HCGP ನೋ AGS
Special
Mr.
counsel.
Pradeep Kumar is directed to accept notice for R1.
2 and 3 T Somsekhar.
PB Patila.
T Somsekhar.
Huh?
T Somsekhar.
T Somsekhar for 2 and 3. Mr. Nitin Prasad.
Nitin Prasad.
For respondent number 4. ಯಾವತ್ತಿರ್ಲಿ?
Next
No, one request, if I may, my lord. Now, my lord, the writ appeal, my lord, was disposed of on the grounds that there is a delay of 23 years, my lord, but because that the award was not passed.
Yes.
My lord, our only apprehension is now during the pendency of this matter, my lord, if at all an award has passed, again it will cause a fresh cause of action and again decades of litigation. But it's been litigating for 30 years now.
So
my
even
lord.
if it is passed after 23 years, nobody will accept it.
Again, yes.
So therefore, you please serve a copy.
Yes, I'll serve the copy right now, my lord. I have the extra sets.
Do it.
I'll serve it right now, my
Do
lord.
it.
Yes.
Next.
My lord, if I can also request for a date in the matter, my lords.
The date is given, you wait for the court officer to announce.
Yes, my lord.
14th August.
14th August. Obliged. my lord.
Varun RR.
Arun Ara.
Lords, I am challenging the general award, my lords. Lords, the acquisition is of the year 2000.
You are challenging the general award.
Please, my lords, annexure G, my lords, in page 39. My lords, the acquisition is of the year 2010 for the purpose of Shivamogga Airport. My lords, after 2010 till date, determination of price was not made.
HL Pradeep Kumar for response 1, 2 and 3. Is
covered.
directed to accept notice for response 1, 2 and 3.
Award is passed, but now there is a delay in passing award. There is a delay in passing award.
So he wants a consent award.
I'll just, Lord,
Not consent
file
award.
my objections, Lord.
Huh?
I'll file my objections.
ಯಾವತ್ತಿರ್ಲಿ?
Natina. After 10
next
days.
is also same.
Next is also same, my lords. Acquisition is of the year 2007. Same parties.
HL Pradeep Kumar is directed to accept notice for respondents. List on when?
17.
17, yes.
Grateful.
25, I'll take it up later. Murugesh.
24 also.
24 same.
24 same. Kindly both may be connected, my lords.
Serial number, preliminary in B group matter, serial number 26. Vinayak B.
Appear for the petition.
Vinayak B.
In this matter, my lord, your lordships have directed to furnish the details of, my lord, site numbers in survey number, my lord, 37D 42.
Directed to place on record the details of the sites formed in survey number 37 bar D, 44 bar 2, 44 bar 3 of Kuppalur village. Who has to furnish the detail?
Muda.
Yes, Mr. H.C. Shivram. H.C. Shivram, password.
Serial number 27. Joseph Anthony.
Joseph Anthony.
Serial number 27. Joseph Anthony.
Dildar Shigalli.
This matter is regarding my lords, township, my lords, where they have
sorted for allotment of civic amenities site in favor of the landowners
yes.
association, my lords. My lords had directed me to secure instructions with
Yeah,
regarding to for what purpose that the CHI site is going to be allotted. As per our notification also, my lords, we have stated it is going to be allotted for the purpose of hospital or to the school, my lords. So we are sticking on to that only, my lords. We are not going to allot it for any other purpose. Lords, if they say, if they given a representation to say that, my lords, out of these two, my lords, which they need, my lords, we'll go further with that only, my lords.
My lords, the senior counsel is currently in another court hall right now. He's on his legs.
Did you hear what he said?
Yes, my lords. I'll submit that to the senior. And
What did he say?
Get some inputs from him.
What did he say?
My lord, he said that he would be allotting it only for hospitals or for the purpose of a school. Yes, my lords.
Barkol. The learned counsel for the respondent number 2 submits that the respondent number 2 has proposed to reserve the CS site in question for the purposes of a hospital or for a school. Full stop. He submits that the petitioner may choose between the two, and the respondent number 2 would take steps to reserve the same for the said purpose. The learned counsel for the petitioner seeks time to secure instructions. List on next Thursday.
13th August.
Previous man to Lordship. Lordship directed me to find out whether the sites have been formed in the land in question, Your Lordship. I have written letter, as commissioner has been transferred. By 12th, I will get the information. 12th may not may have. Will furnish the
Number
26.
26, the learned counsel for the respondent number 2 and 3 seeks time to comply the order dated so and so. List on
12th, my lord. By that time, I will try.
12th, yes.
Grateful. I'm sorry I was late.
Rohan Kotari.
28, Your Lordship, I appear for the petitioner in 8 of the matters. This is with regard to provision of concessions for persons with disability. There's been a development, Your Lordship, where the Karnataka Urban Development Authority rules have been amended pursuant to an order of this court. May I hand over the notification? It's on the identical point.
So
of
nothing will survive.
Giving concession.
Nothing will survive now.
The rules here will be the BDA rules, Your Lordship. They might have to respond to this because.
Yes. Huh? 28.567.
And 17.
And
17.
ah.
Are different. Our grievance is only that we have been allotted sites. We are required to make the time specified by rule 13. When we see the site are not at all being followed.
In which layout is the site?
Hello, Nadaprabhu
Hello, this is Kempegowda layout.
Madam,
Sorry.
I hope by now it must have reached you that you have to respect people.
Apologies. Just wanted
And
to.
in this court, we are very, very particular.
No, I will.
Nobody can call you by names. I can't call you like Joyananthakar. I can't call you.
No, I was just trying to respond to the question.
He is Nadaprabhu Kempegowda. So he's not Kempegowda. Please refer to him like that because the layout
I wanted to
is
say
named as
Kempegowda
Nadaprabhu.
layout. I apologize.
Every day this has become a routine for me to tell people to respect our ancestors. He is the founder of Bangalore. Don't forget
There
that.
was no disrespect.
No disrespect,
hint
Andhra.
or
What do you mean?
anything.
You call him by name, sir.
No, I was only trying to. I'm
Please
mistake
change.
on my part.
Please change your attitude.
Mistake on my part.
Yes. Please accept that and correct
100%.
yourself.
100%.
Our matters we have not challenged it.
So some sites have been allotted to you, and the sites are not to be cannot be identified.
Courts are not found, no one understanding. We gave a recommendation to inspect this part. Not to charges, penal interest, still the sites are found. But to grant us time till sites are
Yes.
found. We gave
Yes, madam. What is your case?
My lords, one thing I want to make a submission in addition to what my learned friend said. The petitions where I appear in are people with disabilities, and the prayer that we sought is that as per the Disabilities Act, concessional rates
Yes.
and reservation was not given. Now, my lords, there is a new, in another matter, following directions, there is a new notification issued by the Karnataka government, wherein 25% concessional rate is now been announced in all layouts.
Yes.
So therefore, the statement of objections already filed by both BDA and government, now in light of this new one, the concessional rate to those who, I represent petitioners who are persons with disabilities who've already been allotted, but they have not been given the concessional rate, which is a statutory requirement.
Yes.
So now
Yeah.
with this 25%, they will have to implement this.
I appear in 28, 6 and 7.
Now there is some rules which provide for allotment of sites to physically handicapped.
ಅಲ್ಲ ಅದರಲ್ಲಿ ನಾನಿಲ್ಲ
ಯಾರು whoever is
I
there.
appear in that matter, in physical disadvantage. There is now circular from the BDA also, my lords, to with that aspects, my lords. We'll seek instructions, my lords.
Now what they are now seeking is that they need some concession rate.
Please. I understand.
Allotment is one, concession also they want.
Yes.
So if BDA can consider that, I think we can put a quietus to this writ petition.
That's my habit on the next week, my lords, because, my lords, there are some allotments which is already been made in the concessional rates. Whether the petitioners has availed that benefits or not, my lords, I'll seek instruction, because this match matter, my lords, it also contains other aspects regarding challenging the rules of section 9, 13 and 14.
Anyway, that has become academic now. It has become academic because of the whatever circular or rules that you have framed now.
That is being followed in the BDM also, my lords. We'll see.
We yavat martiri.
Next week, my lords. I'll seek
And who appears in your cases?
I appear, my lords.
ಅಲ್ಲ
ಅದೇನೋ
Yes.
ಅಲ್ಲ ನಾನು I appear in 2 matters of Mr. C.V. Kumar.
Why don't you identify whether the lands, sites that are allotted to them could be identified?
ಅಲ್ಲ
Whether
ಅದು
civic communities-
2017 ಅಲ್ಲಿ ಮಿಲಟ್ಸ್ because of the litigations ಮಿಲಟ್ಸ್ in Nadaprabhu Kempegowda layout, we could not improve much. Now after ಮಿಲಟ್ಸ್ division bench judgment of 2024, ಮಿಲಟ್ಸ್ we are developing the sites. ಅವ್ರದ್ದು ಇನ್ನೊಂದು ಏನಂತಂದ್ರೆ
Put a timeline within which you can develop the sites.
ಅಲ್ಲ ಅವ್ರದ್ದು ಇನ್ನೊಂದಿದೆ, they want ಈಗ ಅಲ್ಲ ಅವ್ರದ್ದು ಏನಂದ್ರೆ 2030 ಒಂದು ರೇಟು, 30-40 ಒಂದು ರೇಟು, 40-60 ಒಂದು ರೇಟು, 50-80 ಒಂದು ರೇಟು ಅಂತ ಹೇಳಿ ಹಾಕಿದಿರಿ. ಕೀಪ್ ಎ ಯೂನಿಫಾರ್ಮ್ ರೇಟ್ ಅಂತ ಹೇಳಿ ಅವ್ರದ್ದು ಇದು.
Yes.
Two aspects are challenged in this batch matter, my lords. One aspect is regarding the physical disabilities. Another aspect is regarding, my lords, allotment of rules, section rules 9 and 13, my lords. Allotment of BDA rules, my lords. That is being challenged. So it maybe have to be separated, my lords, then my lords may pass an order.
Yes.
Two aspects are very different.
On the disability related issue, I can pass
No,
over
correct,
the latest
but
circular.
if any of the grievance of any of the petitioners is redressed by these latest rules,
Yes.
and the petitions could be closed,
Yes.
taking note of these rules.
In fact,
Huh.
please the petitioners, I will give those
Please
numbers.
give the list where we
Yes.
can close the petition based on these rules.
Yes, in fact, I'll give that list. The petitions which relate to persons with disabilities, where now this new circular government order has come. I will give a copy of this to my friend. Those on the next date, if they admit that this is there, we want this concession. That's all we are seeking. Those at least could be
Counsel
addressed
for
by
the
this.
respondent seeks time to secure instructions whether the
New
some
circular
of the petitioners could be extended concessional rates of allotment
for persons with disabilities.
with the persons with disabilities. Yes, list on yavat?
Next week, my lords.
Next week.
Next
can it be,
Thursday.
Please,
instead of
Thursday.
next, Monday, 19th.
Next Thursday or Friday?
Regarding the same issue, my
Can it
lords,
be
there is
on,
a PIL which is pending before the.
So anyway, now that you have amended the rules or you have supplemented the rules, many petitions can be closed. So we'll list those petitions and close. Estagatho close manana. And wherever there is an issue, we'll consider that.
Yes.
Yes, when do you want it?
Can it be 18th or 19th, my lords?
That will be too far, madam. 13th or 14th.
I'll appear online. I'll take.
Yes, that's
I'll
fine.
appear online, since I may not be in station.
Yes.
My matter.
13th or 14th.
My matters. My letter friend says.
13th it can be then, at least, my lords. 13th.
Letter friend for BDA submitted that in after 2014, they have taken steps to develop the sites.
So we'll record the statement that with another 2 years they'll develop.
And they can recompute our
Please,
close ಮಾಡ್ಬೋದಾ?
please, my lords. A date may be certain years may be fixed.
ಕೊಡಿ the files ಕೊಡಿ.
Then it
Serial
could-
number.
28.5.
Madam, you can go.
Yes,
We'll
yes,
take up
great.
his matters.
Great, great.
28.5 ಕೊಡಿ.
Mine is 6 and 7, my lords.
28.5, 6 and 7.
Yes, my lords.
Naveen Chandra,
11 and 17.
5 and 6 also?
Please, ma'am.
28 points.
7,
My
11
lord,
and 17.
28.15, my lord.
Already 28.5. Naveen Chandra,
I'm appearing, your lordship, in 28, 28.1.
Madam, 28.5.
We are not appearing, your lordship.
Please sit down. Who appears? 28.5 will need will ba.
ಇವರಿಲ್ಲ ನಾನಿದ್ದೀನಿ.
Sachin BS in government education.
Allah sir, Naveen Chandra, CV Kumar.
NOC ಹಾಕಿ.
Lordship, NOC had been given in.
Yes. You please sit down. That is not your matter.
We were previously in this matter.
I don't know, you're not on record. Take your seat. ಇದರಲ್ಲಿ ಏನೋ ಕೇಳ್ತಿ ಯೂನಿಫಾರ್ಮ್ ರೇಟ್ ಅಂತ ಕೇಳ್ತಿದ್ರಲ್ಲ.
That is not.
You're giving up that prayer?
Till such time, they form the layout, not to
Let's,
insist upon payment and penalty.
insisting
ದುಡ್ಡು
upon
ಕೊಡದಿರ ಲೇಔಟ್ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ? If you don't pay, how will they form the layout?
Section 31 says.
Now already 9 years they
unless
have taken time.
It is ready for, in all respects, they should not.
Which 31?
Section 31.
ಕೊಡಿ.
Okay, BDA. Authority not to sell or to dispose of sites in certain cases. The authority shall not sell or otherwise dispose of any sites for the purpose of construction building thereof for the accommodation of persons until
Let's,
government specified.
My lords, this is with regard to, my lords, because of change in circumstances. For formation of roads and others, my lords, we require funds. It is not a profitable organization. And already 9 years have.
You can't do it. Law says unless you section 13 ಅಲ್ಲಿ ಮಾಡೋವರೆಗೂ ನೀವು ಸೇಲ್ ಮಾಡಂಗಿಲ್ಲ ಅಂತಿದೆ.
Let's.
Now, was this allotment based on the intervention of the court or?
No, my lords. Independently, they have applied and allotment have been done.
Considering our seniority, we are all
ಹೆಂಗೆ ಮಾಡಕ್ ಬರುತ್ತೆ?
middle class people, we borrow funds and.
So at that point of time, we were doing it, my lords.
Correct. ನೀವು doing it ಅಂದ್ರೆ you're not doing in accordance with law. ಕಾನೂನು ಬಿಟ್ಟು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ, ಇದು next week ತಾವು ಹಾಕಿದ್ರೆ ನಾನು I'll take necessary instructions.
So all this batch matter may be taken in the next week, my lords. We will segregate it, my lords, because everything is combined, my lord. Different prayers are there in different petitions, my lords.
ಈ ಮೆಮೊ ಕೂಡ ಕೊಟ್ಬಿಡಿ. If you're not pressing relief number A, please give a memo. ಬರ್ಕೊಳ್ಳಿ. A memo is filed by the learned counsel for the petitioner giving up relief number A sought for in this. ಇನ್ನ ಎಲ್ಲದರಲ್ಲೂ ಕೇಳಿದ್ದೀರಾ?
Only in these three.
6 and 7 they have asked.
6 and 7.
28.5, 28.6, 28.7. What about 11 and 17?
ಅದ್ರೊಳಗಿಲ್ಲ. We have challenged the very rule.
11, 17.
On the
In view of
basis
the memo, relief number, in view of the memo, the writ petition is restricted to relief number B. Counsel for the petitioner is directed to make appropriate entries in the prayer portion of the writ petition stating that the relief A is given up. In ಮಿಕ್ಕಿದಲ್ಲಿ list on date code 13th. List on 13th.
Lordship, there's an interim order, it may continue.
Interim order is extended till the next date.
Please.
ಯಾವ್ದು ಡೀಲಿಂಗ್ ಕೂಡ? Yes. ಅದರಲ್ಲಿ ಇಲ್ಲಮ್ಮ. 5, 6 and 7 ಅಷ್ಟೇ. 29.
Serial number 29.
Petition is.
This matter objections are ready, sent
So
it for the
Vasant Kumar.
authority.
Matter has been partly heard, my
My
lordship.
lord. In this matter, objections are ready, my lord, sent it for the authorized signature, my lord. Kindly have done tomorrow or Monday, my lord.
Learned counsel for the respondent seeks time to file statement of objections. Office director to delete the name of Mr. G. Lakshmi Rao as the counsel for respondent and continue the name of Mr. Murugesh V. Charati. List on date.
14th.
Sinchana MR,
14th August.
Unni Krishnan,
Serial number 30, Sinchana MR.
Lords, my apology. On last date of hearing, I did not appear before this court. Lords, by an order dated 9/7/2026 of your lordship, there was a direction to the BDA, my lords, to seek the alternative
whether
site.
learned counsel for the respondent is directed to secure instructions where the petition can be allotted an alternate site in
Now, my
Arkavathy.
lords, further, now to my client, they have sent a notice today to appear before them on 13/8/2026 before Justice Keshav Narayan Committee, my lords. Produce this.
For what?
To see whether the alternative site is available, because this
Hello,
is
have you filed any petition or something
no,
like that?
no, my lord. I
Then
have
why
given
are
a
you sending?
representation to the BDA.
No, why are
on
you
that
sending?
They have,
No, why are you sending him to this
They have made a representation.
committee?
representation to BDA. I have done it. not
They have
for,
made a representation in for the clarification of this.
Correct, sir. Was it the terms of reference to Justice K. N. Keshav Narayan committee?
No minutes.
Then why are you sending him unnecessarily?
They can
ಅದು
appear
ಯಾವ್ದೊಂದು
before-
ಇದಿತ್ತಲ್ಲ ಟಿ ಶೇಷ್ ಇದು ಆಯ್ತದು ಇವ್ರಿತ್ತಲ್ರಿ ಯಾವ್ದದು there's one batch of petitions where you ಇದು ಲಕ್ಷ್ಮೀಶ್ ಅವ್ರೆ ಅದು ಯಾವ್ದು ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದ್ರೆ ಅರ್ಕಾವತಿ ಯಾವ್ದದು some allotment of alternate sites in ಅರ್ಕಾವತಿ layout
ಕಮಿಟಿ ಫಾರಂ ಮಾಡಿ ಲಿಸ್ಟ್ ಮಾಡಿ
ಅಲ್ಲ ಒಂದು ಆಕ್ಷನ್ ಮಾಡಿದ್ರಲ್ಲ ಇಂಟರ್ಮೀಡಿಯೇಟ್ ಸೈಟ್ಸ್ ಅದು ಯಾವ್ದು ಅದು ಸ್ಟೇ ಆಗಿತ್ತಲ್ಲ
ಹೌದು ನಾಗರಾಜ ಕೇಸಲ್ಲಿ
ಶೇಷಗಿರಿ ರಾವ್ ಕೇಸಲ್ಲ ಸೀತಾರಾಮ್ ಆ ಕೇಸಲ್ಲಿ ವಿಲ್ ಕ್ಲಬ್ ಇಟ್ ಅಲಾಂಗ್ ವಿತ್ ದಟ್ ಯಾವತ್ತು ಕೊಟ್ಟಿದೀವಿ you are allotted a site in Arkavati layout.
Arkavati layout.
Then I think we'll club it along with that. That number idya? Could it, what is that notice?
To appear before the Keshav, Justice Keshav Narayan.
ಇವತ್ತು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
My vendors.
Who is this Bharat Kumar?
ಅದು earlier writ petition and file ಮಾಡಿದ್ದವರು. He is the landlord. Now I have taken, my vendors was allotted the BDA site wherein I have the second purchase land. This is.
So this is a farmer's quota only you have purchased.
We have, my vendor has purchased. Through my vendor I have purchased the sale deed. That is the reason I have given that representation.
So this is allotted to the farmers.
No, my lord, they are not the farmers.
ಅಲ್ಲ ಮೇಡಮ್ ಭರತ್ ಕುಮಾರ್ ಯಾರು?
ಅಲ್ಲ ಅವರು ಒರಿಜಿನಲ್ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್. ಅವರು he had consented acquisition.
So he had got some land.
He had given one site to her, his vendor, petitioner's vendor.
Then how can you?
ಆಮೇಲೆ ಅದು ಅರ್ಧ ಏನು ಹೋಗಿದೆ. My lord, confusion ಆಯ್ತು. In fact, I have sought for details. Today morning I received a call saying that 1 week ಕೊಟ್ರೆ I will furnish the list of sites which are available.
Correct, but ಇದು ಇನ್ಸೆಂಟಿವ್ ಸೈಟ್ ಅಲಾಟ್ ಮಾಡಿದ್ಮೇಲೆ how can you cancel it?
ಆಗಿದೆ. Unfortunately, my lord, I want to settle this issue. ಅದಕ್ಕೆ I have asked them to give the list of sites. Next week, my lord, I will furnish all the sites. And the only way, my lord, justice can get is through the court.
They are purchased.
ಹೌದು, and even mortgaged also. ಅದು ಆಗಿದೆ. I am with the petition. I feel sorry, my lord.
And I went to see the land planning. I came to know that there is only the half site. Not even half.
My friend told me that they might be agreeable if any other site is allotted.
Any other site in the same layout?
1 week, same layout. ಅದೇ 1 week ಕೊಡಿ.
Learn counsel for the respondent seeks time to secure instructions whether the petitioner can be accommodated in Arkavati layout itself. List on ಯಾವತ್ತು?
Next week. ಇವತ್ತೇ ಈವ್ನಿಂಗ್ ಬರ್ತದೆ, but next week any time.
Take whatever the next week, 14th August.
13th
August.
Number 31, Keshav Bhatt.
Mr. Keshav Bhatt. ಎಲ್ಲೋ ಸೌಂಡ್ ಎಲ್ಲ ಬರ್ತಾ ಇದೆ ಬಟ್ ಪಾರ್ಟಿ ಬರ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ
Sorry, I was searching for the file. My lord, this is the BDA matter, my lord, which I had submitted, my lord. Your lordship may kindly appoint a commissioner, my lord. That is my request.
At your cost.
Pardon, at my cost, at petitioner's cost.
ಯಾರು ಕಾಣ್ತಾ ಇಲ್ಲ.
My lord, in fact, there are.
She was appointed once. No? What's your name, madam? Tejaswini.
Very well.
ಎಷ್ಟು
Pardon.
How much?
I leave it to your lordship.
ನೀವ್ ಹೇಳ್ಬೇಕು. How many are there?
My lord, there are two premises are
Three
there.
shops are there.
Two complexes are there. One is at, my lord, Kengeri near metro station, I am told. Another is another RR Nagar.
ಸೊ ಕೆಂಗೇರಿ ಹತ್ತತ್ರನೇ ಇದೆ. ಎಷ್ಟು ಹೇಳಿ?
ಹತ್ರನೇ ಇದೆ ಎರಡು.
ಎಷ್ಟು ಹೇಳಿ?
10,000.
ಒಬ್ರಿಗ?
ಅಲ್ಲಪ್ಪ, ಒಟ್ಟಿಗೆ ಒಂದೇ ಕಾಂಪ್ಲೆಕ್ಸ್.
ಒಟ್ಟಿಗೆಲ್ಲ ನಾ ಮಾಡೋದೇ ಇಲ್ಲ.
ಅಲ್ಲ ಆಯ್ತು, I leave it to your lordship.
10,000 per person.
Pardon, my lord?
10,000 per person. If you are willing, I can appoint.
ಆಯ್ತು, ನಾನು ಅದಕ್ಕೆ.
ನೀವ್ ಹೇಳಿ. If you say yes, I'll appoint.
Very well.
Barcode. The learned counsel for the respondent has placed on record certain photographs which give an indication that the complex is fully developed by the respondents. This is however denied by the petitioner, who contends that the complex is not at all developed and is in very bad shape. Full stop. In support of his contention, he has relied on some photographs. Full stop. In order to resolve this issue, Miss Tejaswini BM was present in the court, was requested to visit the complex at the complex developed by BDA at Kengeri Metro.
Kengeri near metro station.
First writ petition, my lords. Halage Vaderhalli.
At Halage Vaderhalli and
Valgerhalli complex. Valgerhalli.
Vaderhalli ಅಂದ್ರಲ್ಲ.
ಇಲ್ಲ, ಹಲಗೆ ವಡೇರಹಳ್ಳಿ ಬೇರೆ, ಹಲಗೆ ವಲ್ಗೇರಹಳ್ಳಿ ಬೇರೆ.
ಎರಡು ಬೇರೆ ಬೇರೆ.
ಎರಡು ಬೇರೆ ಬೇರೆ.
ಎರಡು ಹೋಗ್ಬೇಕಲ್ವಾ? At ಹಲಗೆ ವಡೇರಹಳ್ಳಿ and Valgerhalli. Valgerhalli.
Last three petitions pertaining to Valgerhalli. First writ petition pertaining to Halage Vaderhalli.
Full stop. She accepted the request and agreed to be appointed as a court commissioner. Accordingly, she is appointed as a court commissioner to inspect the commercial complexes developed by the Bangalore Development Authority at Halage Vaderhalli and Valgerhalli, and submit a report whether the commercial complex is complete in all respects, and in particular the shops allotted to the petitioners, and in particular whether the shops allotted to the petitioners could be made use of for commercial activity.
Yes.
Full stop.
Petitioners may be permitted to file memo of instruction.
No memo of instructions.
She shall point out, my lord.
She shall take pictures of the development of any deficiencies found and submit along with her report. Full stop. Office is directed to issue a commissioner warrant authorizing her to execute the above work. The commissioner's fee is fixed at a sum of rupees
10,000 each.
Sum of rupees 10,000 each, payable by 10,000 payable by each of the petitioners at the spot. Full stop. The commissioner shall visit the spot on yavattu.
When you will visit?
When can you go?
She is ready, my lord. She is ready. My lord, your lordship may.
Saturday is 8th. 8th.
Second Saturday.
Second Saturday commercial complex ತಾನೆ.
ನಮ್ಮ ಇಂಜಿನಿಯರ್ಸ್ ಅವರು ಎಲ್ಲ ಪ್ರೆಸೆಂಟ್ ಇರ್ಬೇಕು. ಇನ್ನೊಂದು ಡೇಟ್.
ಆಯ್ತು, ಯಾವತ್ತು ಹೋಗ್ತಾರೆ ಹೇಳಿ?
ಯಾವ ಡೇಟ್ ಹೇಳಿ ಮೇಡಮ್?
ಅಲ್ಲ, 8 ಅವರು ರಜಾ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಆಯ್ತು, 8th ರಜಾ, 15th ರಜಾ ಇದೆ ಅವ್ರಿಗೆ.
Then 10th, my lord. Monday evening 3 o'clock.
You can go.
Monday evening, 3 o'clock.
Commission shall visit the commercial complexes on 10th at 5 o'clock. At 3:30 PM, full stop. It is open for the petitioners as well as the officers of the Bangalore Development Authority to be present. Full stop. The Land Council for the petitioner shall make appropriate arrangements for the travel of the commissioner. List on yavat? List on 14th. Please furnish your report by 12th or 13th. 14th.
And shop number may be noted down. Shop number 4, 16 and 17.
ತೋರಿಸ್ತಾರಲ್ಲ ಅಲ್ಲಿ.
ಅಲ್ಲೋದ್ನೇ
Shop belonging to the, more particularly in respect to the shop belonging the petitioners bearing number
4, 16, 17.
First ಯಾವುದು shop number?
ಹಲ್ಗೆ ವಡರಹಳ್ಳಿ.
ಎಲ್ಲಪ್ಪ
First petition.
ಹಲ್ಗೆ ವಡರಹಳ್ಳಿ.
ಯಾವ shop number?
Shop number 4, 16 and 17.
416.
4, 16.
There are 3 persons, is
Please,
it?
3 shops, my lords.
4, 16 and 17 in Halike Vaderalli complex. ಆಮೇಲೆ ಇನ್ನೊಂದ್ರಲ್ಲಿ?
ಇನ್ನೊಂದ್ರಲ್ಲಿ 1, 2 and 3.
1, 2 and 3
First floor.
At Valagerahalli complex.
First floor.
1, 2 and 3 in first floor at Valagerahalli complex.
The commissioner may also be directed to note, my lord, how many premises are occupied in the.
ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ ನೋಡಿ, ಒಂದು ಕೇಸಲ್ಲಿ ನೀವು 3 ಜನ ಇದ್ದೀರಾ.
ಹೌದು.
ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಒಬ್ರಿದ್ದಾರೆ. ಸೊ ಒಬ್ಬೊಬ್ರು 10,000 ಕೊಡ್ಬೇಕು.
ಆಯ್ತು.
ಅಲ್ಲಿಗೆ 3, 4, 5, 6.
ಅದಕ್ಕೆ ಹೇಳಿದ್ ನಾನು.
4 ಜನ ಇದು 3
4 ಇರೋದು.
6 ಜನ ಇರೋದು.
4 ಇರೋದು ಇಲ್ಲಿ.
4 ಅಲ್ಲ ಸರ್. 4, 16, 17. ಒಂದು
ನಾಟ್ ಪ್ರೆಮಿಸಿಸ್ ರಿಪಿಟಿಷನ್.
ಪ್ರಿಮೈಸಸ್ ಅಲ್ಲಿ ಯಾಕಂದ್ರೆ ನೋಡಿ ಫಸ್ಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ 3 ಜನ ಇದ್ದಾರೆ. ಅವರು 10,000 ಕೊಡ್ಬೇಕು.
3 shops, 1 person. 3 shops, 1 person in first petition.
ಫಸ್ಟ್ ಪಿಟಿಷನ್ ಒಬ್ರೇನಾ?
ಒಬ್ರೇ. ಆಸ್ ಪರ್ ರಿಟ್ ಪಿಟಿಷನ್ 10,000 ಅಂತ ಹೇಳಿ.
ಆಯ್ತು. ಎಸ್.
ಅಲ್ಲ my lord, you may be directed to note, my lord, how many number of premises are there in the complex and how many are.
ಅದೆಲ್ಲ ಯಾಕೆ ಹೇಳ್ತೀರಿ? You said it is not in a good condition.
ಅಲ್ಲ ಅದು in general ನೋಡಿದ್ರೆ ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಫಸ್ಟ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ I am told, my lord, not a single shop is occupied.
How are you bothered?
Second, ಅಲ್ಲ it is not habitable at all. That is the reason why nobody is coming. How many times they have notified for auction?
It may not be habitable for various reasons. If you are not occupying for some reason, you can point out to the commissioner.
Allah, that's right. That's why I said that petitioner is permitted to point out the
whatever you want to point out deficiencies, you point out.
Very well, my lord. That may be observed. That's why I said that.
Any deficiencies? Yes. List on 14th or whatever. Badrinath.
Serial number 33. 32 urgent.
33.
Serial number 32 urgent. Serial number 33. Prithvish MK. Prithvish.
I appear for the petition, my lord. I appear for the petition. Can I seek a short accommodation, my lord? Just few days back, reply was also given. Can I come back to your lordship in another 10 days, my lord? If I'm not
List on so and so.
There is an interim order in operation as on today.
Interim order granted as extended to the next.
14th August.
Grateful.
Serial number 34 urgent. Serial number 35. Samit S.
Ground rent matter, my lord. It was ground rent matter. Supposed to other batch first.
If it is only ground rent, it is already covered. Covered ಅಲ್ಲ? ಮೇಡಮ್ ಇದೊಂದು ಗ್ರೌಂಡ್ ರೆಂಟ್ ಒಂದು ಮಾಡಿತ್ತು ನೋಡಿ. Where is the demand notice?
So demand notice is at annexure.
Also sought for scrutiny ಬೇರೆ ಕೇಳಿದ್ರಲ್ಲ. ನಕ್ಷೆ
Page number
ಪರಿಶೀಲನೆ.
20 madam. Page number 20.
ನಕ್ಷೆ ಪರಿಶೀಲನಾ ಶುಲ್ಕ ನೆಲ ಬಾಡಿಗೆ. ಕೆರೆ ಅಭಿವೃದ್ಧಿ ಶುಲ್ಕ. ಪ್ರಾರಂಭಿಕ ಪ್ರಮಾಣ ಪತ್ರ ಪಡೆಯದೆ ನಿರ್ಮಿಸಿದ ಕಟ್ಟಡದ ಭಾಗಕ್ಕೆ ದಂಡ. ಸ್ವಾಧೀನ ಪತ್ರ ಪಡೆಯದೆ ಈಗಾಗಲೇ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುವುದಕ್ಕೆ ದಂಡ. ಕಾರ್ಮಿಕ ಕಲ್ಯಾಣ ನಿಧಿ, ಭದ್ರತಾ ಠೇವಣಿ ಎಲ್ಲ ಇದೆಯಲ್ಲ. ಸೆಕ್ಯೂರಿಟಿ ಡೆಪಾಸಿಟ್ ಇದೆ. Security deposit there, labor cess is there. There is lake rejuvenation fee, then scrutiny fee, ground rent. All these things, I think it is covered.
Yes, covered.
Petition is allowed in part. The impugned demand raised by the respondent number 2. Vidates notice dated 21/3/2023. Insofar as it relates to scrutiny fee, ground rent, lake development fee, security deposit is quashed. As regards labor cess, the respondent number 2 is directed to issue a fresh demand in accordance with Rule 4 of the cess rules. And the petitioner shall pay the same in accordance with the Rule 4 of the cess rules. The other demands made by the respondent number 2, as per the notice dated 21/3/2023, is upheld. What about GST? GST and SGST, ಅದನ್ನ ಹೆಂಗ್ ಚಾರ್ಜ್ ಮಾಡ್ತೀರಾ?
My lord, they have, according my instruction, my lord, they have already other things they have paid.
You return this. GST ಹೆಂಗ್ ಚಾರ್ಜ್ ಮಾಡ್ತೀರಾ ನೀವು? ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡುವಾಗ GST ಹೆಂಗ್ ಕೊಡ್ತೀರಾ? GST and SGST.
My lord, that one I didn't, I thought other aspect on.
No, this also it is covered. Similarly, the demand for payment of is CGST at 9% and GST at 9%. CGST and SGST at 9% is also set aside. If amounts are paid by the petitioner towards CGST and SGST, the same shall be appropriate towards the other dues payable. Yes. You have any other matters?
In fact, my lords, on the last day,
Supposed to get listed today.
where a grounded, my lords, on the last day, there were 15-16 matters listed on 31st. We had demarcated which matters were only ground rent, like the petition that was listed today, and other petitions where there are levies under the ground rent along with levies under the KTCP Act, my lords. Section 18 as well as 18A. So those petitions are coming up on the 13th, my lords, whereas due to some inadvertent, the other petitions only pertaining to ground rent have not been listed.
What about lake rejuvenation charges under 18A?
18A, in fact, my lords, idರಲ್ಲಿ ನೋಡಿದ್ರೆ they do not say it is under section 18A of the KTCP Act.
Under 18A, they're entitled to demand.
Under 18A, they're entitled to. But in the demand notice, there's no specific mention of the KTCP provision itself.
No, that is right. Then lake rejuvenation charges ತೆಗ್ದಾಕಮದು. Let the lake rejuvenation be there.
Because that is yet to be decided.
This is made clear that the above order is subject to the outcome of writ appeal.
1050.
Writ appeal 105 filed by the state government.
Indeed, my lords, which is pending.
1050 of
2025.
2025. That is against the judgment authored by Justice Devdas or Justice Nagaprasanna?
That is from
Sitaram
Justice
Sitaram
Devdas.
Shetty.
That is from Justice Devdas' order.
Subject to the outcome of writ appeal 1050 of 2025.
Subdivision.
Yes.
Serial number 36, Devendrayan.
In that order, my lord. In that order, they have allowed, now BBMP is collecting.
Yadu?
The interim order.
That is right. But anyway, that is always subject to. Yes, next.
Serial number 36.
Petitioner, kindly pass our matter.
Devendra.
Kindly pass our
submission.
matter.
The issue is regarding the identification of a property which was put up for auction. It is his case that he thought it was a corner site going by this.
What was? This was auctioned to him.
It was auctioned to him. But my lord, then he doesn't even physically visit the site. He just goes by the satellite. He doesn't. So now the issue is whether that was a corner site which was, ಅದಕ್ಕೆ ಒಂದು sanction plan ಕೊಟ್ರೆ it might close this issue.
ಏನ್ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್?
Even ನಮ್ಮ layout plan ಅಲ್ಲಿ, layout plan ಅಲ್ಲಿ if it is a corner plot, then yes.
Then if you had auctioned it saying it's a corner plot.
It is not.
Then what is?
No, it was corner and intermediate. My lord may kindly see the auction notification. He goes only by this Google images, my lord, which is, it is just for, in an open area, he might be, okay, it is somewhere there and there. It might not be. Yes.
Is that the way you give the location?
No, my lord, he could have actually gone and visited also.
You should go to the spot.
He should
go to the spot and then upload the location.
That is exactly what it is. My lord, there might be some, even if, my lord, but even in our location, regular location also, there might be some difference of 2-3 feet.
It's not 2-3 feet.
Eitherly, my lord, my submission is this.
40-50 feet
He applies for a he applies for a intermediate site. Now he wants a corner site.
Now, where does he apply for intermediate? It's an e-auction.
He applied for a site. He has paid this 25%. Then when 75% was demanded, he says, then he goes and sees. To his shock, he finds out that
he doesn't go and see.
Yes.
But when he tries to log in again, the location is.
All the more, my lord,
pin has changed.
This can't be a ground, my lord, that he would be entitled to a site which is not at all earmarked as a.
So where is the notification? Where is the auction notification? What is the site number? Site number, you know?
Site number is
7088.
7088.
7088. ಏನಿದು? Further extension of Anjanapura 5th block.
Yes, English. We have clearly said, my lord, that geotag location of auction sites is for reference only. No claim is entertained if there are any discrepancies relating to it. We had said that even. I will not be on technicalities.
Click here to go antiದೆ.
Click here to go antiದೆ.
Click here to go. It took him to a corner site. When he
in the images, not physically. Not physically. Oh, he took him to a corner. That is what he says. Yes.
Click here to go. This is an e-auction.
Oh, the auction. Oh.
If it's an e-auction, if you are not mature to conduct an e-auction, you should not have done it. If you have the wherewithal, the technical expertise, then only you should have done it. ನೀವು e-auction click ಮಾಡಿ, took him to a corner site. Now you say no, ಅದೇನೋ mistake.
If there is an infraction of the rules of the BDA, my lord, as far as auction is concerned, yes, my lord, this is an add-on facility. Either ಈ technology ಅಲ್ಲಿ ಇರುವಾಗ you can go there and see it ಅಂತ. He has not even gone there.
Why should he go? It's
ಅಲ್ಲ ಆಯ್ತು ಸ್ವಾಮಿ, ಆದರೂ ಕೂಡನು.
Sir, why should he go?
My lord, it is only a self-serving statement. He says, I clicked this, it went there ಅಂತ.
Self-serving ಅಲ್ಲ. Please go to annexure page 19. Sorry, page 17. Sorry, page 18. 708A. Click here to go.
Click here to go.
He clicked it.
Yes.
It took him to a corner site.
That is what he says.
That is what he says. ತೋರಿಸಿ
live mobile ತೋರಿಸಬೇಕು.
ನೀವು ತೋರಿಸಿ, ನಿಮ್ತಾನೆ ವೆಬ್ಸೈಟ್.
I will try. I think this controversy can be set at right. Not if I am able to show that 708/A, which he applied, is not a corner site.
Yeah, then you return his money then.
It's up to him, my lord. I cannot say anything on that.
Return his money.
Right, my lord.
Page number 20 ಏನಿದು? There is one more location which says BDA 708A.
ಅದು Google map ಹಾಕಿರೋದು.
How can this location change, Unni Krishna? How can the location?
My personal experience, my lord, ಸ್ವಲ್ಪ difference ಬಂದೇ ಬರುತ್ತೆ. ಅಲ್ಲ ಈ ಸೈಟ್ ಬಗ್ಗೆ ಅಲ್ಲ.
No.
Generally, if one had to go by.
How can the pin change is what I am asking you. How can the pin change? Can the pin jump? Unless someone does it?
No, that can't happen.
Pin jump ಆಗುತ್ತಾ?
ಅಲ್ಲ, ಆಗಲ್ಲ.
No, whether the pin can jump from one place to another. Please come to Annexure F. Page 21.
ಅದೇ Google.
Young jump I pin no? Unless you must have changed it.
We cannot do that.
Why can't you do it?
Some control.
Pin can be changed. What is this? I think like your client, you are also a novice in
I might be a
using.
novice.
You are also a novice.
ನಾವು ಎಷ್ಟೋ ಸತಿ ಲೊಕೇಶನ್ ಕಳ್ಸಿರುವಾಗ ಸ್ವಲ್ಪ ಡಿಫರೆನ್ಸ್ ಆಗ್ಬಿಟ್ಟು
ಕೇಳ್ಕೊಂಡಲ್ಲ ಸೈಟ್ ಮಾಡ್ತಾ ಇದಾರೆ ಇಲ್ಲಿ ಅಂತ ಯಾರು ಕೇಳೋದಿಲ್ಲ. ವಿಡಿಯೋ ಸೈಟ್ ಮಾಡ್ತಿದಾರೆ ಇಲ್ಲಿ ಅಂತ ನೀವು ಲೊಕೇಶನ್ ಹಾಕಿದ್ರೆ ಲೊಕೇಶನ್ ಅವ್ರು ಕ್ಲಿಕ್ ಮಾಡಿದ್ರು ಇಟ್ ಟುಕ್ ಹಿಮ್ ಟು ಎ ಕಾರ್ನರ್ ಸೈಟ್. Based upon that he gave his bid. Now you say no, that is not corner site, that is intermediate site. Why he would not have participated in the bid? He would not have participated.
My lord, my lord, had the notification be only for a corner plot, then my lord, yes, it is also intermediate and corner. I will not come on that, my lord. I am the last person to come in the way of somebody being entitled to a site. I have been fair, my lord. 708
either you give him a corner site.
ಇಲ್ಲ ಆತರ ಮಾಡಕ್ಕಲ್ಲ. I will 708, my lord, then my lord,
return the money with interest. Return the money with interest.
The petitioner, but 708A, my lord, is definitely not a corner plot.
That is your problem, mister. For the mistake that you have committed, return the money with interest. Just the way you ask for interest from allottees, return the money with interest.
And my lord, he has also not paid the balance amount.
Not necessary. Why should he pay?
Not necessary in this form.
ಯಾವುದು ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ 25% ಕಟ್ಟಿದ್ದಾರೆ ಅವರು, ಅದಾದ್ಮೇಲೆ ನಿಲ್ಲಿಸಿದ್ದಾರೆ. 25% ಕಟ್ಬಿಟ್ಟು then after all that he has come for the petition. ಆ ಡೇಟ್ಸ್ ಎಲ್ಲ ಮುಗ್ದ ಮೇಲೆ ಆಯ್ತು ಸ್ವಾಮಿ, then I'll produce that plan.
How can you change the offer, mister? How can you change the offer after it is accepted?
But his only case is based on the GR tag, my lord. And my lord, we have
ನೀವು ಅದು ಮಾಡಬಾರ್ದಿತ್ತು. ನೀವು ಹೇಳ್ಬೇಕಾಯ್ತು, ನೀವು ಬಿಡ್ ಮಾಡಕ್ ಮುಂಚೆ ಹೋಗಿ ಸೈಟ್ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳ್ಬೇಕಾಗಿತ್ತು. Click here to go. Who asked you to do it?
Go andre to see anta, not physically.
Who asked you to do it? It's an e-auction, so electronically everything can be done anta ಅವ್ರು ಮಾಡಿದ್ರು. ಇವಾಗ now you say no. ಅದು ಬೇರೆ ಇದು ಬೇರೆ.
ಅಲ್ಲ ಅದು ಬೇರೆ ಅಂತಲ್ಲ, ನಾನು ಹೇಳ್ತೇನೆ his case is based on that.
No.
So ಆ ಒಂದು ಇದರಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. It is not his case that we have violated some rules, we have not given him time.
That is right. ಅದಕ್ಕೆ ಅವರು ದುಡ್ಡು ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ಅವರಿಗೆ along with interest.
And ನಮ್ಮ notification is for both type of sites, corner, BDA ಎಲ್ಲ.
ಯಾವ್ದಿದು? Which is this layout? Further extension.
Sir, MV extension.
Further extension of Anjanapura, 5th G block. ಎಲ್ಲಿದೆ ಇದು ಈ ಹರಾಜು ಪ್ರಕಟಣೆ ಒಳಗೆ?
ನಾನು ಲೇಔಟ್ ಪ್ಲಾನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
ಅಂಜನಾಪುರ ಲೇಔಟ್ 5th block. 5th G block.
Survey number 46/3A, Gollalli village.
Right side is 780. ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರವು ವಾಸಯೋಗ್ಯ ಮೂಲೆ ಮಧ್ಯಂತರ ನಿವೇಶನಗಳ ಈ ಹರಾಜು ಪ್ರಕಟಿಸಿದೆ. ಕ್ಲಿಕ್ ಮಾಡಿದಾಗ ಕಾರ್ನರ್ಗೆ ಹೋಯ್ತು. ಸೊ ಮೂಲೆ ಅಂತ ತಿಳ್ಕೊಬೇಕಾ, ಮಧ್ಯಂತರ ಅಂತ ತಿಳ್ಕೊಬೇಕಾ?
ಎರಡು ಮಿಕ್ಸ್ ಅಂತ. All types of sites.
Correct upon ನಿಮ್ಮ location tag is a corner site.
ನಾನು ಅದು layout plan ಕೊಡ್ತೀನಿ ಸರ್. 10 days ಕೂಡ I'll furnish.
Yes, are you willing to take back your money with interest?
Let my humble request is on alternative site, though it is a corner site. Alternative site, though it is same corner site may be given.
If you want to take back your money, you can take back along with interest. For the mistake that they have committed, they'll have to pay you interest.
Otherwise, I request this honorable court kindly give the any corner site to the.
Any corner site ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗುತ್ತೆ? ಈ ಕಾರ್ನರ್ ಸೈಟ್ ಬೇರೆ ಕಾರ್ನರ್ ಸೈಟ್ ಒಂದೇ ಆಗಕ್ಕೆ ಸಾಧ್ಯನಾ?
maybe this site, maybe they give the site to that price, we reduce the price maybe.
ಯಾವ ಪ್ರೈಸು?
ಈಗ ಮಿಡ್ಲ್ ಸೈಟ್ ಅಂತ ಏನ್ ಹೇಳ್ತಾ ಇದಾರೆ ಅವರು, ಅದೇ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಏನಿದೆಯೋ ಅದು ಆ ಲೆಕ್ಕದಲ್ಲಿ ಏನೋ ಕೊಡಕ್ಕಾಗುತ್ತಾ?
ನೀವು ಬಿಡ್ ಮಾಡೋದು ಎಷ್ಟಕ್ಕೆ?
1 ಕೋಟಿ ಚಿಲ್ಲರೆ. 89 lakhs something. 89 lakh.
89 lakhs ತಗೊಂಡ್ರೆ ಒಳ್ಳೇದೇ ತಾನೆ ಇವತ್ತು. ವಾಟ್ ಇಸ್ ದ ಸೈಜ್?
30-40.
30-40. Does it not make sense for you to buy even at that rate?
I'm informed it's a very prime site is what I informed. ಒಳ್ಳೆ ಡೆವಲಪ್ಡ್ ಏರಿಯಾ ಅಂತ. ಇಲ್ಲ ನನಗೆ ನಾನು ಕೇಳಿದ್ದೀನಿ ಸೈಟ್ ಚೆನ್ನಾಗಿದೆ ಎಲ್ಲ ಕೇಳಿದ್ದೀನಿ, ನಿಯರ್ ಸ್ಲಮ್ ತರ ಬಂದೆ. ದೇ ಆಲ್ ಸೆಡ್ ದಟ್ ಇಟ್ಸ್ ಅ ಗುಡ್.
ಅಂಜನಾಪುರ ಹೋಗಿದ್ದೀರಾ?
ಅಲ್ಲ ನಾನು ಆ ಕಡೆ ಹೋಗೇ ಇಲ್ಲ.
We are unable to identify though it is a forest.
ಆಯ್ತಪ್ಪ. Are you willing to take this site at the same price or we can ask him to reduce 10%?
ಅದು ಬೇಕಾದ್ರೆ ಹೇಳಿ ಸ್ವಾಮಿ ಪ್ಲೀಸ್.
10%
ಬೇಸ್ ಪ್ರೈಸ್ ಏನಿದೆ ಕೊಟ್ರೆ.
ಬೇಸ್ ಪ್ರೈಸ್
ಅಲ್ಲ, ಈಗ ಅಲ್ಲಿ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಏನಿದೆಯೋ ಆ ಟೈಮಲ್ಲಿ ಅಷ್ಟಿತ್ತು ಅಷ್ಟು ಕೊಟ್ರು.
ಬೇಸ್ ಪ್ರೈಸ್ ಕೊಡಂಗಿದ್ರೆ ಬಿಡ್ಡಿಂಗ್ ಯಾಕೆ ಹಾಕ್ಬೇಕಾಯ್ತು?
ಮೈ ರಿಕ್ವೆಸ್ಟ್,
you can tell him to consider reducing the value by 10%.
Please.
ಅದೇ ಸೈಟ್ ಬೇಕು ಅನ್ನಂಗಿದ್ರೆ, if you are willing to take that site, you can ask him to find out whether they are willing to close it at 10%.
ಈಗ according to my knowledge, they made a mistake by the engineering department, though it is middle site. As on the date of e-auction, they are not verified.
ಹೇಳಿದ್ದಾಯ್ತು mister. You want to retain this site or not?
I will talk to
retain it.
Kindly pass over, I will make my submission.
Retain ಮಾಡಿದ್ರೆ ಇಟ್ಸ್ ಅವರ್ ಅಡ್ವೈಸ್.
ರಿಟೈನ್ ಮಾಡಂಗಿದ್ರೆ 10% ಲೆಸ್.
ಅದನ್ನ ಕೇಳಬೇಕು.
ಕೇಳ್ಕೊಂಡು ಹೇಳಿ.
ಅಲ್ಲ ಮಲ್ಲ, ದಿ reason for auction is that it will fetch more than the market price. That is the reason. My lord, he cannot now say I made a mistake. Adu idanalla.
Now made a mistake. ಮಾಡಿದ ಮಿಸ್ಟೇಕ್.
ಅಲ್ಲ ನಾವೇ ಅದೇ ಹತ್ರ ಹೇಳ್ಕೊಂಡಿದ್ದು
correct, but then loss of opportunity, I am going to impose cost on you, on your officers, to be recovered from their salary.
Loss of
opportunity. Loss of opportunity. He could have participated in the auction. He could have bid for some other site. ಇವಾಗ ಅದು ಆಕ್ಷನ್ ಹೋಗಿತ್ತಾ ಅದು? He lost the opportunity.
No, he successful.
ಈ ಸೈಟ್ ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಆಯ್ತಪ್ಪ.
ಅಲ್ಲ ಈ ಸೈಟ್ ಕೊಡಕ್ಕೆ ರೆಡಿ, ಅವ್ನು ಬ್ಯಾಲೆನ್ಸ್ 95 ಕೊಡ್ಬೇಕಲ್ಲ.
So therefore ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the petitioner submits that the petitioner is willing to take the site in question, even if it is an intermediate site, provided the respondent considers reducing the auction price by 10%. The learned counsel for the respondent seeks time to secure instructions. List on yavat?
Any day.
Next Thursday. List on Thursday.
13th August.
Manmohan.
Serial number 37.
Public.
Manmohan PN.
PN Manmohan.
Please. In this matter, third respondent, he was implicated subsequently. Initially, he was not a party.
What is sought for?
I have challenged him, the regulation, virus of the regulation itself. I am now asked to give the site free of cost. This is insofar as intermediate ring road.
Mysore.
Illa Bengaluru.
What have we sought for?
I have
so far condition number 8. No condition in.
I have to relinquish the site free of cost.
What have to be relinquished?
At the time of giving the provisional certificate.
Annexure G, na H.
Annexure K, page number 70.
Sought for something in annexure H, condition number 8.
Please, that is page number 59.
ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ರಸ್ತೆ ಇತ್ಯಾದಿ ರಸ್ತೆ ಪಂಕ್ತೀಕರಣದಲ್ಲಿ ಬರುವ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರಕ್ಕೆ ನೋಂದಾಯಿತ ಪ್ರಕಟೆಯಾಗಿ
condition number 8.
We all ಇದೆಲ್ಲ set aside.
Regarding my lord, zonal regulation is very clear, BDA my lord, that has been challenged here because the regulation itself say that my lord, that pertaining to lordship aware of that the judgment pertaining to circular quashed by this honorable court. The regulation is not quashed my lord.
Even if there's a regulation, how can you ask him to give it up free of cost? Even if there's a regulation.
Regulation is very clearly said, my lord.
No, but you have to acquire it.
Please.
Section 69 nodidre,
On
you have to acquire it.
on that regard, my lord, similar appeal is, my lord, order pass in favor of the authority, my lord, I will place it.
Order placed in favor of the authority.
Please, please.
ಏನಂತ?
To regarding, that is not required to acquire, it is, my lord, for development purpose ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಆ ರೆಗ್ಯುಲೇಷನ್ ಹಾಕೇ ಬರ್ದಿದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರ ಒಂದು ಕೊಟ್ಟರೆ ನಾವು ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ ಹೇಳ್ಬೋದು. Page number, my lord, 89. Regulation number, my lord, 7.3.
No, I can understand
Please,
if it is a layout, the internal roads have to be given relinquished. I can
Please.
understand. But a road which is yet to be formed
My lord, in this
or identified in the master plan.
in this case, my lord, that road within the layout plan,
Correct.
even though, my lord, single plot itself. This is a, my lord, when, my lord, the road comes within the layout plan, my lord, whether it is, my lord, single plot or layout plan, my lord, it can be relinquished to that. That is the conditions. Even though, my lord, lordship, my lord, if within the excluding the plan, my lord, then, my lord,
Angida, suppose if there's a 100 feet road running through the layout,
please.
which is yet to be formed, FAR ನೀವು 100 feet road ಪ್ರಕಾರ
ಇಲ್ಲ,
ಕೊಡ್ತೀರಲ್ಲ,
FAR ಅದು ಫುಲ್ಲೇ ಕೊಡ್ತಾರೆ ಅವರಿಗೆ.
100 feet applicability, 100 feet ಗೆ ಅಪ್ಲೈ ಆಗೋತ್ತ
Without deducting that, my lord, we give an FAR.
See, for a 100 feet road,
Please.
the FAR is more.
Please.
Would you accept it? It is, I think, 3 or 3.25.
Please.
Suppose if it's a 30 feet road, FAR is only 2.
Please.
100 feet road ಇನ್ನ ಮಾಡೇ ಇಲ್ಲ ನೀವು. You want it to be relinquished. Plan sanction ಮಾಡೋದು ಮಾತ್ರ FAR 2 ಕೊಡ್ತೀರಾ. Plan sanction ಮಾಡುವಾಗ FAR 2 ಕೊಡ್ತೀರಾ.
Lord, this is, my lord, pertaining to BDA regulation. In respect of our regulation is concerned, my lord, we have given maximum FAR, my lord, without deducting that which was area was relinquished to the authority.
That is, no, you're not getting it.
Please, please.
If it's a 100 feet road,
Please.
if it's a 100 feet road, the maximum permissible FAR will be given. Correct?
Please, please.
If it's a connecting road is 40 feet, the FAR goes down.
Please.
Now your 100 feet is yet to be formed, for which he has to relinquish. You don't take that 100 feet for the purpose of calculating FAR.
Please.
You treat it as a 40 feet road. ತಪ್ಪಲ್ವಾ ಅದು? ಜಮೀನ್ ಬಿಟ್ಕೊಟ್ಟ ಮೇಲೆ ಆ ರೋಡ್ಗೆ ಅಪ್ಲೈ ಆಗುವಂತ FAR ಕೊಡ್ಬೇಕು ಅವರಿಗೆ. ಅದು ತಪ್ಪಲ್ವಾ ಅದು? Yes, ಯಾವಾಗ?
Next week.
Learn counsel for the respondent. Number 3 seeks time to secure instructions. List on so and so.
14.
19.
Anandita Srinivasan.
14th, Lordship may kind, my lords, may make one request. 14th, I have some inconvenience. Can it be on 12th, my lords?
12th is not
20th.
either 13th, 14th, 20, 21, 27, 28.
Lordship may have it on 20th, my lords.
20.
Obliged.
Anandita Srinivasan.
On the last occasion, your lordship had directed the respondent to
I seek an
ascertain what
indulgence,
BDA
plus.
sites are there in Sir M. Vishweshwaraya layout, my lord.
I seek an indulgence of accommodation of time, my lords. 17th ಗೆ ಹಾಕೊಳ್ಳಿ ಸರ್ date.
ಏನ್ ನೀವ್ ಹೇಳಿದ ಡೇಟ್ ಕೊಡ್ತಾ ಇದೀವಿ ಬಟ್ ಯಾರು ಏನು ಮಾಡ್ತಾ ಇಲ್ಲ.
ಅವರು
My lord, this-
Simply listing matters.
Virtually the second round, I'm here before this
ಯಾವತ್ತು
lordship.
ಬೇಕು ಅಚ್ಚಪ್ಪ?
17th ಕೊಡಿ ಸರ್.
17th Monday.
17th is this Monday, 20th. Learn counsel for the respondent number 2 to 4 seeks time to secure instructions to comply the order dated 23/7/26. List on 20th.
Grateful.
Number 39, Timaya KH.
KH Timaya. Yes, what happened?
The last occasion, short
ಈ case. ಏನಾಯ್ತು?
Take instruction from the secretary.
ಕೇಳ್ದೆ.
So for us allotment of the site is concerned.
Yes, ಅದಕ್ಕೆ.
ಅಲ್ಲ ಕೇಳ್ದೆ, that is what they are saying. One is the rules don't forbid. ಅಂದ್ರೆ ಅದೇ it becomes precedent, my lord.
Now we will say that this will not be treated as a precedent. We will say that this application filed by the husband shall be treated as an application filed by the wife and shall be the second attempt and neither the petitioner nor his wife shall be entitled for allotment of any BDA site. ಆಯ್ತು, ನಾವು ಡೈರೆಕ್ಟ್ ಮಾಡ್ತೀವಿ. Let us we will direct. Yeah, we will say that this will not be treated as a precedent under any circumstance. ಏನ್ ಮಾಡ್ತೀರಿ?
Clarity ಕೇಳ್ಕೊಂಡು ಬಂದಾಗ we will not be able to. I'm not concerned about what correctly.
ಏನ್ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದಿರೇನ್ರಿ? ಲೀಸ್ ಆಗಿಲ್ವಾ?
Lease cum sale agreement ಮಾಡಬೇಕಾದ್ರೆ they have taken the issue.
Genuine ಆಗಿ ಆಗ್ತಕ್ಕಂಥ ಕೇಸ್ಗಳು ಆದ್ರೆ ಒಂದಾಗ್ತದೆ. Genuine ಆಗಿ ಆಗದೇ ಇರ್ತಕ್ಕಂಥದ್ದು ನಮ್ಗೆ ಗೊತ್ತಿದೆ ಹೇಗೆ.
No, we can say ಎಷ್ಟು ಜನ ಮಕ್ಕಳು ನಿಮಗೆ?
ಒಬ್ರೆ.
We will say that even the daughter will not be entitled to apply for a site. That is right. We will say that this will not be treated as a precedent. See, it is all your mistake. You should have been careful while considering the attempts, which is mentioned in the application. Blind and you act madidira. You have received the money. Entire payment
Entire amount has been paid. Even 11 rupees deposit was
paid. It's all your mistake. Now, if you say that no, you have committed a mistake.
21% delay payment, 21% matter. It became such a difficult precedent for us that it took us a lot of time, with a very intense litigation to have it turned back. A lot of an entire stream of chain of cases. I'm not saying anything about the London friends claim. I'm not. But then, Lord, that would become a habit, and I'm still the chain of people in this community. It's what my experience with BD has been in the last 6 years. ಅದೇ ಒಂದು ಅವಕಾಶ ಮಾಡ್ಕೊಳ್ತಾರೆ.
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? How will they misuse it? How will they misuse it?
ಏನಾಗುತ್ತೆ BDನಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಏನು? ಸೆಕೆಂಡ್ ಲೆವೆಲ್ ವೆರಿಫಿಕೇಶನ್ ನಮ್ಮ ಕೈಲಿ ಮಾಡಕ್ಕಾಗಲ್ಲ ಬಿಕಾಸ್ ಆಫ್ ಲ್ಯಾಕ್ ಆಫ್ ಮ್ಯಾನ್. ಯಾರನ್ನೋ ನಾವು ಕಳಿಸಿ ವೆರಿಫೈ ಮಾಡ್ಲಿಕ್ಕೆ.
ಆಯ್ತು, suppose if we say that this application filed by the husband shall be treated as the second attempt made by the wife, and henceforth the husband and the wife shall not be entitled for allotment of any other site, including the dependent daughter or whatever.
ನಾನು ನನ್ನ ಅನುಭವ ಅಂತ ಹೇಳ್ತೀನಿ. Sorry that I'm taking my lots. I'm just expressing my opinion. I conducted that batch matters where delayed payment were taken with 21% interest and sites were allotted after a period of 10-15 years. I handled that matter in the writ appeal stage. There are a lot of cases where BD had done it. When finally the commissioner said that we have to put a stop to it because it is getting misused, the files were given to me, original files were given to me. I verified the original files. The person who had actually sought for allotment and the person who had now come to the court were unrelated. The signatures mismatched. The letters that we had written to that person had come back saying that no such person in the address. It was felt, my lord, by the team of the SPF, and I felt it, that the persons who are now trying to claim that they are so and so and they sought allotment and came to the honor of the court were just the people who were related to a lobby and.
ನೀವೇನು ಮಾಡಬೇಕಾಗಿಲ್ಲ. ಅಲಾಟ್ಮೆಂಟ್ ರಿಜಿಸ್ಟರ್ ತಗೊಳ್ಳಿ. ಅಲಾಟ್ಮೆಂಟ್ ರಿಜಿಸ್ಟರ್ ತಗೊಂಡು KB ಮೀಟರ್ ಇರುತ್ತೆ. KB ಮೀಟರ್ ತಗೊಂಡು ಕಂಪೇರ್ ಮಾಡಿ. ಒಬ್ಬೊಬ್ರಿಗೆ 5-5, 6-6 ಸೈಟ್ ಇರುತ್ತೆ. ಅದನ್ನ ಮಾಡೋದಿಲ್ಲ ನೀವು.
What happened, Lord, was we wanted to take strict action. I suggested that we take some action. The rot has to stop somewhere. I was not spared in the bunch.
Right, but then
Because of the target. So it becomes so difficult, my lord, that
you're like a blind man. You're simply walking. You don't know which direction to go. You're simply walking.
So ಏನಾದರೂ ಮಾಡಿದ್ರೆ ಅದೇ ತರ ಆಗಿದೆ. ನಾನು my lord, I don't want to talk anything about it. Lord knows. I don't have to say anything about it. I am only expressing my apprehension rather than, my lord, trying to say something which is not like that. ಆಮೇಲೆ ಹಳೆ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದನ್ನು ರಿಓಪನ್ ಆಗ್ತದ ಅಂತ ಹೇಳಿ ಅದು ಒಂದು ಅಪ್ಡೇಟ್. Older application which have already been rejected, would they also start getting reopened now?
What does the BDA allotment of site rules say? Whether he or she should not have a site?
General agalla, but if they have subsidial allot ಆಗಿರೋ 11 ಅಲ್ಲಿ ಪ್ರಾಫಿಟ್ ಸೈಟ್ ರೂಲ್ಸ್ 11 ಅಲ್ಲಿ ಬೇರೆಯವರ ಪ್ರೈವೇಟ್ ಸೈಟ್ ತಗೊಂಡ್ರೆ ಅಪ್ಲೈ ಆಗಲ್ಲ, ಬಟ್ ದೇ ಶುಡ್ ನಾಟ್ ಹ್ಯಾವ್ ಎ ಸೈಟ್ ಅಲಾಟೆಡ್ ಅಟ್ ಸಬ್ಸಿಡಿ ಐದರ್.
So if the wife had some site, she says that she had purchased some site, so therefore she did not make the second attempt.
That is not a bar from what.
No, that is not a bar. So we'll say that this application filed by the husband shall be treated as a second attempt made by the wife. That is the reason why she says that I did not make the second attempt.
What is the nature of the site owned by the first
Revenue
site? It is allotted.
Revenue site ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಅವರು.
Revenue site.
ಎಲ್ಲಿದೆ ಸೇಲ್ ಡೀಡ್ ಇದೆಯಾ ಅದರದ್ದು?
ತಂದಿಲ್ಲ ಸರ್.
ನಿಮ್ಗೆ ಯಾವ್ದು ನಿಮ್ಮ ಮಿಸ್ಸಸ್ ಹೆಸರಲ್ಲಿ ಸೈಟ್ ಇತ್ತಲ್ಲ, ಎಲ್ಲಿ ಯಾರು ಕೊಟ್ಟರು? ಸೊಸೈಟಿನಾ?
ಇಲ್ಲ ಸೊಸೈಟಿ ಅಲ್ಲ.
ಕೇಳಿ ನೋಡಿ ಯಾವುದು ಅಂತ. ಎಲ್ಲಿದೆ ಎಲ್ಲಿದೆ ಸೇಲ್ ಡೀಡ್ ಒಂದು ಕಾಪಿ ಕೊಡಿ. ಸೇಲ್ ಡೀಡ್ ಒಂದು ಕಾಪಿ ಕೂಡ ಕೇಳಿ. ತಂದಿದ್ದೀರಾ? ಇದೆಯಾ ಮೊಬೈಲಲ್ಲಿ? ಪ್ರಿಂಟ್ ಕೊಡಿ ಒಂದು. ಒಂದು ಪ್ರಿಂಟ್ ಕೊಡಿ, ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ.
ಫಾರ್ಮಲ್ ಆಗಿ ಅಬ್ಜೆಕ್ಷನ್ ಫೇಸ್ ಮಾಡ್ತೀನಿ.
Pass over. Learned counsel for the respondent has filed a statement of objections. The same is taken on record. Marie Lingegowda.
Number 40.
Let it be placed on record tomorrow.
ಇದನ್ನು ಕೊಡ್ತಾರೆ ಈಗ ಮೊಬೈಲಲ್ಲಿ ಇದೆಯಂತೆ. This is what I am going to pass. I am going to say that this will be treated as a second attempt filed by the wife. And this shall not be treated as a precedent. This judgment is passed in view of the peculiar facts of the case because BD has accepted the money and issued an allotment letter and things have changed. And no further allotment to the husband, to the wife or to even the daughter also.
Serial number 40, Marlingegowda, appearing for petitioner in this case, my lord. My lord, seeking direction to the respondent number 1 to transfer the kata in my name, my lord. My lord, in the year 2006 itself, my lord, the BDA, Employees Welfare Association, my lord, formed a layout, my lord. In the year 2008, my lord, they allotted one site to the allottee, my lord. Then, my lord.
Yes, Mr. Krishna.
The association has filed the expedition coming up tomorrow.
Association is.
They have filed their expedition. In that case, your lordship directed them to produce the bylaws of the society. Maybe Shivakumar is saying.
ಅವ್ರು ಅಪೀಲ್ ಹಾಕಿದಾರೆ ಅದ್ರ ಮೇಲೆ?
ಹಾಕಿಲ್ಲ, ನಾಳೆಗೆ ಅದು ಬ್ಯಾಚ್ ನಾಳೆಗೆ ಬರ್ತಾ ಇದೆ. ಇದನ್ನು ಅದರ ಜೊತೆ ಇಲ್ಲ.
Your
one of the allottee has already, one of the purchaser filed a writ petition in.
Correct, Mr. Idu. Who is this petitioner? Is an allottee?
No, my lord, he is a bona fide purchaser.
From whom did you purchase?
Transaction taken place, my lord.
Whom did you purchase?
I purchased it from my vendor. My vendor's vendor is the allottee.
Whether your vendor's vendor was a member?
Please, my lord.
He was an employee of BDA or a deputy?
He is an employee of BDA, my lord. I will.
Are you sure?
I need to take instruction from him, my lord.
Page 38, my lord. Original sale deed, there is a condition, specific condition that sale deed in 10 years, they cannot alienate the property. Page 38.
ಅದಕ್ಕೆ ನಿಮ್ಮ ಕಂಡೀಷನ್ ಇದೆ 50% ಏನೋ. You can collect some 50% penalty.
ಅಲ್ಲ, ಇಲ್ಲಿ ಖಾತಾ ಇಶ್ಯೂ ಮಾಡಿ there is a direction from the government, my lord, there is a circular. That circular was challenged by the association. ಅದು ನಾಳೆಗೆ ಬರ್ತಾ ಇದೆ.
ಇಲ್ಲ, ಬಟ್ ಆ ಗ್ರೌಂಡ್ ಇದ್ರೆ violation of a condition of non-alienation, there is a penalty imposed, 50% of the allotment price ಏನೋ ಇದು ಕಟ್ಟಬೇಕು ಅಂತ.
My lord, my vendor had a kata. My vendor's vendor had a kata. Subsequently, I purchased the property, my lord. My lord, based on the oral direction in the year 2019 itself, my lord.
List tomorrow, na?
After lapse
List tomorrow along with WP number?
653.
10,737 of 26.
Yes. 42 M Ganesh,
Even urgent, seal number 42, M Ganesh.
K Krishna.
Lordship directed me not to, Lords, ascertain whether any benefits could be extended to the petitioners.
Constable seeks time to comply the order dated in view of the ongoing.
BBMP.
Anyway, what is the issue?
But this is regarding they made the application for the BD for approval of the layout plan. The builder, my lord, that we have resolved to approve the layout plan with certain condition. They have not fulfilled the condition. Thereafter, the layout plan was not approved. But the builder, they have formed the layout, and these petitioners are purchasing of these sites from the unauthorized layout. Now, last date and your last.
ಅದೇನೋ ಖಾತೆ ಮಾಡೋದ್ರ ಬಗ್ಗೆ.
Lord, the past resolution, my lord. So, because the entire area, my lords, does not come within the purview of this corporation, the matter is referred to GBA, my lord.
ಯಾರಿಗೆ ಬರುತ್ತೆ ಮತ್ತೆ ಇದು?
ಅದು GBA ಬರುತ್ತೆ ಸ್ವಾಮಿ.
BDA
ಅಲ್ಲ, GBA, Greater Bangalore Authority. My lord, may I read, my lord, second page, last, my lord, that would be relevant. Lord, ಜಂಟಿ ನಿರ್ದೇಶಕರು ನಗರ ಯೋಜನೆ ಬೆಂಗಳೂರು ಪಶ್ಚಿಮ ನಗರ ಪಾಲಿಕೆರವರು ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ಪ್ರಸ್ತಾಪಿಸಿ ಕರ್ನಾಟಕ ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಕಾಯ್ದೆ ಕಾಲಂ 17(2)E ರಲ್ಲಿ ಉಲ್ಲೇಖಿಸಲಾದಂತೆ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರದಿಂದ ಬಿಡುಗಡೆಗೊಳ್ಳದಿರುವ ಬಡಾವಣೆ ನಿವೇಶನಗಳಿಗೆ ಖಾತಾ ನೀಡಲು ಅವಕಾಶವಿಲ್ಲದೆ ಇರುವುದರಿಂದ ಈಗಾಗಲೇ ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ತಿಳಿಸಿರುವ ಮಾನದಂಡಗಳ ಅಡಿಯಲ್ಲಿ ಪ್ರಸ್ತುತ ಅಧಿಕಾರ ಪ್ರತ್ಯಾಯೋಜನೆಗೊಂಡ GBA ಹಂತದಲ್ಲಿ ಕ್ರಮವಹಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಪಾಲಿಕೆಗಳಿಗೆ ಕೇವಲ 2.5 ಎಕರೆ ವಿಸ್ತೀರ್ಣದ ವರೆಗಿನ ಏಕ ನಿವೇಶನಗಳಿಗೆ ಅಭಿವೃದ್ಧಿ ಯೋಜನೆ ಮಂಜೂರಾತಿ ನೀಡಲು ಅವಕಾಶವಿದ್ದು, ಅದೇ ರೀತಿ ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಬೆಂಗಳೂರು ದಿನಾಂಕ 24/7/2026 ಅಡಿಯಲ್ಲಿ ಗ್ರೇಟರ್ ಬೆಂಗಳೂರು ಪ್ರಾಧಿಕಾರದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ 2000 ಚದರ ಮೀಟರ್ ವರೆಗಿನ ಏಕ ನಿವೇಶನದ ವಿನ್ಯಾಸಗಳಿಗೆ ಅನ್ವಯಿಸಿ ಶೇಕಡಾ 2 ಮಾರ್ಗಸೂಚಿ ದರದ ಶುಲ್ಕವನ್ನು ಪಾವತಿಸಿಕೊಂಡು ಖಾತಾ ನೀಡಲು ಅವಕಾಶವಿದ್ದು, ಸದರಿ ಬಡಾವಣೆಯು ಈ ಆದೇಶದ ವ್ಯಾಪ್ತಿಯನ್ನು ಮೀರಿರುವುದರಿಂದ ಹಾಗೂ ಸದರಿ ಪ್ರಕರಣದ ವಿಷಯದಲ್ಲಿ ತೀರ್ಮಾನವು ನೀತಿ ರೂಪಣೆ ಪಾಲಿಸಿ ಮ್ಯಾಟರ್ ಆಗಿರುವ ಕಾರಣ GBA ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ವಿಷಯದ ಕುರಿತು ಗ್ರೇಟರ್ ಬೆಂಗಳೂರು ಪ್ರಾಧಿಕಾರದ ಮುಖ್ಯ ನಗರ ಯೋಜಕರ ಹಂತದಲ್ಲಿ ತೀರ್ಮಾನ ಕೈಗೊಳ್ಳಬೇಕಾಗಿರುತ್ತದೆ ಎಂದು
This area lies within the BBMP limits or not?
BBMP planning authority is GBA now presently. GBA is presently the planning authority.
So all I directed was,
please,
why don't you consider treating it as an irregular, what you call sale, and regularize it by applying whatever this policy decision that you have taken, by imposing some 2% of the market value and regularize this purchase.
Individually it can be done, my lord.
Individually,
the petitioners, if they approach individually, my lord, they will consider. Lordship may kindly direct.
If you say that you will consider, I will dispose this.
As a layout, my lord, this is the difficulty.
Not as the entire layout, individually. Individual.
My lord, my instructions are, my lord, that they had approached the joint commissioner, and apparently they have been told to, my lord, individually make applications.
B ಖಾತೆನೂ ಆಗಿಲ್ವಾ ನಿಂದು?
ಇದು ಎ ಖಾತೆನೇ ಸ್ವಾಮಿ, ಎ ಖಾತೆನೇ ಆಗಿದೆ.
ಮತ್ತೆ ಈ ಖಾತೆ ಮಾಡಿಸ್ಬೇಕು.
ಎ ಖಾತೆನೇ ಮಾಡಿದಾರೆ ಅವರು, ಎಲ್ಲಾನು ನಮ್ದೆಲ್ಲ ಎ ಖಾತೆನೇ ಆಗಿರೋದು. Layout is neatly formed and entire investment is made by the society itself.
That is okay, mister. What is your problem? You don't have an e-khata.
The problem is a letter written by fourth respondent to sixth respondent. Sixth respondent is obstructing the enjoyment of the property. He is not allowing us to get the plan sanction. He is not allowing.
Fourth respondent is executive engineer.
Executive engineer. He has dashed a letter to sixth respondent, my lord.
Joint commissioner.
Yes, my lord.
ಏನಂತ?
ಇದಕ್ಕೆ ಮನೆ ಖಾತೆ ಗೀತೆ ಮಾಡಬೇಡಿ, ಮತ್ತೆ ಅವ್ರಿಗೆ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್
ಓದಿ,
ಮಾಡಬೇಡಿ.
ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಓದಿ?
2016, my lord, they have.
Page number?
Kindly see the last letter, my lord.
Page number ಹೇಳ್ರಿ.
Ink page.
Annexure K.
Annexure K. Annexure, ಇವ್ರು ಅವ್ರು ಹಾಕ್ಕೊಂಡು.
ಓದಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅನಕ್ಷರ ಕೆ ನಲ್ಲಿ ಓದಿ.
Annexure K ಮೇಡಮ್. Annexure, kindly see annexure L, ink page 264 madam. 264.
Annexure K is at page 262.
Annexure K is the letter.
ಓದಿ ಫಸ್ಟ್ ಲೆಟರ್ ಓದಿ.
ಲೆಟರ್ ಅಲ್ಲ, ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಶ್ರೀ ರಾಜರಾಜೇಶ್ವರಿ ಗೃಹ ನಿರ್ಮಾಣ ಸಹಕಾರ ಸಂಘ ನಿಯಮಿತ 914 ಆಫ್ ಕ್ವಾರ್ಟರ್ ಅಡ್ಡ ರಸ್ತೆ ಮಾರುತಿ ಸರ್ಕಲ್ ಹತ್ತಿರ ಪೈಪ್ಲೈನ್ ಹನುಮಂತನಗರ ಬೆಂಗಳೂರು 19 ರವರೆಗೆ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳು ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕುರವರು ತಾಲೂಕು ಕೆಂಗೇರಿ ಹೋಬಳಿ ನಾಗದೇವನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 3/5 3/6 3/7 11/1 3/8 3/9 4/12 4/2 4/1 4/4 5/2 8/1 ಬಿ 8/4 8/5 8/2 8/3 2/10 9 12/2 ಬಿ ಮತ್ತು 5/1ರಲ್ಲಿ ಒಟ್ಟು 29 ಎಕರೆ 19 ಗುಂಟೆ ಜಮೀನನ್ನು ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡು ಆರ್ಡಿ ನಂಬರ್ 165/AOB 89 ದಿನಾಂಕ 13/11/92ರಲ್ಲಿ ಬಡಾವಣೆ ರಚಿಸಲು ಭೂಮಿಯನ್ನು ಸಂಘದವರಿಗೆ ಹಸ್ತಾಂತರಿಸಲಾಗಿರುತ್ತೆ. ಮೇಲ್ಕಂಡ ಬಡಾವಣೆ
ಲೇಔಟ್ ಪ್ಲಾನ್ ಪರ್ಮಿಷನ್ ಎಲ್ಲಿದೆ?
ಲೇಔಟ್ ಪ್ಲಾನ್ಗೆ ಅವರು
ಏನೇನು ಕಂಡೀಷನ್ಸ್ ಇತ್ತು?
Condition NOC from the KEB and BWSSP, Pollution Control Board. And in the middle, my lord, the annexure D prakara, they demanded development charges of 57 lakhs. That order was assigned before this honorable court. This honorable court formed a considered opinion. The demand made by the respondent is not correct, and the order is set aside. And formed a opinion that the layout plan is correct. And that order was challenged by the respondent before the Honorable Supreme Court of India. Supreme Court of India set aside that order and directed the first respondent to consider whether the service charges or development charges made by the respondent is excessive or not. That issue was not considered. The petitioners filed a writ petition before this Honorable Court by way of and even that representation was also considered even today. First respondent has got a direction.
Where is the judgment of the Supreme Court?
Kindly see annexure. Annexure F, my lord. Ink page 159.
159, huh?
159, ink page 159. I'll read out the operative portion of the order.
Yes.
That is on ink page 246. In the results, the appeals are allowed. Impugned order is set aside, and writ petitions filed by the respondents are dismissed, subject to the direction that within 3 months from the date of receipt of production of the copy of the judgment, state government shall take appropriate decision in the context of communication dated 3/5/2005. Within this period, the state government shall also decide whether the levy of supervision charges, improvement charges, examination charges, slum clearance board, some clearance development charges, and MRTS at the rate specified in the communications of BDA was excessive. The decision of the state government should be communicated to the respondents within next 4 months. If any of the respondents feel aggrieved by the decision of the state government, then it shall be free to avail appropriate legal remedy. Parties shall bear their own cost.
ಇದಾದ್ಮೇಲೆ ಏನಾಯ್ತು? ಗವರ್ಮೆಂಟ್ ಅವ್ರು ಮಾಡಿದ್ರೆ ಏನಾದ್ರು?
ಮಾಡಲಿಲ್ಲ ಸ್ವಾಮಿ, ಏನು ಮಾಡಲಿಲ್ಲ. Then we have filed a writ petition. Kindly see annexure 252 mail. Annexure H. I will read out the operative portion mail. In view of the aforesaid facts, in page 258, in view of the aforesaid facts and circumstances, rival submissions, respondent number 4 is hereby directed to address the grievances of the petitioners and consider the representation dated 18/1/2020 at Annexure A. Pass
Already
appro-
respondent number 4 is the assistant executive engineer.
Yes, my lord. Direction
ಇಲ್ಲ
is
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದು ಸ್ಟೇಟ್ ಅಂತಾರೆ.
state. But ಇವ್ರು ಹಾಕೊಂಡ್ರು writ petition ಅಲ್ಲೇ the direction is given by this honorable court to respondent number 4
You asked for a direction, they gave a direction.
to dispose our representation. Our writ petition is to dispose our as per the consider the directions given by the honorable Supreme Court of India.
Correct. If that is the case, in 54 ಲಕ್ಷ ಏನೋ ಕೊಡ್ಬೇಕಲ್ಲ, ಅದು ಕೊಟ್ಬಿಟ್ಟು why don't you buy peace? 54 ಲಕ್ಷ ಏನೋ ಕೊಡ್ಬೇಕಲ್ಲ.
57 ಲಕ್ಷ ಅವ್ರು ಕೇಳಿದ್ದಾರೆ. That order was set aside by this division bench of this honorable court. And when they have gone to this,
If they are willing to clarify, if you pay this money, if we can say that the layout is duly approved, what more you want? ಇಷ್ಟು ಜನ ಇದ್ದೀರಲ್ಲ ನೀವು, ಎಲ್ಲ ಡಿವೈಡ್ ಮಾಡ್ಕೊಂಡು can you not pay it and buy peace?
now the area is taken over by the corporation.
It is fair enough. Plan ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿಲ್ವಲ್ಲ ನಿಮ್ದು. ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆದ್ರೆ ನಿಮ್ ಟೈಟ್ಲ್ ಪರ್ಫೆಕ್ಟ್ ಆಗುತ್ತೆ. ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿಲ್ದೇ ಇದ್ರೆ your title is always doubtful.
The appropriate authority.
Lecture R7, they individually approach.
Annexure?
Lecture R7 to my statement of objection, page 23.
ಎಲ್ಲಿದೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್? ಹಾಕಿದಾರ ಅಲ್ಲಿ ಕೊಡಿ. Anyway, if we can dispense the requirement of NOCs from KEB, because ಈಗಾಗಲೇ ಬಿಲ್ಡಿಂಗ್ ಗಳೆಲ್ಲ ಕಟ್ಟಿರ್ತೀರಿ, ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕೊಟ್ಟಿರ್ತಾರೆ, so the purpose of NOC is now lost. R7.
Their representation is concerned. ಉಲ್ಲೇಖಿತ ಮನವಿಯಲ್ಲಿ ರಾಜರಾಜೇಶ್ವರಿ ಗೃಹ ನಿರ್ಮಾಣ ಸಹಕಾರ ಸಂಘದಲ್ಲಿ ನಿರ್ಮಿಸುವ ಬಡಾವಣೆಯಲ್ಲಿ ವಿವಿಧ ಅಳತೆಯ ಒಟ್ಟು 568 ನಿವೇಶನಗಳು ಸದರಿ ನಿವೇಶನಗಳ ಮಾಲೀಕರುಗಳು ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಪ್ರತಿ ಪಾವತಿಸಬೇಕಾದ ಶುಲ್ಕ ಮೊತ್ತ 57,10,000 ಪಾವತಿಸುವುದಾಗಿ ತಿಳಿಸುತ್ತಾ ಸದರಿ ಶುಲ್ಕವನ್ನು ಪಾವತಿಸಿಕೊಂಡು ನಿವೇಶನಗಳ ಮಾಲೀಕರುಗಳಿಗೆ ಪ್ರಾಧಿಕಾರದ ನಿರಾಪೇಕ್ಷಣ ಪತ್ರ, ಖಾತಾ ವರ್ಗಾವಣೆ ಹಾಗೂ ಮನೆ ನಿರ್ಮಾಣಕ್ಕೆ ಲಕ್ಷ್ಯ ಮಂಜೂರಾತಿ ಸಂಬಂಧಿಸಿದಂತೆ ಸೂಕ್ತ ಆದೇಶ ನೀಡಬೇಕೆಂದು ಸುಮಾರು 111 ನಿವೇಶನಗಳ ಮಾಲೀಕರು ವಿಳಾಸ ಮತ್ತು ಸಹಿ ಇರುವ ಪಟ್ಟಿಯನ್ನು ಲಗತ್ತಿಸಿ ಮನವಿ ಕೋರಿದ್ದಾರೆ. ತಮ್ಮ ಮನವಿಯಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ನಾಗದೇವನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 7 ಮತ್ತು ಇತರ ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಒಟ್ಟು 29 ಎಕರೆ 19 ಗುಂಟೆ ಪ್ರದೇಶಕ್ಕೆ ಅನುಮೋದನೆ ಕೋರಿ ಸಂಘದಿಂದ ಸಲ್ಲಿಸಿರುವ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪ್ರಾಧಿಕಾರ ಸಭೆ ಮಂಡಿಸಲಾಗಿದ್ದು, ಪ್ರಾಧಿಕಾರ ಸಭೆಯ ವಿಷಯ ಸಂಖ್ಯೆ ಡೇಟ್ 31/10/92 ನಿರ್ಣಯದಂತೆ ತಿಳಿಸಿರುವ ಷರತ್ತುಗಳನ್ನು ಪಾಲಿಸದೇ ಇರುವುದರಿಂದ ಬಡಾವಣೆ ನಕ್ಷೆಯನ್ನು ಅನುಮೋದಿಸಿ ಕಾರ್ಯಾದೇಶ ನೀಡಿರುವುದಿಲ್ಲ. ಆದುದರಿಂದ ಇದೊಂದು ಅನಧಿಕೃತ ಬಡಾವಣೆಯಾಗಿರುತ್ತದೆ. ಹೀಗಾಗಿ ಅನಧಿಕೃತ ನಿರ್ಮಾಣವಾಗಿರುವ ಬಡಾವಣೆಯನ್ನು ಅನುಮೋದಿಸಲು ಪ್ರಸ್ತುತ ಕಾಯ್ದೆಗಳಲ್ಲಿ ವಲಯ ನಿಯಮಾವಳಿಗಳಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ತಮ್ಮ ಮನವಿಯನ್ನು ಪರಿಗಣಿಸಲು ಅವಕಾಶವಿಲ್ಲ ಎಂದು
No, if all of you decide to put your heads together, 595 ಜನ ಇದ್ದೀರ, ಒಬ್ಬೊಬ್ರು 10,000 ಕೊಡಕ್ಕಾಗಲ್ವಾ?
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, society is not in existence, my lord. The office bearers have not taken any
Forget
interest.
the society. All of you are allottees. 595 ಜನ ಇದ್ದೀರಾ, ಒಬ್ಬೊಬ್ರಿಗೆ 10,000 ಕೊಟ್ರೆ 57 ಲಕ್ಷ ಆಯ್ತು. You pay this money, we'll direct the BDA to approve the plan. Direct the BDA to approve the plan so that you can go ahead with your whatever work that is required.
As against the share of the petitioners, my lord, we are ready to give, my lord.
Thank you.
Sorry, my lord.
ಏನ್ ಮಾಡೋದು? You bring all your friends together. If you are willing to pay this 57 lakhs, I can direct them to sanction the plan. Plan sanction ಮಾಡಿ ಏನು ಬಿಲ್ಡಿಂಗ್ ಲೈಸೆನ್ಸ್, ಬಿಲ್ಡಿಂಗ್ ಪ್ಲಾನ್ ಅಪ್ರೂವ್ ಮಾಡಬೇಕು ಅದೆಲ್ಲ ಮಾಡಿಸುವ. ನಿಮ್ದು ಲೇಔಟ್ ರೆಗ್ಯುಲರೈಸ್ ಆಗುತ್ತೆ. Why don't you hold a meeting of all the site owners?
We'll take instructions, sir.
10,000 ರೂಪಾಯಿ ಒಬ್ಬರು ಕೊಟ್ರೆ you can buy peace, no? Is it not wise?
Take instructions.
Yeah.
That would be more reasonable than 2%. Your Lordship's suggestion, my lord, would be more reasonable than 2% of what they have to pay. my lord.
ಹೌದು 2% anyway they have to
Guidance,
give.
please.
Because ಈ ಖಾತಾ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ they have to give, I don't know whether it is from B to A, it is 2%.
It is 2%, my lord.
Otherwise it is not.
It is normal.
But 10,000 ರೂಪಾಯಿಗೆ if you can buy peace, why not buy it?
Yes, madam. We'll
ಅಲ್ವಾ?
take this- Yes, madam.
Postpone buying one pair of shoes for 1 year. It will become 10,000.
Take instructions, madam.
ಯಾವತ್ತಿರ್ಲಿ?
Any day.
The Learned Counsel for the petitioner seeks time to secure instructions whether all the 595 site allottees would put their heads together to pay up a sum of rupees 57 lakhs and odd to the Bangalore Development Authority for an ex post fact sanction of the layout plan. So hence list on ಯಾವತ್ತು?
Any date, madam, any date.
ನಿಮ್ಗೆ ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ, ಮೀಟಿಂಗ್ ಯಾವತ್ತು ಮಾಡ್ತೀರಾ?
20th of this.
20th.
Yes.
28th,
20th, 20ನೇ ತಾರೀಕು.
20ನೇ ತಾರೀಕು. 20th. List on 20th.
Yes.
Right, the Learned Counsel for the respondent number 5 to 7 has filed a memo and enclosed therewith a resolution dated 5/8/2026. The same is taken on record.
Please. Grateful.
43, Govind Raju K.
Govind Raju.
Petitioner in this case, madam. In this case, I have filed a mandam was seeking direction to consider the representation.
What consider? What have you sought in the representation?
Yes, my lord, that one site was allotted to me. Lease cum sale agreement was entered, my lord. The adjacent site, similar relief was passed by this coordinate bench, my lord.
First ನೀವು representation ಏನ್ ಹೇಳಿದ್ರಿ?
Adjacent site ಆಗಿದೆ ಇದೆ, same owner ಮೇಲೆನೆ.
ಅಪ್ಪ representation ಏನ್ ಹೇಳಿದ್ಯಾ ಅಂತ ಹೇಳಪ್ಪ ಮೊದಲು.
That, my lord, I given the representation to that site number 1749 and 1750 was.
ನಿಮ್ಗೆ ಏನ್ ಕಾಯಿಲೆ ಬಂದಿದೆ ಫಸ್ಟ್ ನೀವ್ ಹೇಳ್ಬೇಕಲ್ವಾ? ಪಕ್ಕದ ಮರ ಇಂಜೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರೆ ನನಗೂ ಇಂಜೆಕ್ಷನ್ ಕೊಡಿ ಅಂದ್ರೆ?
ಇಲ್ಲ, ಎರಡೂನು ಕ್ಲಬ್.
ಫಸ್ಟ್ ನಿಮ್ ಕಾಯಿಲೆ ಹೇಳಿ ಏನು ಅಂತ.
76 lease cum sale agreement was entered between the parties, my lord. Subsequently, that sale was not registered. I am the purchaser of the earlier, after 10 years also, that was not granted in my favor, my lord.
Yes. He is a purchaser from an allottee, so he wants a sale deed in his name.
Yes, please. There is some fine that we will impose and then execute the sale.
But if he has sold it after the time prescribed.
Time prescribed adrunu, my lords, without the allottee, original allottee getting a sale deed registered in his name, he should not have sold it, but a sale ಮಾಡಬಹುದು. My lordship has passed an order, my lords, where if I'm not wrong, my lords, 10% of the value would be taken.
ಎಲ್ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಹಂಗಿದ್ಯಾ?
Yes, also.
ಎಲ್ಲಿದೆ? Then you consider and pass appropriate orders.
This is the order passed in 1750 dalli, that one.
The petitioner sought for the nature of mandamus to direct the respondent number 2 to consider his representation dated 3/4/2018 and execute a deed of conveyance transferring the property and register the khata in his name. Petitioner claims that the respondent number 2 had allotted a site bearing number 1749 to Mr.
K. Manjunath, sorry.
To Mr. Vedanta Char on 9/12/1975. Full stop. The said Mr. Vedanta Char had deposited the allotment price, consequent to which a lease cum sale agreement dated 4/5/1976 was executed in favor of Mr. Vedanta Char. Full stop. Thereafter, he was placed in possession of the allotted site. Full stop. A possession certificate was also issued on 4/9/1976. Full stop. Petitioner contends that as per the conditions mentioned in the possession certificate, Mr. Vedanta Char was prohibited from alienating the site for a period of 10 years. However, due to personal necessities, after the expiry of 10 years, Mr. Vedanta Char sold the aforesaid site to the petitioner on 10/1/2018. Full stop. Petitioner contends that he gave a representation to the respondent number 2 to transfer site number 1749 in his name and execute a deed of conveyance in his name. Full stop. The respondent number 2 addressed a letter to the revenue inspector directing him to inspect the property inspect the site number 1749 and certify the signature and the photograph of the purchaser from Mr. Vedanta Char. Accordingly, the respondent number 4 visited the spot and visited the house of the petitioner and drew up a maser and verified the signature of the petitioner, which was forwarded to the respondent number 2. Full stop. Petitioner contends that in spite of the report, the respondent number 2 has not taken any action. The petitioner is therefore before this court, seeking for a direction to the respondent to consider his representation dated 3/4/2018 and execute a deed of conveyance conveying the site bearing number 1749 to the petitioner. Stop. The learned counsel for the respondent submits that the vendor of the petitioner had not obtained a sale deed in his name, but had encumbered the same to the petitioner. He contends that under Rule 14 of the BD Allotment of Site Rules 1984, the purchaser is bound to pay, is it 10%?
12%.
12% of the
Per annum on the allotted value of the site.
12% of the 12% of the allotment price.
Per annum.
Per annum. Per annum andre?
Every year on the allotted value. That's a 14 subclass 3B manner.
What do you mean by per annum andre? Per annum is
calculated at 12% per annum on the allotted value of the site. 14 subclass 3 mallards, notwithstanding anything contained in these rules.
Require him to surrender site whereupon no building is constructed.
Sell the site or the site with the building constructed thereupon. The authority may, with the previous approval of the government, either where the building is constructed on the site so allotted, the authority shall permit him to sell the building, provided the lessee shall pay to the authority an amount calculated at 12% per annum on the allotted value of the site.
So this is the authority after such surrender. Where the building is surrendered, the authority shall permit him to sell the building, provided pays to the authority an amount calculated 12% per annum on the allotted value of the site. Per annum for how many years?
From the date after the expiry of the 10 years is what I understand.
Then
the expiry of 10 years.
Provide that when an allottee intends to sell a site, allotted site with a building,
Allot, sir.
Without the approval.
There is an amendment which says, I'll just read out, my lords, on 34/2005, my lord, there is an amendment, my lord. Provided that where a lessee has alienated the site in contravention of the provisions of sub-rule 2 prior to 31/12/2022, the authority may, on an application of the purchaser of the site and subject to the payment of the purchaser of an amount equal to 25% of the guidance value prevalent at the
Anyway,
time of the last sale transaction.
this is before 22.
Also,
Yes. So therefore, this rule will apply. That is before 20.
Alienated.
The sale ಆಗಿರೋದು the 2018 ಅಲ್ಲ.
2018.
18 level. So it is prior to 2022, my lords.
ಏನಾಯ್ತು?
If I may pass on that.
ಅಲ್ಲ ಅದು ಬೇಕಾಗಿಲ್ಲ. It is before 2022.
Also, this particular sale is also prior to 2022.
ಓದಿ ಯಾವಾಗ ಬಂದಿದೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಯಾವಾಗ?
30/4/2005, my lords.
Amendment is
Bylaw shall be
2005.
deemed to have been inserted with effect from 30/4/2005.
ಅದು ಹೆಂಗಾಗುತ್ತೆ? How is it possible from? What is the significance of that retrospective effect? ಏನಕ್ಕೆ ಹಂಗ್ ಮಾಡಿದ್ದಾರೆ?
There's a ಚೀಟಿ, right side ಚೀಟಿ.
ಇದು sub-rule 2ಗೆ. In sub-rule 2, the following proviso shall be deemed. If the site is in the lease period within the lease period ಆದ್ರೆ ಇದು lease period ಆಗೋಗಿದೆಯಲ್ಲ. So rule 2 will not apply.
Rule 3. ಅದರಲ್ಲಿ 12% per annum of the settle value.
ಆಯ್ತು.
Post the expiry.
Rule 14, sub-rule 3B of the BDA allotment of site rules 1985-4 mandate that when an allottee sells the site with the building without obtaining the approval of the BDA and without obtaining a deed of absolute sale, then if the allottee pays to the authority an amount calculated 12% per annum on the allotted value of the site, the same can be regularized by executing deeds of conveyance in favor of the purchaser. He therefore contends that the case of the petition would be considered in the light of the above rule. Full stop. Next para. In view of the fact that the petitioner has purchased the site long after the period prescribed under when the possession certificate had expired, the petitioner is entitled for a deed of conveyance from the respondent number 2. In that way of the matter, this petition is disposed of, directing the respondent number 2 to consider the representation of the petitioner in the light of Rule 14, Sub-Rule 3, bracket B of the BDA allotment of site rules 1984 and pass appropriate orders within a period of 6 weeks from the date of receipt of a copy of this order.
Let's.
Next case.
My lord, in this case, my lord, I seek direction to respond number 3, execute a supplementary deed and change the Kanta.
Govindraj, please come to your previous petition. Please. The first para ಏನು ಹೇಳಿದ್ರು, second para ಏನು? ಇದೆಲ್ಲ ಬೇಕಾ? ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಬರ್ದಿದ್ರಲ್ಲ ಬೇಕಾ? ಥರ್ಡ್ ಪ್ಯಾರಾ ಏನಿದೆ? ಬಾಡಿ ಕಾರ್ಪೊರೇಟಿವ್, ಪರ್ಪಿಚುವಲ್ ಸಕ್ಸೆಷನ್, ಸೀಲು, ಪವರ್, ಇದೆಲ್ಲ ಬೇಕಾ ಪ್ಲೀಡಿಂಗ್ ಅಲ್ಲಿ? ಅಲ್ಲ ಬೇಕಾ ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ಬೇಕಾ? BDA has been authorized to form a layout to allot the same for needy at an affordable price, apart from permitting the private colonizers to form a layout. ಬೇಕಾ ಇದೆಲ್ಲ? Why this unnecessary pleading? Why this unnecessary pleading, mister? Stop this unnecessary pleading. Just because you know something, please don't put it into the pleadings. ಒಂದು ಪುಸ್ತಕ ಬರೀರಿ, BDA ಆಕ್ಟ್ ಮೇಲೆ ಒಂದು ಪುಸ್ತಕ ಬರೀರಿ, ನಾವೆಲ್ಲ ತಕೊಂಡು ಓದ್ತೀವಿ. ರೀಡಿಂಗ್ ಅಲ್ಲೆಲ್ಲ ಅನವಶ್ಯಕತೆ ದಯವಿಟ್ಟು ಹಾಕಬೇಡಿ. ಪ್ಲೀಸ್ ಟ್ರೈ ಟು ಬಿ ಆಸ್ ಕ್ರಿಸ್ಪ್ ಆಸ್ ಪಾಸಿಬಲ್. ಎಷ್ಟು ಕಡಿಮೆ ಹೇಳ್ತೀರೋ ಅಷ್ಟು ಒಳ್ಳೇದು. ಅವಶ್ಯಕತೆ ಇಲ್ದಿರೋದೆಲ್ಲ ಹೇಳ್ಬೇಡಿ. ನ್ಯೂಸ್ ರೀಲು, ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್, ಫಸ್ಟ್ ಪಿಕ್ಚರ್ ತೋರಿಸ್ಬಿಡಿ. ಸ್ಟಾಪ್ ದಿಸ್ ಪ್ಲೀಸ್.
Number 44. Going Raju.
In this petition, my lord.
For in this matter, I request for a pass over, my lord.
My lord, in this case, my lord, I have already initiated a civil suit, my lord.
ಏನ್ ಸೂಟಿ?
ಇದು ಡೈರೆಕ್ಷನ್ ಸೀಕಿಂಗ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಸೊಸೈಟಿ ಸಪ್ಲಿಮೆಂಟರಿ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಡಿ ಅಂತ ನಾನು ಕೇಳಿದ್ದೆ ಸ್ವಾಮಿ. ಆಸ್ ದಿ ಸೇಮ್ ಖಾತಾ ವಾಸ್ ಚೇಂಜ್ ಟು ಚೇಂಜ್ ದಿ ಖಾತಾ ಇನ್ ಮೈ ಫೇವರ್, ಮೈ ಲಾರ್ಡ್. ದಟ್ ನೌ ಐ ಸಾಟ್ ಎ ರಿಲೀಫ್ ಇನ್ OS ಸೂಟ್ ಫೈಲ್ಡ್, ಮೈ ಲಾರ್ಡ್. ದಿಸ್ ಅಲ್ಲಿ ಇದು ಡಿಸೈಡ್ ಆಗಬೇಕು ಬಿಕಾಸ್ yes, my lord, that's the reason. With liberty to take contention in that.
The petitioner has filed a memo to withdraw this petition and seeks liberty to urge all contentions raised in this petition in OS number
4068 of
4068 of
24,
24 pending before
additional civil judge CH-5.
Serial number 46, my lord, I requested for 2 weeks.
46
Please, ma'am.
ಯಾಕೆ ವಚನ್?
To receive instructions in that matter.
Respond to until 6 time. List on so and so.
Serial number
47 is covered by judgment, my lord.
45, my lord. 2 weeks time we granted to file the objection. But there is 1964.
45.
I for the
petitioner.
Learn counsel for the respond number 2 seeks time.
My lord, already several times your lordship time is
So
taken.
what?
3 to 4 times. we have
1964
taken already.
acquisition, my lord. Now after 50 years after they
ನೋಡ್ದಾ ನೀವು 50 ವರ್ಷ ಆದ್ಮೇಲೆ ಬಂದಿದ್ದೀರಾ?
No, my lord, it is not.
ಹೇಳ್ತಿದ್ದಾರೆ.
There is a correspondence by the BDA only.
Correct. He says that you come after 50 years and you are hurrying.
No, it's not.
Learn counsel for the respond number 2 seeks time. List on so and so.
20th August. My lord, serial number 47 is covered by judgment.
ಏನ್ ಮಾಡೋದು? ಊಟ ಮಾಡೋದು ಬೇಡವಾ?
Past door matter, serial number 6. Rajaram S. Serial number 6, Rajaram. Serial number 6, past door matters, Rajaram S.
There is no representation for the petitioner. It could be land acquisition act. Could
Kindly the liberty to withdraw, my lord.
Don't counsel
Kindly
for this.
liberty to file a fresh
So you said there's some judgment.
Yes, my lord, but there is ಅದು LAC miscellaneous ಚಾಲೆಂಜ್ ಮಾಡಿ ಮೇಡಮ್ MFA ಹಾಕಿದ್ವಿ ಅದನ್ನು ವಿಡ್ರಾ ಪಿಟಿಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿತ್ತು ಮೇಡಮ್.
So you said there's some judgment.
Yes, madam.
Where the court has said writ petition, the MFA is not maintainable.
Yes, madam. That's MFA.
Huh?
It says that they withdraw the liberty to file a writ petition.
But this is your submission.
Yes, madam.
You said that the High Court has passed an order saying that MFA is not maintainable. Please come to section 54, Land Acquisition Act. Could you copy code?
ಒಂದೇ ಇರೋದು
54 to ಓದಿ ಕೊಡಿ. Read section 54 subclause 2.
54. Appeal is proceeding before the court, my lord. Form any decree of the court other than the High Court passed on an appeal under subsection 1, subsection clause 1. An appeal shall be laid to High Court if by only if the amount of value of subject matter in dispute in appeal exceed 2,000 rupees or the case of involved in any question of title to land.
So therefore amount exceeds 2,000.
Yes, madam.
But appeal ಬರ್ತದಲ್ಲ High Court ಗೆ.
Yes, madam. MSA.
MSA ಅಲ್ಲ. It is MFA only. Who said it is MSA?
SO ಹೇಳಿದ್ರು ಮೇಡಮ್ ಕೇಸ್ ಕೇಳಿ ಬಂದು LAC appeal dismiss ಆಗಿದೆ ಮೇಡಮ್.
The appeal dismiss ಆಯ್ತು 54(1) ನಲ್ಲಿ there is an appeal to the district court.
Yes, madam.
54(2) ನಲ್ಲಿ there is an appeal to the High Court.
Yes, madam.
SO ಹೇಳಿದ್ರು ಅಂತ SO ಮಾತು ಕೇಳ್ಕೊಂಬಂದು ಹೇಳ್ತಿದ್ರು as if it is some precedent. ಹೇಳ್ರಿ ಯಾರಾದ್ರು.
No, madam. Because the question arises on maintainability, so that there is.
So whatever it is,
yes, madam.
you're challenging an order passed by the district court under 54(1).
Yes, madam.
So 54(2) appeal lies to the High Court only.
Yes, madam.
If the subject matter is more than 2,000. ಏನ್ ಯೋಚನೆ ಮಾಡೋದಿಲ್ಲ ಸುಮ್ಮನೆ ನೀವು ಓದ್ರಲ್ಲಿ ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟ್ ಇದೆ ಓದಿಲ್ಲಿ ಓದಿದ್ರ ಮತ್ತೆ who told you it is MSA?
Because there is an appeal is dismissed, so that
Correct.
LIC appeal is
Appeal before the district court, the first appeal.
Yes, my lord.
Before the high court, it is not second appeal. It is first appeal only. Again, it's an appeal.
The valuation is exceed, my lord, so that.
Valuation 2,000 exceed ಆದ್ರೆ high court ಬರುತ್ತೆ ಅಂತ ಇರೋದು ಅದು.
Yes, my lord.
ಮತ್ತೆ you want to withdraw it?
Yes, my lord.
When counsel for the petitioner seeks liberty to withdraw this petition.
Liberty to file a fresh appeal, my lord.
Stop. The file a memo.
Yes, my lord.
Yes, file a memo. Full stop. In that regard, in view of the memo, the petition is dismissed as withdrawn. If the petitioner has any other remedy, he may avail the same in accordance with law.
Kindly, my lord.
Yes.
There is some certified copy as annexed in this file.
Office is directed to return the certified copies of the impugned judgment and award passed by the reference court as well as the appellate court after retaining photocopies.
Achha.
ನೋಡಿಲ್ಲ ನಾಳೆ ಯಾವುದು ಇದೆಯಾ ನಾಳೆ ಯಾವುದಿಲ್ವಾ ನಾಳೆ ಯಾಕೆ
Serial number 39. Serial number 39.
Yeah.
Now secured the copy of the seal deed.
ಮೆಮೋ ಕುಡಿತೀಮಯ್ಯ ಇದೇನಿದು A memo is filed by the learned counsel for the petitioner, along with which he has enclosed a copy of the sale deed dated 10/4/2006, executed in favor of the wife of the petitioner in respect of a site bearing number 9 in survey number 166/5 of Kodigeli village, Yelahanka Hubli, Bangalore North Taluk. The same is taken on record. Memo Kudi. The petitioner has called in question an endorsement bearing number so-and-so dated so-and-so issued by the respondent number 2. He has also sought for a direction to the respondent number 2 to execute his lease cum sale deed, sale agreement. Annexure yes ಏನಿದು? What is annexure yes? ಇದ್ಯಾರು ಜೈಕುಮಾರ್ ಅಂದ್ರೆ ಯಾರಿದು?
Is the petitioner. Annexure S is the copy of the lease cum sale deed, draft lease cum sale deed.
Is a draft, is it?
Draft it was given.
Lease cum sale agreement in respect of site number B9 SA 186. Full stop. Petitioner contends that he had filed an application ಯಾವ ಲೇಔಟ್ ಇದು?
ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ.
It contends that the respondent number 1 had invited applications for allotment of sites in Nadaprabhu Kempegowda layout. The petitioner filed an application seeking allotment of sites, allotment of a site measuring 9 into 12 meters under the scheduled caste category, na?
Category 1. Category 1, my lord.
SC/ST category 1 ಅಂತ ಹಾಕಿದ್ದೀರಾ?
ಅದನ್ನ SC/ST category 1 ಅಲ್ಲ ಅದು. ಸ್ಪೆಸಿಫೈ ಮಾಡಿರೋದೇ category 1 ಅಂತ ಹೇಳಿ.
No, but do you belong to scheduled caste?
Scheduled caste.
To the scheduled caste category 1. Full stop. Petitioner contends that his wife had also filed an application seeking, petitioner contends that his wife had earlier filed an application seeking allotment of site in the year 2004 under the scheduled caste category, and she was assigned with the registration number SC/ST 182043 for a bigger dimension of site measuring 15 meters into 24 meters. Full stop. The petitioner claims that while submitting the application for allotment of a site, the petitioner was under the bona fide impression that the application filed by his wife would also be considered for the benefit of the number of attempts made, and accordingly, in column number 21 of the application, he had referred to his wife's application number, wife's registration number 182043 as his first attempt. Full stop. The respondent number 2, after verification of the particulars mentioned in the application, allotted a site bearing number BDA/DS2. Allotted a site bearing number B9SA186, measuring 9 into 12 meters in terms of a letter of allotment bearing number so-and-so dated 14/11/2018. Full stop. The petitioner paid the balance amount of rupees 22,09,152 as demanded by the respondent number 2. Full stop. Petitioner claims that the respondent number 2 had held out that a lease agreement would be executed and possession of the site would be handed over on completion of all formalities, and also indicated that the respondent number 1 has no objection for the petitioner to mortgage the allotted site in favor of a nationalized bank for the purpose of raising a loan to meet the cost of the site. Next para. He contends that as per the directions of the respondent number 2, he produced all documents including his caste certificate issued by the competent authority and furnished his specimen signature and photographs. Full stop. He contends that he also remitted a sum of rupees. He contends that after paying the entire allotment price, the respondent number 1 addressed a letter dated 21/9/2021 calling upon the petitioner to pay difference amount of rupees 22, which was also paid by him on 12/10/2021. Full stop. Petitioner contends that a draft comes lease sale agreement was also forwarded to the petitioner as per its letter dated 22/10/2021. He contends that 22 22/10/21, and the petitioner was required to be present at the office of the sub-registrar on 22/10/2021. Full stop. The petitioner claims that he was present at the office of the sub-registrar, but the respondent, instead of executing the lease cum sale agreement, postponed it on the pretext that the respondent number 2 had to obtain opinion from the legal team as to whether the site should be allotted to the petitioner or not. Petitioner claims that from that day onwards, there was no response from the respondents. Full stop. He then requested the respondents by letter dated 23/11/2021 to execute a lease cum sale agreement. However, after continued persuasion, the respondent issued an endorsement dated 8/6/2023 stating that the petitioner is not eligible for allotment of the site on the ground that as per the notification, the allotment of site for scheduled caste category 1 should be for only those persons who had made 2 attempts. That the petitioner had wrongly quoted the attempt made by his wife as the first attempt. So the petitioner, being agreed by the said endorsement, is before this court. Next, the learned counsel for the petitioner contends that the wife of the petitioner had also filed an application seeking allotment of site in the year 2004. However, since she had purchased a revenue site, however, since she purchased a revenue site in the year 2006, she was advised not to pursue her application and not to pursue her application for allotment of a site, as she already owned a site. Full stop. He contends that it was under that misconception that the petitioner, that the wife of the petitioner did not file application for allotment of a site again when notifications were issued by the respondent number 1 inviting applications for allotment of sites in Nadaprabhu Kempegowda layout. In support of this contention, he has placed on record a copy of the sale deed dated 10/4/2006 executed in favor of the wife of the petitioner. Full stop. He contends that the petitioner was thereafter informed that there was no embargo for the wife of the petitioner to file an application seeking allotment of a site, even if she had purchased a revenue site. Full stop. He contends that since the allotment was for the family, the petitioner felt it appropriate to mention the first attempt made by his wife in the application filed by him. Full stop. He contends that the respondent number 2, respondents, after having received the entire allotment price and after allotment price have now turned around to claim that the petitioner is not entitled for allotment of a site unless he made 2 attempts. Full stop. He contends that this was a bona fide mistake on the part of the petitioner and his family, and therefore the same may be condoned, and the attempt made by the wife of the petitioner may also be treated as an attempt made by and that the attempt made by the petitioner's wife may be treated as an attempt made by the petitioner, as the allotment of the site is made to a family which includes the spouse of the petitioner, full stop. He therefore contends that the impugned endorsement be quashed and a direction be issued to the respondents to convey to execute a lease cum sale agreement and also issue a possession certificate and also do the required to ensure conveyance of the property to the petitioner. The writ petition is opposed by the respondents. Statement really, Vachan? Who has filed a statement of objections inter alia contending that the petitioner had sought for allotment of a site vide his application dated 6/2/2018 for a site measuring 9 into 12 meters under the scheduled caste category. In the application, he had stated at serial number 21 regarding the previous attempts made that he had made an earlier attempt on 26/5/2004 with registration number 019385. While application number 182043 for a 15 into 24 meters dimension site. Based on the information provided in the application, the respondents felt that the petitioner's application was the second attempt seeking allotment of a site, and therefore a site bearing number B9SA 186 was allotted to the petitioner with a letter of allotment dated 14/11/2018. It is contended that after the allotment, the BDA was required to execute a lease cum sale agreement as per the BDA allotment of sites rules 1984. At that juncture, when the application filed by the petitioner was scrutinized, it was seen that the petitioner had furnished false/incorrect information at serial number 21 of the application by stating that he had made an earlier attempt for allotment of a site. It was then found out that the previous attempt made by the petitioner was not by him but was by his wife. It is contended that the cutoff for allotment of a site to a person belonging to the scheduled caste is 2 attempts, and therefore the representation of the petitioner seeking lease cum sale agreement, and therefore the request of the petitioner seeking lease cum sale agreement was liable to be rejected. Accordingly, the respondent number 2 issued the impugned endorsement dated 8/6/2023 rejecting the request of the petitioner seeking registration of a lease cum sale agreement. It is contended that since the petitioner had given false and incorrect information in the application form, in view of Rule 1310 of the BDA allotment of site rules 1984, the amount deposited by the petitioner is liable to be forfeited. Full stop. Next para. It is contended that the petitioner had himself admitted in his letter dated 25/11/2022 addressed to the respondent number 1 that he had that the information furnished in the application at serial number application for allotment of site at serial number 21 was with regard to an attempt made earlier by his wife and not by him. Full stop. It is therefore contended that there is no provision in the BDA allotment of site rules 1984 which enables counting the attempt made by a family member for allotment of site in favor of another family member. Furthermore, it is further contended that the attempt made by the wife of the petitioner was in respect of a bigger site, while the petitioner had sought for allotment of a site measuring 9 into 12 meters. 12 meters. And on this count too, the petitioner was not eligible for allotment. Full stop. It is therefore claimed that the endorsement issued by the respondent number 2 is justified and is in line with the BD allotment of site rules 1984. The learned counsel for the respondent number 1 and 2 vociferously contended that the petitioner had deliberately given a false statement that he had made an earlier attempt for allotment of a site, which was only to gain priority, only to gain the eligibility criteria fixed by the respondent number 1 for allotment of sites to persons belonging to scheduled caste. He contends that the petitioner is an educated person and therefore he could not have misrepresented to the respondent number 1 that he had made an earlier attempt, while what was done was not by him but by his wife. Stop. He therefore contends that no indulgence can be shown to the petitioner as that would be ignoring a patent illegality committed by the petitioner. Full stop. He contends that if this mistake is condoned, this would open an avenue for people to exploit, and therefore prays that the impugned endorsement be upheld. Full stop. However, as regards the refund of the allotment price deposited by the petitioner, he submitted that the rules provide that the respondent number 1 is entitled to forfeit the amount deposited, and therefore prays that no order be passed to refund the allotment price deposited by the petitioner. Next, I have considered submissions made by the learned counsel for the petitioner and the learned counsel for the respondents. Next para. Under the BD allotment of site rules 1984, what is the
Rule 10.
Rule 10. Under the BD allotment, no person who has any dependent member of no person who or any dependent member of whose no person who or any dependent member of whose family owns a site or a house has been allotted by the, allotted a site or a house by the BDA or a cooperative society or any such other authority within the metropolitan area of Bangalore, or has been allotted a site or a house in any part in the state by any other urban development authority, he is eligible to apply for an allotment of a site. Full stop. Therefore, a reading of the above rule, would make it apparent that between members of a family, only one person will be eligible for allotment of a site from the Bangalore Development Authority. Full stop. In the case on hand, the wife of the petitioner as well as the petitioner had applied for allotment of a site. Full stop. The wife of the petitioner could have conveniently applied for allotment of a site when the respondent number 1 invited applications for allotment of a site in Nadaprabhu Kempegowda layout. However, since she had already purchased a revenue site, she chose not to file an application. Unmindful of the full stop, she was full stop. She perhaps was misguided in assuming that she was perhaps misguided in not filing an application on the ground that she already owned a site within the limits of the metropolitan area, and therefore she was not eligible. Full stop. A coordinate bench of this court, while considering the very same question in Pankaja Prabhudev versus BDA 2012 Part 1 KLG 241, had categorically held that owning a site within the limits of the metropolitan area is not an ineligibility to seek allotment of a site from the authority. Full stop. Therefore, the attempt made by the wife of the petitioner should inure to the benefit of the family of the petitioner. Full stop. Ideally, the application seeking allotment of a site must have been filed by the wife of the petitioner. However, the petitioner has filed the application seeking allotment of a smaller site than what was sought by his wife, and the same is allotted to the petitioner. Full stop. There can be no quarrel that the petitioner has given a wrong information in the application filed by claiming that the earlier attempt made, by claiming that the mentioning of the earlier attempt made in the application was not by him but was by his wife. Full stop. However, having regard to the purpose of the BDA allotment of site rules 1984, which is to provide a site to a person who does not own a site allotted by the Bangalore Development Authority or any cooperative society or any urban development authority, the respondents ought to have condoned this mistake. Full stop. In view of the above, the impugned endorsement deserves to be set at naught. However, subject to a caveat that the petitioner and his wife shall not be entitled for making any further application seeking allotment of a site from the Bangalore Development Authority or from any cooperative society or any urban development authority or the housing board or such other agency of the state government. Full stop. This would also ensure that this would also dispose of two applications filed by the petitioner and his wife. Full stop. In view of the above, this petition is allowed. The impugned endorsement bearing number so and so dated so and so is quashed. The respondent number 1 and 2 are directed to take steps to execute a lease cum sale agreement.
I'm so sorry, may I submit? But the number of attempts will have to be taken into account. We will do it, my lord. But in terms of seniority, the age also has to be looked into. The age of madam will have to be seen if she's entitled under that age also. There are two eligibility under Rule 11, my lord. The number of attempts first. If the number of attempts are the same, then it is the age. The age also is the same. Then we see if one of them is a land loser in the acquisition. We see it, my lord. That's how the applications are vetted. Now, my lords, will have to again revet the application. Lordship may kindly set out not my endorsement. Then direct me to reconsider it in light of. Now, your lordships will have to direct.
Husband is more than the wife.
As my lord would direct us in the unique facts of this case. Lordship would direct us to reconsider the application in light of the.
ತಿರ್ಗಾ reconsider
ಅಲ್ಲ,
ನಿಮ್ಮ
ಮತ್ತೆ
office
ಏಜ್
ಎಲ್ಲ
ಏಜ್
ಬರ್ತಾರೆ.
ಮತ್ತೆ ಲೆಕ್ಕ ಬರುತ್ತೆ.
ಏನಾಯ್ತು?
ಅಲ್ಲ ಏಜ್ ನಾವು ನೋಡ್ಬಿಟ್ಟು
not
ಇಫ್ ದಿ
necessary.
ಏಜ್ ಸ್ಟಾಪ್ಸ್ ಮೈ ಸಬ್ಮಿಟ್.
Let the RDL end to this couple. ಮುಗಿಸ್ರಿ ಸಾರ್.
ನಾನು ಏನ್
ತಿರ್ಗಾ
ಹೇಳ್ತಾ
ವಾಪಸ್ ನಿಮ್ಮ ಆಫೀಸ್
ಕೊಡೋದಕ್ಕೆ ಏನಿಲ್ಲ.
ಬಂದು
I bow down to what my lord has already said. I'm not saying anything on that. If there is the seniority stops at an age higher than the age of either of the parties, my lord, I do not know how my lord would direct me, either his age or madam's age. I do not know.
obviously he is older than his wife.
I leave it to my lord as my lord directs me. Age will have to be also looked into.
No. In favor of the petitioner, in respect of the site bearing number so and so, in Nada Prabhu Kempegowda layout, within a period of 3 months from the date of receipt of a copy of this order, it is made clear that the petitioner, his wife, shall not be entitled to seek allotment of any site from the BDA henceforth, and the application filed by the wife of the petitioner bearing number so and so stands disposed of. They also shall not make any application to any cooperative society or any urban development authority or the housing board or any agency of the state seeking allotment of a site. Yes.
Because if this site, my lord, has already been allotted to somebody else, another alternate site.
There is a stay, in fact, there is a stay granted with Sonamba court.
Huh?
The stay has been granted.
Stay is granted.
Stay is granted.
It is needless to mention that if the site in question is already allotted to somebody else, the respondents shall ensure that an alternate site is allotted and conveyed to the petitioner.
This shall not be a precedent.
This order is passed in the peculiar facts and circumstances of this case and shall not be treated as a precedent. Yes.
Grateful, madam.
Site is not allotted to anybody because virtue of the.
ಆಯ್ತು ಮಾಡಿದ್ರೆ
ಇಲ್ಲ
Number 47, Srinivas V.
Yes. Srinivas V.
Yes, Lord, petitioner, land have been acquired have been utilized for the formation of the outer ring road, which he was having revenue site he was having. Therefore, he made an application to the BDA. Annexure C is the application made by him. Lord, they have given an acknowledgement also. We are seeking an alternative sites in lieu of the site which have been used by them for formation of the road, Lord. Lord, this is the resolution which is at Annexure E. Lord, the petitioner was owning a site, Lord, which is the Annexure A is his sale deed, which is Komagatta Khata number 46, site bearing 266. Lord, this was utilized by the BDA for the formation of the ring road, outer ring road. Peripheral.
MAR road. MAR road.
MA.
ಯಾವುದು?
MAR road.
Major arterial road, part 2. And therefore, my lord, the petitioner, Lord, he made an application which is at Annexure C, seeking for an alternative site. My lord, Annexure C is the application, my lord. Now, my lord, that has not been considered in, therefore, he is before this honorable court, my lord. And resolution of the BDA.
VG Bopaya committee. The revenue
Good.
site holder, there is a subsequent purchase.
So he has to appear before the committee.
ಹೌದು ಅಲ್ಲ ಮಾಡಲಿಲ್ಲ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಪ್ಲಿಕೇಶನ್ ಕಮಿಟಿಗೆ
The petitioner sought for it in the nature of mandamus to consider, to direct the respondent to consider his application dated 6/5/2024 and allot an alternate site. Next para. Petitioner claims that he was the owner of a site bearing Khata number 46, property number 286, and and property number site bearing Khata number 46, property number 286, having e-Khata number 15020301900301899 and property number 1251/1398/46/286 measuring east to west 40 feet and north to south 60 feet, situated at Kommagatta village, Kengeri Hubli, Bengaluru South Taluk, having purchased it in terms of a sale deed dated 11/3/2019. He contends that Khata was made out in his name by the Sulikere Gram Panchayat and he has paid the up-to-date property tax. He contends that the said site was utilized by the respondent for formation of major arterial road part 2 without following the due process of law and without paying any compensation. Full stop. Petitioner therefore applied for allotment of a
Required for Nadaprabhu Kempegowda layout.
in a major arterial road ಅಂತಿದೆ.
ಒಂದು portion ಅಲ್ಲಿ ಹೋಗುತ್ತೆ. ಆ ಒಂದು portion ಅಲ್ಲಿ ಹೋಗುತ್ತೆ.
ಏನಾಯ್ತು?
In the site, major arterial road is one.
Applied for an alternative site. Full stop. The certificate was issued by the respondent purportedly acknowledging the acquisition of the site of the petitioner and also his entitlement for allotment of an alternate site. Petitioner claims that a resolution was passed by the respondent on 9/6/2017 on subject number 98/2015, where it was resolved that wherever lands are utilized for formation of road, an alternate site would be given to the land loser. Petitioner contends that even after several months, his request for allotment of an alternate site is not considered and therefore seeks for a direction to the respondents to consider his application and allot an alternate site. The learned counsel for the respondent submits that a committee is constituted by the respondent under the chairmanship of Sri V.G. Bopaya, retired district judge, to verify claims for allotment of alternate sites. Full stop. He submits that the request of the petitioner would be placed before the committee and appropriate directions would be obtained, and if the petitioner is entitled for allotment of an alternate site, steps would be taken to do so. In view of the aforesaid submission, the petition is disposed of, directing the respondent to place the request of the petitioner before the committee headed by Sri V.G. Bopaya, retired district judge, who shall take a decision after considering the representation of the petitioner. Full stop. The respondent shall act in compliance with the direction that may be issued by the committee, and this shall be done within a period of 6 months.
3 months. 3 months.
6 months.
ಅದೇ ಕಮಿಟಿ ಮುಂದೆ ತುಂಬಾ ಜನ ಇದಾರಂತಲ್ಲ, ತುಂಬಾ ಜನ ಇದಾರೆ. 6 months from the date of receipt of a copy of this order. Yes.
Much. Serial number 48, Naveed Ahmed.
Naveed Ahmed. Yes. Naveed.
Senior is in the
Huh?
on his leg millers.
Yappa?
Senior is on his leg at quote hole number 4 millers.
This is that matter where, Lord, for the land that has been acquired,
Lordships acquisitions, use without acquisitions.
that is used without acquisition, where, my Lord, we give them 50% or 55%. So there, my Lord, we have in fact given them what we had to give. The dispute is only with regard to a few extent of land. Now, your Lordships are aware, my Lord, we had also argued on the last occasion. Generally, if 40 guntas is taken, my Lord, in that 45%, my Lord, goes towards civic amenities, parks, infrastructure and all that. And 55% is what is left with BDA. So, my Lord, what we do is out of that 55%, my Lord, we give 50%.
Now, how much is acquired?
My Lord, 39 guntas.
39 guntas.
Yes, what we have given them, my Lord, is 9,000.
11,680 total.
11,680, my Lord, according to us. We have to
ಸರಿ,
give.
1 ಎಕರೆಗೆ ನೀವು ಪ್ಲಾನ್ ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ do you think you will ask for CA site? Suppose if he comes.
ಅಲ್ಲಲ್ಲ, ಈಗ ಏನಾಗಿದೆ, ಈಗ ನಾವೇ ಡೆವಲಪ್ ಮಾಡಿದ್ರು
ಬಿಡಿ, ನೀವು ಬೇಡ. Suppose if he wants to develop his land.
ಅದೇ that's what I'm saying. If we ourselves develop also, my Lord, 45% anyway has to be left. My Lord.
No, if it's a 1 acre, where's the question of 45%?
If he's developing it as a sites or whatever, if he's going to make.
Whatever it is, for 1 acre, there's no requirement of civic amenity. Yes, what is the area?
Under for section 17, when they make an application, Lords, it applies universally.
Correct. If it's 1 acre, where's the question of, there's a limit, KTCP Act list is nodi. Minimum is, I think, 2.5 acres.
Anyway, my lord, but here, my submission to your lordship says, so what has happened is, there, my lord, there was, my lord, where they relinquished it, where it was said that 40% of the developed land would be given. My lord, that may not be correct. It will be, my lord, 50% of 55%, my lord. That is what this honorable court, my lord, now has held. Earlier, my lord, what happened was BDA, my lord, in its usual magnanimity, started giving even 100%.
You have taken 39 guntas of his land. Suppose if he had developed, he would have had the entire 55%. Suppose if he had developed, he would have had the entire 55%. Maybe development cost, yes. Development cost, yes, he has to pay.
My lord, in fact, my lord, this has been considered by this honorable court, number of judgments, my lord. We have actually produced all those, my lord, compilation.
It's a matter of basic common sense. The land is not acquired. If the land is not acquired, the question of BDA benefiting from that would not arise. If the land is acquired, I can understand. If the land is not acquired,
acquired only here.
Utilized, not acquired. The land is utilized without acquisition.
That's why. That's why 50%. Others we are giving them 40%.
So therefore, whatever developed land which can be made out in 1 acre should be given to him. Whatever 1 acre of land will develop ಮಾಡಿದ್ರೆ ಎಷ್ಟು developed land ಸಿಗುತ್ತೋ
ಈಗ ನಮ್ದು ಆ 1 acre ನಾವು ಡೆವಲಪ್ ಮಾಡಿದಾಗ along with all others ನಮ್ದು 45% ಹೋಗ್ಬಿಡುತ್ತೆ.
ಹೌದು 45% you
ಅಲ್ಲ ನಮ್ಗೆ ಉಳಿಯೋದು 55%.
You are not getting it. Either you are not getting it or you are trying to be very intelligent.
Why will I, my lord? Why will
I'll tell you. I'll tell you.
Like,
this. No, I'll tell you. I'll tell you. Please wait.
My lord, your lordship may say that I'm, but your lordship may not say that I'm not trying to, my lord. This, my lord, we have come straightforward. We are telling your court, my lord, wherever it is, we tell that.
I have told this twice.
No, my lord, this has come up for the first time. Your lordships have not said this.
Now I just told you twice. See, if 1 acre of land belonging to a person is used up without acquisition.
Yes.
Suppose if he had filed an application for developing on his own, he would have been entitled to 55%.
That is the
yes. Let me complete.
Yes.
He would be entitled to 55%.
He would be entitled.
Correct.
Howdo.
Whatever 45% would go, that will be used for civic amenity, roads, so gates, so it will be given free to you. It will be given free to you. Correct. So he should be entitled for 55%.
My submission is, in fact, these arguments were placed by us, saying the calculation as to how much, my lord, they would have had to spend and how much they get. So there, my lord, then the honorable division bench has said. But yes, what your lordships are saying now, if it is regard to only 1 acre or something, my lord, that I have not examined. But rest all, my lord, in all the matters in this, where, my lord, in fact, my lord, as I was trying to say, BDA was even giving 100%, where 40 guntas of land is taken and 40 guntas developed land is...
See, that I can understand. Land for land need not be given.
Yes.
Because you are going to give developed land. I can understand that. But you can't say, out of developed land, I'll give 40%. Out of 55%, you can't say, I'll give you 40%.
50%.
50% agli.
If it is utilized, acquired and utilized, we give 40%. Even in Nadaprabhu, Kempegoda layout and all that, we have done that. And where for the formation of road or whatever we have acquired, we have been giving 50% of 55%. That has been what has been given.
How is it justified?
10% is higher, sir. My lord, this one, after a lot of all this calculation, then it has come, my lord, because now even that after that 45% he leaves, he has to, my lord, spend on all the approvals. He has to spend a lot of money. It is not that he gets.
Let that go out of that 45%.
Allah, it can't. It can't. Now, what happens is 45% he has to leave.
Yes.
45% is gone. Now, my lord, he gets 55% if he's developing on his own. Now, 55%, if he didn't have to spend a single amount for that 45%, then I understand, my lord, that 55%.
Town country planning. There is a minimum area.
But that I have not examined.
If it is less than 1 acre, he need not leave a civic community and other. I didn't mean to hurt you, Mr. Senior Counsel.
Beg your pardon?
I didn't mean to hurt you, but
No,
then
no.
I was just trying to tell you.
Yes. No, because my lord, this matter was heard by your lordships on a few occasions, the very same matter. This came up for the first time with regard to this particular thing about less than an acre. No, my lord, in fact, I'm also told my lord, in some of the judgments where even if it is 22 guntas has been taken, even there it has happened.
No, that is what? That is the mistake that we are committing.
Then that will have to be.
That is a mistake we are committing. See, if
It's taken by the government now.
that is a mistake we are committing.
Now, what has happened is, my lord, this decision is taken by the government also. My lord, what your lordship was saying, this particular aspect, my lord, I have not.
Needs to be challenged. 9/10/2018, there is a circular.
Lord, there is a circular on 9/2/2018.
Where they have fixed the.
My lord, where they have fixed this, my lord. And my lord, in number of judgments.
May I just make one submission? Ours is resolution number 50 minutes. 51. 50 ಅಲ್ಲಿ resolution ಅಲ್ಲಿ ಅವರು 25,000 square feet ಕೊಡ್ತೀನಿ ಅಂತ resolution pass ಮಾಡಿದ್ರು. They have approached this court. This court has directed them to give the land. Though they have complied it. Now the very next resolution is ours. And among which millers.
They are now faced with a government order.
This is
They are now faced with a government order which says only 40% or 50% should be given.
50% or 55%.
50% of 55%.
They are confronted with that.
In fact, my lord, we have already given them the land. It is not that we have not given them. Now the only dispute between us and them is about 5,100. We say that we have to still give them 2,485. They say we have to give them balance of 7,600.
This is on similar facts, my lord. And it has attained finality.
Negative equality, my lord. In fact, 100% was given. That was they sought.
Right, but this doesn't sound logical also. If he could have developed his land, suppose
Look, that is only if your lordships are saying that no civic community, no parks, nothing.
No, 1 acre of land, he gets it converted. He applies for a single unit plan. He applies for a single unit. He develops it. Where's the question of relinquishing a civic community park?
No, my lord, but here, my lord, why I'm saying that the honorable division bench looked into all aspects of this. Where, my lord, there in that matter, what happened was, as I said, 100%, 75%, 50% was to be given. They sought parity, but then, my lord, the honorable division bench said in these kind of cases there cannot be parity, negative equality or illegality.
Whether the division bench has looked into this question. Suppose if 1 acre of land is sought to be utilized, that 1 acre, there's no question of leaving civic community sites. There's no question of leaving what you call parks, open spaces. That apply agadilla.
But illi, what your lordships may have to consider is, now when we are developing, now what he gets, my lord, is absolutely developed land. That is the reason why. No, my lord, may I just make this submission?
Right.
No, my lord, one matter where ultimately, my lord, the Supreme Court confirmed the order of Arunachalam, which was actually the right view taken, where the court said it should be the value of the land that should be given.
Yes.
So they said all this 50 and 75% is not right. You value the land as on the date of the notification. My lord, that even the learned single judges following Arunachalam, which was challenged before division bench, went up to the Supreme Court, and that has been confirmed, and that order is being followed by a number of learned single judges of this honorable court. So there, what they say is, instead of all this, you give value the land, and there what they say is, now if you fix a particular value, if he is agreeable, give a portion of the developed land to him. Part of it you give in cash or whatever, or both, or either of them. That, my lord, has been confirmed.
Yeah, I'll give you a flip side. Suppose if he wants compensation now, he wants compensation. You will pay compensation for the entire land. You are bound to pay.
Under the old act.
Old act or new act, we'll consider later. You have to pay compensation for the entire extent.
Absolutely. In fact, this, my lord, 50%, even in Bondu Ramaswamy and other layout matters, even the Honorable Supreme Court has held, this is beneficial for them. This, my lord, what they have considered is, when we give them 50% of the developed land, this is much more beneficial for them than their land, undeveloped land being acquired and being, my lord, even as on today.
You are right. I don't say no.
Yes,
if it is acquired, what you say is right, because there's a cost of acquisition.
Look, all these cases are which are not acquired only. All these matters, look, 22 guntas.
Acquisition madilla iundralli.
Alla, elladrallu acquisition madida road alli all these matters arise out of those kind of cases only where without acquiring, we have utilized the land. Most of the time, my lord, there would be a consent deed with them. It's not as though, my lord, that we have come and we have taken it, my lord. They have taken a portion of it. So it is not as though that we have just thrown them out and we have done something totally illegal. It is not that. They would have agreed, they would have taken it, but then they come back to the court saying that we should have got so much. So it is not as though that we have straight away come and we have taken illegal possession. That has not happened. They only when they agree, my lord. Otherwise, they would have immediately come to the court and your lordships would immediately stay the matter. So this was what was considered. And then the government said that if we give this, this is much more beneficial for them.
I don't know how it is beneficial.
Look,
See,
because
ನಿಮ್ಗೆ 45 I think both of us are not trying to understand what is running in our mind.
I'll only make one submission. If your lordships are saying that 1 acre.
Forget 1 acre also. Forget 1 acre also. This 45% of land,
yes,
which you say will be towards
all the roads and everything.
Correct, Alva?
Yes.
You're not going to pay compensation for him for the 45%.
Allah, if it is acquired and utilized, we'll pay for his land, the entire land.
Correct. ಆ 45% ಏನು ಉಪಯೋಗಿಸ್ತಿರಲ್ಲ ಡಿಡಕ್ಟ್ ಮಾಡ್ತಿರಲ್ಲ
ಅಲ್ಲ ಅದು ಡಿಡಕ್ಟ್ ಮಾಡೋದು only for this kind of 50% ಕೊಡಬೇಕಾದ್ರೆ.
ಕರೆಕ್ಟ್ ನೀವು ಹೇಳ್ತಿರೋದು ಕರೆಕ್ಟ್. ಅದಕ್ಕೆ ನೀವು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡಲ್ವಲ್ಲ. You're not going to pay compensation for that.
What we are going to give them is out of the 55% developed land, 50% of 55% developed land which you are going to give.
Correct. ನಿಮಗೆ ಯಾಕೆ ಕೊಡಬೇಕು ಅಂತ ನಾನು ಕೇಳಿದೆ. Out of 55%, the whole 55% should go to him.
No, that was basically precisely what happened was that was what was being given by BD and that was what was challenged.
Why should you be given? Why should you be given is the question.
Now, if I am acquiring the land, my lord, I am acquiring the land. I am developing the land.
You are utilizing it.
So many acres of land.
You are utilizing it unauthorizedly. You are utilizing it unauthorizedly. You are not acquiring it. You are utilizing it unauthorizedly and illegally. In that situation, why should you also benefit? Why should you also benefit?
I understand, my lord. If there cannot be an unjust enrichment, my lord. There cannot be an unjust enrichment, nor can there be any impoverishment for them.
Yes.
Both are there. Now, if that is the case, my lord, now Arunachalam's case, which is very clear, which says that you have to give them the value, that then we are willing to give them the value.
Yes. Pay the value as per 2013.
We give them the value of the land.
Pay the value as per the 2013
That will give. In fact, this is more benefit. My lord, this has been held by the courts. We have even.
Saying 2013. What is saying 2013?
No. But the amount would be paid because the learned single judges have said as on that date and the amount. If I'm just able to
correct me if I'm wrong. You 45% ಏನು ಹೋಗುತ್ತೋ ಅದು ಹೋಯ್ತಲ್ಲ ಅವನಿಗೆ. 45% which you are going to deduct. It's a loss for him. It's a loss for him ultimately. 45% that you are going to deduct.
If he applies for
45% will be set up out. ಹೌದಾ? Only out of 55% you are going to share. You will get 60%, he will get 40% according to you.
That is if it is acquired and utilized.
Yes.
If it is without acquisition utilized, we give them 50%.
Yes.
50% or 55%.
50% or 55% ಮಿಕ್ಕಿದ 50% ನಿಮ್ಗೆ ಯಾಕೆ ಹೋಗ್ಬೇಕು ಅಂತ ಕೇಳ್ತಿರೋದು.
45% ನಾನು
45% ನಿಮಗೆ
all I am spending.
45% is coming to you.
No, we are not gaining anything in that 45%.
ಅಲ್ಲೇ ಬರೋದು. ರೋಡು ನೀವೇ ಮಾಡೋದು.
ಹೌದು, ಅದು ಯಾರಿಗೆ? Because of those roads, he gets a higher value.
Fine.
Because of the park, he gets a higher value. Now your lordship may kindly see. Now, even as on today, my lords, as on today, even if any of us were to go and buy a site, we talk, my lord, and we say, I agree that with regard to BDA. But even as on today, my lord, any person will want to buy a BDA site for the simple reason, it will have the roads, it will have the civic amenities, it will have the parks, and it will be neatly laid out. That is the reason why people still prefer to buy otherwise outskirts, those villa developments, my lord, those private developments are there. Barring those which are high costing villas which are there, otherwise, my lord, private developers, when they develop, there are no parks. My lord, I have seen it before when we are staying in a rented place. My lord, in those areas there are no parks.
Correct, you are right.
So only in BDA layouts you'll find these parks.
ನಾನು ಕೇಳ್ತಿರೋದು ನಿಮಗೆ ಯಾಕೆ ಬೇಕು ಅಂತ.
ಅಲ್ಲ ನಾನು ಡೆವಲಪ್ ಮಾಡಿರೋದು ಮತ್ತೆ ನಾನು ಈಗ then my lord one thing is there. Now if I take 1 acre of somebody's land and my lord now 45% my lord I'm going to spend on everything my lord. Now I spend on all that.
You'll
Then,
get 45%.
get it. No, we don't get it my lord. That is
you will get it because civic.
ಅಲ್ಲ ನಾನು 55% ಅಲ್ಲಿ.
ಅಲ್ರಿ 45% ಏನಕ್ಕೆ ಡಿರೆಕ್ಟ್ ಮಾಡ್ತೀರಾ? ಸಿವಿಕ್ ಕಮ್ಯುನಿಟಿ ತಾನೆ?
ಇಲ್ಲ.
ಇನ್ನೇನಕ್ಕೆ?
It is for everything. Park, civic community, infrastructure, my lord, sewage.
ಪಾರ್ಕಿಗೆ ಆಗ್ಲಿ, ಪಾರ್ಕ್ ಆಗ್ಲಿ, ಸಿವಿಕ್ ಕಮ್ಯುನಿಟಿಗೆ ಆಗ್ಲಿ,
drainage, sewage,
everything. It's all your property only.
It is
drainage is yours.
That doesn't go to us.
Whether it comes to you or not, it is yours. The roads vest in you. Parks vest in you.
That generally goes to BBMP for them to maintain it. Ultimately from the BDA, it goes to BBMP and now it will be a Greater Bangalore Authority, my lord. They maintain it, not us. So we don't get it, my lord. So we don't get it.
Rule has to be challenged in that case.
Then my lord, they may have to challenge that particular rule.
Section 17 itself. Then section 17 would have to be challenged to say that section 17 of KTCP Act, which prescribes that 45% has to be, that would have to be challenged.
No, that need not be challenged.
Well, it's a situation where it is either acquired and then taken up or otherwise. Well, can't change the situation.
Why?
Look, if they have to leave,
if it is being used for the same purpose,
then we'll quash the acquisition. We'll ask you to restore the land the way it was. We'll quash this one. We'll say we'll direct you to restore the land.
No. My lord, if my lord, ultimately the endeavor of your lordships would be that he gets fair and just compensation. Now, if that fair and just compensation, now your lordship may evaluate what is it that he would have.
The value of
what is it that he would have got if we had taken his land by issuing all the notification and acquiring it in accordance with law, and we had paid him the compensation. If he was getting X compensation, and now if we are giving him X plus 1, Lord, even as on today, if he wants that, we'll give it to him.
Why should we go into that question at all? You have utilized the land without acquisition. We'll put a full stop. We'll say, please return the land back to him.
Lord, now that has been utilized, Lord, now that cannot.
So therefore, if you utilized it, where's the question of you benefiting from it?
Lord, we
have done something illegal.
Lord, if he cannot benefit, there cannot be an unjust enrichment. Now, my lord, why did the honorable court say that it should be the value of the land, my lord?
Yes.
The value of the land will have to be given to him. Ultimately, my lord, these are all on the resolutions. My lord, then, if ultimately, my lord, he is relying on, or in other matters which we have produced about 30 judgments, where, my lord, the BDA went on to the extent of saying 100% will be given. It was given. 75% was given of the developed land. 40 guntas, 40 kot bitru. 40 guntas get 30 guntas kot bitru. Then when they sought for parity, then all these judgments came, and then, my lord, there, when this was happening there, then the learned single judges said, so this 50% should not be given. It should be the value of the land. The value of the land should be given to them.
Yes.
So it is only that now, my lord, here also there are 20 guntas, 27 guntas, 30 guntas of land, my lord. For that they give. Now, my lord, if my lord, they are able to show that this land under the normal acquisition, that they would have got more than what we are giving, my lord, then so be it, my lord.
Yes.
But if what we are giving them now, my lord, this also, this 40% giving them or 50%, my lord, this has been the seal of the Supreme Court is there on this.
No, we'll do one thing. We'll assess as per the 2013 Act.
No, that is not applicable, my lord. Now the Honorable Supreme Court, my lord, has held. Your lordships are hearing our matter on that.
I'll tell you, if you had acquired the land in accordance with law, the BDA Act would prevail. Because you acquired the land without following the due process of law.
But here,
it is
without acquisition only,
no.
I will point out from the learned single judge's order where they say under the old act only it has to be given.
When you are not complied with the BDA Act, acquiring his land, how do you fall back upon BDA Act for the purpose of determining the compensation? If you follow the BDA Act, yes,
in fact,
what you say is right.
They actually notified this land for acquisition. On the ground that possession was not taken, my acquisition got set aside.
But in fact, it appears that we had actually notified this land for acquisition.
Whatever it is, if you are acquired, take it. If you are not acquired, you cannot say, I'll fall back upon section 36 and say that Land Acquisition Act ಪ್ರಕಾರ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ.
My lord, this aspect we'll just look into this as to what your lordships have said. And my lord, we anyway we have given this, my lord, then we'll
2013 Act ಪ್ರಕಾರ ತಗೊಳ್ಳಿ.
ಇಲ್ಲ ಅದು ನಾವು ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ.
ತಗೊಳ್ಳೇಬೇಕು, ಯಾಕಂದ್ರೆ ನೀವು BD Act ಪ್ರಕಾರ ಅಕ್ವಿಸಿಷನ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, my lord, what I am told now is that acquisition was there, but possession was not taken, or that's what I'm being informed.
Whatever it is, you are not acquired under the BD Act. If you are not acquired under the BD Act, you cannot fall back upon the BD Act to say that this will be the compensation. If you are acquired under the BD Act, yes, I can understand. If you have illegally acquired it, used it, then it is a 2013 Act.
But what I'm submitting, my lord, is, my lord, some of these questions, but in all these matters, these are all the matters where we are giving them this 50% are only because of without acquisition we have utilized. All these judgments, my lord, all these are not, every single judgment of which we have produced, my lord, there are about 31 judgments, my lord, I'll point out. All these are without acquisition only. It is not as though, my lord, those are the different judgments. These are all, and they're all smaller thing, and where, my lord, they have said that this is much more beneficial that they get this. Otherwise, my lord, they would have got the compensation under that act. Of course, they have given their relinquishment deed. Even that also, my lord, there are 3 judgments which are on the basis of relinquishment. In fact, one of the division benches, my lord, in a similar matter, my lord, the learned single judge said that you are estopped. Against that, my lord, writ appeal was filed. There, my lord, the honorable division bench said that a similar matter is being considered by the honorable Supreme Court. My lord, Justice Krishna Dikshit had produced that order also. So, my lord, there he says, though we are conscious of the fact that there was no relinquishment deed, but still if there is no impediment or there is no hardship caused, because it's not as though no land has been given, he has been given, we can await the order of the honorable Supreme Court. My lord, may I just read that order, my lord? We had produced that. I'll just read that order. Learned counsel appearing for submit that the almost, my lord, this is 20. Page 221, my lord, of our compilation.
That is all acquisition, my lords. In this case, no acquisition.
Not acquisition.
No.
None of the matters are acquisition.
None of the matters are acquisition. These are all for the formation of road we have taken. These are all for road.
ಕೆಳಗಡೆಗೆ ಹಾಕಿದೆ number. Page numbering ಕೆಳಗಡೆ.
May I just give this, my lord, for a quick reference?
Page number 2
ಬಂತು ಸರ್. 220, 221.
221. My lord, got it? No? The order dated, this is on order on IA.
2 of 20.
That is 26/3/2024. Now, if your lordship sees, the appeal by so and so is filed with, my lord, we will not go into that order on IA number 2 of 23. So and so appearing to submit that almost identical question is being debated on the floor of the apex court in SLP number so and so, and therefore this matter may be deferred till disposal of the same. He also draws our attention to the fact that in terms of the extant policy, the BD has already allotted the site ad measuring 22,700, and therefore in respect of the remaining claim, a decision can be taken after the outcome of the pending SLP. Learned so and so appearing for the land user draws our attention to the relinquishment deed dated 23/2/2000, which provides for allotment of 50% of the developed land, and therefore what is now given to his client is much less than what is agreed to given to him, that is as per the relinquishment deed. Having heard the learned advocate for the parties and having perused the appeal papers, we are broadly in agreement with the submission of the learned panel for the BDA. It is that it is not the case that no land has been given to the land loser by the BDA. Part of the developed land is admittedly given. Whether 50% needs to be given in terms of relinquishment deed can be examined after the disposal of the aforesaid SLP, where similar question is being debated. We are also aware that the SLP does not involve any relinquishment deed of the kind. No prejudice will be caused to anyone if disposal of the SLP is awaited in the circumstance. In view of the subject application having been allowed, the impugned order of the learned judge is liable to be kept under suspension. Lord, here it is similar case where the learned single judge, my lord, allowed the writ petition. This was in appeal. This matter, my lord, had come up a few times before the honorable division bench now, but I'm not sure, my lord. I'll also check that.
I think, see, the only benefit that you are going to get from him is that he's allowing his land to be used by you.
It is the only benefit. It is for road, my lord. It is for the road.
No, the only benefit that you can expect from him is to allow you to use his property. That is all. You can't, what you call, share the booty. You can't share the booty. Suppose if the land is his land, is coming in the middle of a road, which you are not acquired. That man allows you to use that particular portion for the road. That is the privilege that he has given to you is only to use his portion. No, you cannot say, ನಾನು ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ ಇಬ್ರು ಹಂಚ್ಕೊಳ್ಳೋಣ ಅಂತ, ಮಿಕ್ಕಿದಲ್ಲಿ ಹಂಚ್ಕೊಳ್ಳೋಣ.
Then there are two questions.
ಮಿಕ್ಕಿದಲ್ಲಿ ಹಂಚ್ಕೊಳ್ಳೋಣ ಅಂತ.
ಅಲ್ಲಲ್ಲ,
I'll just give an example. In fact, Justice D.K. Singh's was allotted,
MAR, major arterial road.
He was allotted a bungalow.
Yes.
Next to his bungalow is the erstwhile Lee Meridian Hotel.
Yes, ma'am. I know where it comes. Yes. Howdu.
Next to that is one big bungalow.
Yes.
That particular building, Lee Meridian building, wanted an entrance, grand entrance. So they negotiated with the owner of that next to the bungalow, the Bandari Maneno, whatever. They paid a huge price, huge.
Yes.
10 times or 20 times of the market value only to get a piece of land so that the entrance is grand. So therefore, if you want a portion of his land for the purpose of your layout, you cannot say, I will develop it, you take 50, I will take 50.
That is only for the reason. Now, my lord, now there are two things, my lord. As
if you say that, Nalappa, ನನಗೆ 1 ಎಕರೆಗೆ ನನಗೆ ಇಷ್ಟು ಡೆವಲಪ್ಮೆಂಟ್ ಕಾಸ್ಟ್ ಇದೆ, you pay me this development cost, you take the development, I can understand. That also I can understand. You cannot say, you take 50, I will take 50. You are not a developer. He did not invite you.
No.
He did not invite you.
My lord, there are only two things, my lord. Why this has come up is this. Now, before your lordship, my lord, the question is, one, what your lordships now are saying is, whether we have now acquired it illegally or whatever, so the 2013 Act. Otherwise, my lord, what is being told, my lord, and that is being in all the judgments is that they are entitled, as on the date of acquisition under the Act, they are entitled for compensation, solatium, or whatever they are entitled for. If that is the case, my lord, this one was, why BDA did this was, my lord, this was more beneficial for them.
Oh no.
Lord, that is what even the Honorable Supreme Court
has said. Fall back upon this Act to pay compensation, provided you acquire the land under this Act. You have not acquired the land under this Act. You have used muscle power to take over that land.
No, muscle power is
muscle power, official power, official machinery.
Muscle power. ಈಗ ನಾಳೆ ನಮ್ ಎಲ್ಲೋ ಜಾಗ ಸಡನ್ಲಿ ಬಂದ್ಕೊಂಡ್ರೆ ಹಂಗ ಆಗ್ತಿಲ್ಲ. It is they would have come forward.
Official machinery.
Relinquishment deed ಆಗಿದೆ. ಅಲ್ಲ, they have agreed. Consent deeds ಆಗಿರ್ತದೆ.
Correct.
In most of the cases, there is a consent deed also that they will allow that. So it is not that, Lord, we are not, demolition is one aspect of the matter, where BDA sometimes may demolish it without notice or whatever. This is not such a case.
Correct. You have used official machinery to take over his land.
ಆ ತರ ಮಾಡಿರಲ್ಲ. ಅಲ್ಲ, they would have agreed.
You can only acquire.
No, that official machinery will be used when we have acquired and when possession or kodilla, and that time we use it, or when we don't. Here, that is not the case, because they would have agreed. Relinquishment deed has been executed.
Relinquishment deed execute ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀರಾ?
Allotment letter also they have issued.
Allotment, not just because they have issued allotment letters for 6 sites, we have given them the relinquishment deed. Now, after receiving the relinquishment deed, they say they will allot only 3 sites, not with the remaining 3 sites.
So whatever that was assured is not being given.
Therefore, we will give them the 3 sites what they have given us. Let them give them our land.
That's what I said.
As simple as it is.
In fact, my lord, relinquishment deed was, that is what was their case, and that was, my lord, this division bench. There, the learned single judge said that you are stopped.
Really, the relinquishment deed. What is mentioned in the relinquishment deed?
That is correct what they're saying. We are not disputing it.
This is part of the petition.
Then it is between 2 individuals. Whatever you have agreed, you have to.
Page 32.
Same thing, my lord, was.
Petition copy.
Annexure E, page 32.
My lord, this very same question is being now being heard by the division bench, my lord, because they.
That is totally different.
No, let me say.
No. I will.
The learned judge.
That is acquired property. What is available with the district? Not what is available with the division bench is not acquired by way of notification. This is not acquired.
Yeah, please let us see what.
That also was not acquired. The learned single judge's order will show that.
What is written in the relinquishment deed?
Yes, Lord.
39 guntas of Devar Chikkanhalli. Handed over to so and so. ಎಷ್ಟು ಕೊಡಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ?
Resolution.
Page 32. No, resolution.
Next page.
As per its resolution dated 18/4/2017. ಎಲ್ಲಿದೆ
Lord, that
resolution
resolution is also the part of the record, my lords.
ಎಲ್ಲಿದೆ ಅದು?
Page number, my lords.
Please come to page 30.
Page number 30.
ಜಮೀನಿಗೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಅಂತ ಮಾಡುವ ಆದೇಶದನ್ವಯ ಪ್ರಾಥಮಿಕ ಅಧಿಸೂಚನೆ ರದ್ದುಪಡಿಸಿದ್ದು, ಸದರಿ ಜಮೀನು ಈಗಾಗಲೇ ಪ್ರಾಥಮಿಕ ವಿಷಯಗಳನ್ನು ಹಂಚಿಕೆ ಮಾಡುವುದರಿಂದ ಭೂ ಮಾಲೀಕರಿಗೆ ಬದಲಿ ಜಮೀನನ್ನು ನೀಡುವ ಬಗ್ಗೆ ಚರ್ಚೆ. ಅದರಂತೆ 40% ಅಂದರೆ 16,998 ಚದರ ಅಡಿಗಳಷ್ಟು ಪ್ರಾಧಿಕಾರದಿಂದ ಬದಲಿ ಜಮೀನನ್ನು ಹಂಚಿಕೆ ಮಾಡಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು.
My lord, I'll just read what my learned friend is saying is not. I'll just read this. The single judge's order against which that writ appeal, that order I read. The circumstances leading to the petition are mostly undisputed, and these undisputed are as follows. The petitioner and the BDA have negotiated BDA's utilization of an extent of 2 acres 5 guntas out of the total extent of 3 acres 3 guntas of so and so village for the purpose of widening K.R.Puram Hebbal Outer Ring Road and construction of overhead bridge. These negotiations are in lieu of the BDA initiating acquisition proceedings. So this is without acquisition. This the judgment of the learned single.
In lieu andre ಏನು?
Lieu ಅಂತಂದ್ರೆ in lieu of the acquisition. Now acquisition ಮಾಡಿದ್ರೆ we would have had to go around that. Without that, we are going to give you this because this is more beneficial for them. Placing on record, the petitioner has not created any encumbrance and so and so. Then, my lord, the relevant portion is in the light of grievances and so and so. This court is examining the question whether BDA could justifiably resile on the promise to allot 45,248 square feet of developed area because of its earlier resolution dated 16/1/2012, revisited by the circular dated 19/10/2018, which we are saying the government circular, my lord, which they are not challenged. Hence, confine the allotment to an extent of only 22,796 square feet of the developed land already allotted. This court, my lord, and then I'll just take your lordship to the relevant portion. So, my lord, it's obvious from the above circumstance that the necessary ingredients for applying the principles of promissory estoppel, that is promised to allot 45,000 for developed area for utilization of the subject property, the execution of the relinquishment deed at 23/2/2000, altering the position and utilization of the subject property are established. Further, the BDA acting upon such promise has transferred 22,000. Lord, it is exactly the same, similar for the purpose of road. They said this is without acquiring. Where they negotiated, they said we'll give relinquishment deed was executed for that 45,000, but they gave only 22,000 in view of the government order. This, my lord, is in appeal, and in this appeal, my lord, the division bench has passed that order, and where this order has been stayed, my lord, that matter is going on now. When that matter is coming up, my lord, it should be coming up anytime soon.
ಇದು ಯಾವ ಲೇಔಟ್ ಗೆ ಅಕ್ವೈರ್ ಆಗಿರೋದು? ಯಾವ ಲೇಔಟ್ ಗೆ? BTM 4 stage.
BTM
4 stage.
Yes, ma'am.
The BTM 4 stage allotment price ಎಷ್ಟಿದೆ? BTM 4 stage allotment price.
We'll have to check that. We'll have to check that. Lord, our case only is this one.
No, I'm only trying to compare.
Yes, ma'am.
Suppose if 2013 Act is applied.
Lord, that may be a difference.
Suppose ಅಂತ ಹೇಳಿದ್ರು.
Yes.
Suppose if 2013 is Act is applied, you will have to pay 2 times the market value.
Lord, why I'm saying that is that way. Because all this comparison of giving, my lord, the government order coming into force or we telling that's all on the basis of the old act itself. The new act has not been considered.
Forget it. We'll say suppose.
So yes,
suppose.
Probably it may be equal or more.
Suppose if it is under the 2013 Act, you'll have to pay twice the market value.
Yes.
Correct? It is not the guidance value, it is the market value. What is your allotment price? Suppose if it is about 2,000 rupees per square feet, then he will be getting more.
But if that is,
he'll be getting more.
True, but that is
because your allotment price will not even be the guidance value. ನಿಮ್ಮ allotment price ಏನಿದೆಯೋ guidance value ಇರೋದಿಲ್ಲ. It will less than the guidance value.
But the site what he is going to get, that will be now he'll be selling it at the market price.
It's a different thing. That is his
value being given. But the value being given, ultimately it all rests on the thing that the value that is being given. What I'm submitting is this one. Now the division bench, my lord, is hearing this matter, my lord. Now, my lord, the learned single judge of this court, my lord, has held in their favor in similar circumstances. My lord, that is being heard. And my lord, there and what we have pointed out is that there is a matter.
Forget the case. It is like a policeman. It is like a policeman who takes away money from somebody or a thief who takes away money from somebody. And he says when he is caught that 100 ರೂಪಾಯಿ ಕದ್ದಿದ್ ನಿಜ, ಕದ್ದ ಮೇಲೆ ಪೊಲೀಸ್ಗೆ 40 ರೂಪಾಯಿ ಕೊಟ್ಟೆ, ಇನ್ ಮಿಕ್ಕಿದ 50-60 ಮಿಕ್ಕಿದೆ, ನೀನ್ 30 ಹಿಡ್ಕೊ, ನಾನ್ 30 ಹಿಡ್ಕೋತೀನಿ. So the man who lost 100 rupees ultimately gets only 30 rupees.
No. Our
man who stole.
I do understand, my lord. Our case, my lord, what your lordships now are doing is, my lord, because it is, my lord, the acquisition at that time or whatever, my lord, it is under the old act. Now, if your lordships are saying the new act, my lord, that is, as on today, my lord, the Supreme Court is very clear that the new act is not applicable to us. So that would arise.
I don't know why you're not seeing what I'm trying to.
I understand, my lord.
You BD Act acquire ಮಾಡಿದ್ರೆ, BD Act to compensation ge same thing will apply. You are not acquired under the BD Act, so don't fall back upon BD Act.
Allala, BD Act alla acquisition again under 1894 Act. My lord, it is not that entire thing is under the BD Act. My lord, what happened? No, my lord, where I'm trying to get at is, my lord, the entire thing is not under the BD Act. Why, my lord, it is being said is that we have to pay the compensation not under the BD Act but under the 1894 Land Acquisition Act.
Because of section 36.
Absolutely, my lord. So it is not under the BD Act.
Correct. Compensation is paid under the
Land Acquisition Act.
Correct. Under the Land Acquisition Act only. It is by reference. No dispute. It is by reference. So therefore you cannot fall back upon it because you are not acquired under the BD Act.
Yes. It will be under the Land Acquisition Act itself, which will be applicable.
No.
Look,
No.
Now the question is.
Bunny.
Please, will your lordship may have it on
section 30. Anyway, you raised a very interesting topic.
Yes.
36.
But idralli now, my lord. Now one more thing is, my lord. Now, if this honorable division bench is considering the very same issue, the very same issue is being considered.
Yes.
Because what I pointed out, this judgment, my lord, the very same issue. The matter is getting listed, and I'm not sure. See that we can just check and tell when the matter is coming up.
Yes.
And my lord, and I'll point out all those judgments, my lord, in respect of very in respect of all roads, in respect of relinquishment deeds, in respect of where the learned judges have said that it will be as on that date under the.
No, I'll give you that classic example of a thief.
But we are not stealing here.
I only gave you an example. Why you want to say that you are stolen? I gave you an example of a thief. No. So that I can break it down to the bare minimum possible. Kadda 100 ರೂಪಾಯಿ ಕದ್ದ, ಪೊಲೀಸರು 40 ರೂಪಾಯಿ ಕಿತ್ಕೊಂಡ್ರು, 60 ರೂಪಾಯಿ ಮಿಕ್ತು. So the thief says, you keep 30, I will keep 30. So he is again benefited. Even after stealing, he still benefited.
We will not be benefited here.
You will get to 50% of 40%.
That road is for
road 45% hoitri.
It is only for the purpose of formation of road.
Road only. This land is entirely
for
used.
the purpose
so
of
your
a
road
road.
Formation will be not spent for the formation of the road.
Correct. Road formation ಗೆ ಉಪಯೋಗಿಸಿದ್ರೆ ಇಲ್ಲ ಅಂತ ನಾನು ಹೇಳೋದಿಲ್ಲ. Ultimately, he has lost his land.
He has lost his land. He is entitled for compensation.
Whether you use it for a road, you use it for a swimming pool, he is not bothered.
Or layout.
Yes. He is not bothered. He says, if I had developed my land, I would have got 55% of the area. Please give me that.
My lord, that is precisely. My lord, now if your lordships are coming to that point, 55% would have been left with him. What he would have spent for 45%, that is what, my lord, we showed to the Honorable Division Bench. Honorable Division Bench making all that calculation, my lord, has ultimately held. No, he'll not. It is the value of the land that will have to be given. That is, my lord, ultimately it is that. But
even then you lose.
Lord, here the question is, my lord, if it is a new act, it's a different thing altogether. It is not the new act. Lord, because
is a new act.
Why, my lord, even Bondu Ramaswamy.
It is a new act because you have not initiated acquisition under the BD Act.
What I'm saying is, in our other matter where we have challenged, my lord, the award where it was passed under 2013 Act, your lordship, my lord, relying on the earlier judgment or whatever, where your lordship says that a person is not worried or bothered about who is acquiring the land, whether it's BDA which is acquiring the land, or it's a KIDB, or it is highways. See, they are going to get it under the 2013 Act. Why should this person get it under the old Act? That is what, my lord, your lordship, which we have to still argue, and that your lordship should still have to take a decision in that matter.
Please allow me to complete. ಈ ಕೇಸಲ್ಲಿ ನಾನು ಆ ಥರ ಹೇಳ್ತಾ ಇಲ್ಲ. What I am trying to tell you is, because you have used the land without following the due process contained in the BD Act, you cannot say that I'll pay compensation as provided under the BD Act. That is under the Land Acquisition Act. ನೀವು ಹೇಳಕ್ಕಾಗಲ್ಲ. ಈ BD Act ಅಲ್ಲಿ acquire ಮಾಡಿದ್ರೆ, then you can fall back upon section 36 and say I'll pay compensation under the 1894 Act. If you are not acquired it, then he has lost the land by the state government exercising jurisdiction. So therefore the state government will have to pay compensation under the 2013 Act. Your Land Acquisition Act illa. Land Acquisition Act illa.
But now now whatever we are acquiring till it's held otherwise by your lordships or whatever happens, my lord, if it is held. Otherwise, my lord, wherever BDA is acquiring, it is still under that, or we get an amendment to the BDA Act and say that we insert that clause and we incorporate a particular clause of 2013 Act. Till then, my lord, whatever we are acquiring, it is still under the old Act.
What did you understand from what I conveyed to you? How did you understand that? ನಾನು ಹೇಳಿದ್ದೀನಿ, ನೀವೇನು ಅರ್ಥ ಆಯ್ತು?
My lord, what your lordships are saying is, Lord, the entire premise, my lord, of your lordship ultimately is that if that land is lost and if it is not been acquired by the BDA, if it is acquired by the BDA, my lord, that also, my lord, your lordships would not say that 2013 Act is not applicable, my lord, because your lordships are already taking a view, not taken a view, but saying that it doesn't stand to reason. There also your lordships have been saying that is the only reason why I am saying this to your lordship.
ನಾನು ಹೇಳಿದ್ದೇನೆ ನಿಮಗೆ. What did I try to convey? Your mind is somewhere else.
Illilla.
What I tried to tell you was, you can apply section 36 of the BD Act only when you acquire land under the BD Act.
Lord, I understand that.
Only when you acquire under the BD Act. If you don't acquire under the BD Act, compensation should be given under the Land Acquisition Act. ಒಪ್ಕೋತೀರಾ at least ಅದಾದ್ರೂ? Land Acquisition Act ಇಲ್ಲ ಇವತ್ತು. 2013 Act ಇದೆ. So if you were to compensate under the 2013 Act, you will have to pay twice the market value, which is far higher.
That also we still don't know. I mean,
Then
that will have to be calculated. We don't know, but probably, my lord, it would be, but I'm not sure about that. That will have to be calculated.
Then the allotment price. ಹಂಗಿದ್ದಾಗ ಏನಾಗುತ್ತೆ? ಹೋಗೋದು ನಿಮ್ಗೆ ತೊಂದ್ರೆ.
That will have to look into that.
Nobody has applied their mind from this point of view.
Possible. That, my lord, that can be, my lord, but now if the very same point, my lord, is being, my lord, debated before the honorable division bench now, where in similar circumstances, my lord, where the learned single judge has already allowed the petition and that is there, and the honorable division bench giving the reasons and saying this matter is being debated in the honorable Supreme Court.
Now I'll give you one more twist. The thief says, ನಿನ್ ಮನೆ ಬೀಗ ಹೊಡೆಯೋದಕ್ಕೆ I used a cutting plier, I used implements. ಆ ಇಂಪ್ಲಿಮೆಂಟ್ಸ್ ಒಂದು 100 ರೂಪಾಯಿ ಖರ್ಚು, ಇದು 20 ರೂಪಾಯಿ ಖರ್ಚಾಗಿದೆ, ಅದನ್ನು ಮೈನಸ್ ಮಾಡೋಣ ಅಂತ. ಔಟ್ ಆಫ್ 60 rupees 20 ರೂಪಾಯಿ ಕಟ್ ಆಗುತ್ತೆ. And 40 rupees you take 20, I take 20.
My lord, if we agree on a particular point, my lord, if the honorable court were to agree that there should not be any unjust enrichment.
Unjust enrichment
my lord, why did then the honorable court say value of the land should be given? Value of the land.
Value of the land, because
then again it is coming to the question. What is happening is the question is again coming back to the new act. Lord, because the whole thing is whether it's under the new act or under the old act. Lord, our contention is that it is still under the old act only.
It can't be. Old act ನೀವು acquire ಮಾಡಿ old act ಅಲ್ಲಿ ಕೊಡಿ. ನೀವು BD act ಅಲ್ಲಿ acquire ಮಾಡಿ old act ಅಲ್ಲಿ ಕೊಡಿ. I have no answer to that. But illegal ಆಗಿ ನೀವು acquire ಮಾಡಿ without notification, you cannot say ನಾನು old act ಅಲ್ಲೇ ಕೊಡ್ತೀನಿ.
But then, my lord, once they agree, and of course promissory estoppel, which, my lord, the learned single judge said, but once there is a government order, my lord, which clearly says that they are entitled for so much. But anyway, my lord, we'll look into that aspect of the matter.
Now that we have spent enough time, I will treat it as parted.
Please, Lord, my lord, we have been, even in the other matter which is coming up tomorrow, my lord, we ourselves, my lord, why I said that is, my lord, your lordships had said because your colleagues had appeared, we made a submission, we have no objection, and In that matter, my lord, after your lordships heard, I requested your lordships to treat it as part heard. In fact, in that matter.
No, but then this is a very interesting topic.
Yes.
Because if a person who has lost his land.
No. If that is, look, what I'm saying is this is not a case where we are not paying him anything. That's what even the Honorable Division Bench has said. We have already given him. And what we had to give, that we are willing to give, that we have said in our objections also. It is only the difference of 5,000 square feet. According to them, balance is 7,600 square feet. According to us, balance is 2,000 and odd square feet. That is the difference is only 5,000. We have given them already.
He was only liable to pay betterment charges. Betterment charges one day
if you don't acquire it, betterment charge, which we could under section 20 and I think we can impose on them.
One acre jameen BDA layout alli pakkadalli 1 acre jameen idire, it will be its value in gold. Now you are saying you collect.
Now since your lordships are saying value in gold, now what he is getting, that also will be value in gold only. What BDA is giving,
what you would have got is 1 kg, you are giving only 250 grams of gold.
But what they are going to get is also in gold only.
Oh, no.
Lords, to put an end to all this litigation, Lords, I have only one suggestion, Lords. Lords, I am ready to give back their sites, Lords. Let them return the property. Lords, if they are not agreeing to the, Lords, just because of this resolution, Lords,
yes,
I agree to give them the land. Otherwise, Lords, I would not have given them this land.
Please speak what is possible.
Lords,
now they used it for a road.
Lords,
they give back a road to you.
Lords, all right, Lords, kindly see the resolution, Lords. Just because the resolution I have given them the land.
Yes. Yeah. When do you want it?
After 2 weeks.
Heard in part. List on yavat. Take whatever date.
Yes. Lord, may we request your lordships to have it on 24th.
24th.
It's a little more than
no.
Little more than 2 weeks.
21st.
21st is a holiday.
21st holiday, huh?
24th, ashte. That's all.
20th.
20th, but Dharwad matters. 24th, Monday.
27th. Yes, 27th.
Please.
For further hearing. Yes.
Obliged, Lords.
Serial number 49, Ganesh Chennai.
Thief the ಸ್ವಲ್ಪ ಇನ್ನೊಂದ್ಸತಿ ಯೋಚನೆ ಮಾಡಿ.
My lord, our only request is we are not doing any charity, my lord. I accept that. They should get the value of the land, my lord. Only thing is they should neither be unjust enrichment nor impoverishment. If that is taken care, my lord, we are in your lordship's hands. That's all.
ಹೇಳಿದ್ದು ಅವನ ಜಮೀನ್ ತಗೊಳ್ಳಿ 45% ಕಿತಾಕಿ. You say 55% ಡೆವಲಪ್ ಮಾಡೋದಕ್ಕೆ ನಮ್ಗೆ ಇಷ್ಟು ಖರ್ಚಾಗುತ್ತಪ್ಪ, ಇಷ್ಟು ಕೊಡು ಅಂತ ಕೇಳಿ, ಯು ಆರ್ ಜಸ್ಟಿಫೈಡ್. ಡೆವಲಪ್ ಮಾಡೋಕ್ಕೆ ಇಷ್ಟು ಖರ್ಚಾಗುತ್ತೆ ಕೊಡು, ದಟ್ ಐ ಥಿಂಕ್ ಈಸ್ ಫೇರ್. ಬಟ್ ನಾನು ನೀನು ಇಬ್ಬರು ಹಂಚ್ಕೊಳ್ಳೋಣ ಅನ್ನೋದು ತಪ್ಪದು. ದಟ್ ಈಸ್, ಇಫ್ ಯು ಸೇ ದಟ್, ದೆನ್ ದ ಥೀವ್ಸ್ ಇಲಸ್ಟ್ರೇಷನ್ ಬೆಸ್ಟ್ ಡಿಸ್ಕ್ರೈಬ್ಸ್ ದ ಸಿಚುವೇಶನ್.
Probably I would rather agree to disagree, my lord, with due respect, my lord.
Yes.
Obliged.
Serial number 49, Ganesh Chennai.
For 2 weeks time. 2 weeks time.
Yes, Vasanta.
With regard to measurement, please.
Time
was allotted
is under process, my lord.
It was allotted with site measuring 40-60, please, my lords. Thereafter, they executed the modified layout plan and got it reduced to 30-40. Lordship suggested the last date of hearing.
Alternative sites.
It is 30-41.
30-40 ಇಟ್ಕೊಂಡು ಇನ್ನೊಂದು ಮಿಕ್ಕ 30-40 ಕೊಡಿ ಅಂತ.
ಎರಡು ಸೈಟ್ ಆಗುತ್ತೆ, ಅದು ಪ್ರೊವಿಷನ್ ಇಲ್ಲ.
ಮೆಜರ್ಮೆಂಟ್ ಸೇಮ್.
ಅದಕ್ಕೆ 40-60 ಇನ್ನೊಂದು ಎರಡು ಆಗುತ್ತೆ. ಅಲ್ಲ 40-60 ಕೊಡ್ತಾರಂತೆ. ಅದು ಎರಡು ಸೈಟ್ ಆಗುತ್ತೆ, ಒಂದು ಸೈಟ್ ಮತ್ತೆ
ಇದೇ ಲೇಔಟ್ ಅಲ್ಲಿ ಕೊಡ್ತೀರಾ?
ಅದೇ ಲೇಔಟ್
ಅಲ್ಲಿ ಹುಡುಕ್ತಾ ಇದಾರಂತೆ ಸ್ವಾಮಿ.
ಇದೇ ಲೇಔಟ್ ಅಲ್ಲಿ 40-60 ಕೊಟ್ರೆ he will be happy to accept it. ಇಲ್ಲ ಕೊಟ್ರೆ 30-40 ಕೊಡಿ, ಇನ್ನು ಮಿಕ್ಕಿದ್ದನ್ನು 30-40 ಕೊಡಿ. ಎರಡು ಸೈಟ್ ಹೆಂಗಾಯ್ತು? ಒಂದೇ ಸೈಟ್ ಅದು.
ಅಲ್ಲ ಒಂದೇ ಸೈಟ್ 40-60 ಏನೋ ಹುಡುಕ್ತಾ ಇದ್ದಾರೆ ಸೈಟ್ ಅಂತ ಹೇಳ್ತಾರೆ.
Sir,
Standard
46,
process
4060 is 2400, 3040 is 1200, 3040 ಕೊಟ್ಟಿದ್ರಾಗ್ಲೇ ಇನ್ನೊಂದು 3040 ಕೊಡಿ. So the total becomes 2400.
ಜನರಲ್ ಅಲಾಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಬರೋದಿಲ್ಲ 2 ಸೈಟ್ ಕೊಡೋದಿಕ್ಕೆ ಅಂತ. ಇನ್ಸೆಂಟಿವ್ ಸೈಟ್ ಅಲ್ಲಾದ್ರೆ ಕೊಡ್ಬೋದು.
ಆಯ್ತು 4060 ಹುಡುಕೊಡಿ ಅದೇ ಲೇಔಟ್ ಅಲ್ಲಿ.
2 weeks time granted.
Learn council.
20 ವರ್ಷದಿಂದ ಆಗಿದೆ.
20 ನೀವು 25ಕ್ಕೆ ತಾನೇ ಬಂದಿರೋದು ಹೈಕೋರ್ಟ್ಗೆ.
ಪೊಸೆಷನ್ ಎಲ್ಲ ತಗೊಂಡಾದ್ಮೇಲೆ ಬರ್ತಾರೆ.
ಆಯ್ತು. Learn counsel for the respondent. Number 1, 2, 3, 6 time. List on when Vasanta?
27th.
27th. Why are you pushing it to the month end? You want to escape the bench?
No.
Then
I request your lordship to take it as part.
No.
20th.
Yes.
Serial number 50, A. Nagarajappa.
Yes, ma'am. I'm for petition.
Deepthi Ayatan. Yes, madam. ಏನಿದು?
The site acquired, allotted by the BDA to the petitioner is allotted to some other persons. And on the last occasion, this court.
Yes, madam.
The respondent to furnish the details of the sites available in Sir M. Vishweshwaraya layout.
ಮಲೋಜ್ ಅವರು ಸರ್ ಎಂ ವಿಶ್ವೇಶ್ವರಯ್ಯ ಲೇಔಟ್ ಅಲ್ಲೇನೆ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಸೈಟ್.
There is no site?
ಮೈಲಾಡ್ಸ್ ನಮ್ಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಏನ್ ಬಂತು ಅಂತಂದ್ರೆ ದೇರ್ ಇಸ್ ಅವೈಲಬಿಲಿಟಿ ಆಫ್ ಸೈಟ್ಸ್ ಬಟ್ ಅದು ಆನ್ ಸೈಟ್ ಹೋಗಿ ನೋಡಿದ್ರೆ ದೇರ್ ಆರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್. ಸೊ ಇಸ್ ಅ ಡಿಸ್ಕ್ರಿಪೆನ್ಸಿ.
She is arguing, can take your seat. Yes.
So ಅದಕ್ಕೆ ಮೈಲಾಡ್ಸ್ if that way is allotted then it will be again ಇನ್ನೊಂದು round of.
ಅಲ್ಲ ಯಾವ ಸೈಟ್ ಕೊಡ್ದಿ? You cancelled the site allotted to him.
Yes, that is cancelled, my lord. That is not available right now.
Then what will you give?
My lord, ನಮ್ಗೆ ಲಿಸ್ಟ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಬಟ್ ಅದೇ ಆನ್ ಸೈಟ್ there is a problem. ಅಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಲ್ರೆಡಿ
Do
ಇರುತ್ತೆ.
whatever you want, madam. You please allot him an alternate site.
Yes, my lord. But ಅದೇ layout ಅಂದ್ರೆ it will be a problem.
ಇನ್ನೆಲ್ಲಿ ಕೊಡ್ತೀರಾ?
Some other similar layout, my lords. Adjacent.
Vacant sites are available in the same. Sorry.
ಹೇಳಿ ಯಾವ್ದಿದೆ ಅಂತ ನೀವೇ ಹೇಳಿ ಅವ್ರಿಗೆ.
They may file the affidavit, my lord. They are not available.
If you have information.
No, my lord.
ಮತ್ತೆ ಸುಮ್ಮನಿರಿ.
Please, my lord. Please.
My lords, adjacent layouts, my lords.
Adjacent layout. First you tell us whether sites are available in this layout or not.
Yes, my lords. I'll get the list, my lords.
Now, if you say there are no sites, I will ask you for further information as to how many sites are formed, how many sites are allotted, what happened to the remaining.
Milords, if I may
We'll have to deeply examine the whole thing.
No, Milords, the instructions ಏನಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ ಲೆಡ್ಜರ್ ಅಲ್ಲಿ ಅವೈಲಬಿಲಿಟಿ ತೋರಿಸ್ತಾ ಇರೋದು ಅಲ್ಲಿ ಫೀಲ್ಡ್ ಅಲ್ಲಿ ಹೋಗಿ ನೋಡಿದ್ರೆ there is already some construction.
So do whatever you want to remove the construction, ensure that.
So presently, Milords, Sir M. Vishweshwaraya layout, they have said there is no possibility. Any other layout can be considered.
Okay, I will take that. Please justify it and by producing documents or some information that these are the sites which are formed, these are the sites which are allotted, these are the sites which are not allotted. Kodi.
Well, I'll file my affidavit.
We'll ask him to pick up one site, we'll chase you to remove the construction.
That is another prolonged procedure.
ಏನು ಮಾಡಕ್ಕಾಗುತ್ತೆ? You please give the list of sites.
If they can make a representation to the authority, then they will be able to consider it.
No point. If we are asking him to go to a lifeless body, we can't send him to a lifeless body.
Milords, if it is going from the.
No, you please, if you say that there are no sites in Sir M. Vishweshwaraya layout, I'll accept it. But justify that.
I have already asked for instructions. I'll ask them to file something in writing.
Barkul. The learned counsel for the respondent submits that there are no sites available in Sir M. Vishweshwaraya layout for allotment to the petitioner as an alternate site. Full stop. The learned counsel is therefore directed to place on record the number of sites formed in Sir M. Vishweshwaraya layout, the number of sites allotted, this number of sites which are not allotted, and the number of sites which are under litigation.
That registry ಅಲ್ಲಿ ಸಿಗಲ್ಲ.
ಮತ್ತೆ ಎನ್ನೆಲ್ಲಿ ಸಿಗುತ್ತೆ? ನಿಮ್ಮ ಹತ್ರ ಸಿಗಿದೆ.
I'll have it verified.
List on when?
20th, Milords.
List on 20th.
Please, number 51, Sri Rajshekar.
Sri Rajshekar. Vachan.
Plus, the petitioner lands were acquired for formation of JP Nagar 9-stage, my lords. Pursuant to which, my lords, the BD has allotted me 2 sites, my lords. Then I requested that instead of 2 sites, 1 site may be allotted, that is 40/16, my lords. BD has approved that and issued me allotment letter on 9/12/2013, my lords, and asked me to pay 12,61,600, my lords. The amount is paid on 23/12/2013, my lords. Since there was some conflicting claim, my lords, the brothers, my lords, it belongs to the brothers, my lords. So the matter was referred to a special task force, my lords, to hold inquiry to determine, my lords. My lords, until now there was no response, and as such there was one more writ petition filed at page number 27.
So the dispute between the petitioners interstate.
Ivaga ಅದು ಸರಿಯಾಗಿದೆ. We had filed an affidavit before the special task force, my lords. That is at
30-40 ಎರಡು ಇಟ್ಕೊಂಡಿದ್ರೆ ನೀನೊಂದು ಅವನೊಂದು ಇಟ್ಕೋಬೋದಿತ್ತ?
ಅದೇನೋ ಅವ್ರಿಗೆ ಜೊತೆಗೆ ಬೇಕು ಅಂತ ಅಂದ್ರು. ಸರ್, my lords, at page number 35, my lords. ಅಲ್ಲಿ affidavit ಹಾಕಿದೀವಿ. Paragraph number 3, my lords. I further state that at time of allotment, the above site, said residential site, I have paid a sum of so and so as a differential site value and other incidental charges to BDA by way of demand draft by collecting the entire amount from Shri Srinivas and Shri M. Manjunath in the year 2013 by cash. I further state that I have no objection to register the above said site in the name of Shri so and so, and I have no right, title and interest.
Who is this Shankar Naik?
Our brother.
His mama brother.
Avaru so avatratra kottidru ivaru kattidru, and now he has given this affidavit before the special task force, my lords.
Yes.
Representation ಕೊಡ್ತಾ ಇದೀವಿ from 2013, my lords.
Yes.
In this matter,
some site is identified.
ಹೌದು, ಇಲ್ಲಿದೆ.
We have not filed wakalat, my lords. Mr. Yadav and other counsel has filed a wakalat.
My lords, filed on 25/11/2025, my lords.
Learned counsel for the respondent submits that the respondent number 1 has not entrusted the wakalat to him. Full stop. Hence list on so and so.
Thus a short date may be given, my lords.
Wakalat interest agbeಕಲ್ಲ, some lawyer has to come.
25 file ಮಾಡಿರೋದು.
Next.
My lords, a date may be fixed, my lords.
Madam, wakalat ಹಾಕಿದ ತಕ್ಷಣ ಮೂವ್ ಮಾಡಿ. Other side.
Please, my lords.
52 urgent, seal number 53. Mahadevan case.
That there may be a direction for them, my lords.
Yes. Direction to engage a lawyer.
ಅಲ್ಲ, ಒಂದು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡೋದಕ್ಕೆ.
My lord, 53 2 weeks time may be given. ಅದು ಖಾತಾ ಟ್ರಾನ್ಸ್ಫರ್ ವಿಷಯ ಖಾತಾ ಇದು ಗ್ರೇಟರ್ ಬ್ಯಾಂಗ್ಳೂರ್ಗೆ NTA ಲೇಔಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಅಂತ.
ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆಯಲ್ಲ.
ಅಲ್ಲ, ಡೀಟೇಲ್ ಇನ್ನು ಅಫಿಷಿಯಲ್ ಆಗಿ ಇನ್ನು ಪೇಪರ್ಸ್ ಹೋಗಿಲ್ಲ.
ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ, and also my lords last
No,
time
this NTA layout is handed over by the BDA to the GBA. ಮಾಡಿದಾರಲ್ಲ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಅದಕ್ಕೆ 2 weeks ಕೊಟ್ರೆ ಬೈ ದ ಟೈಮ್
ಈ BDA ಖಾತೆ ಮಾಡ್ಕೊಡಕ್ ಆಗಲ್ವಾ?
ಇಲ್ಲ ಅಂತೆ, ಫೈಲ್ಸ್ ಎಲ್ಲ has already transition to GBA. My lords, ಇದರಲ್ಲಿ ಪ್ಲಾನ್ ನೋಡಿದ್ರೆ there is a concern which NTI layout association themselves the plan approval ಕೊಡುವಾಗ್ಲೇನೆ ಏನೋ ಕನ್ಸರ್ನ್ ಇದೆ ಅದರಲ್ಲಿ. ಇದು ನೋಡಿ ಸರ್.
No, my previous site is sanctioned, next site is sanctioned, entire site on the list is sanctioned except my site.
My lords, can I show this in the plan?
He has produced a plan.
Yes.
ಅದರಲ್ಲೇನೆ if my lords may see, ಅವರೇನೇನೆ ಅವರು ಈ ಸೈಟ್ ನಂಬರ್ ಗೆ ಸೊಸೈಟಿ ಲ್ಯಾಂಡ್ ಬಿಲ್ಟ್ ಅಪ್ unauthorized construction to be removed by society ಅಂತ demarcation ಆಗಿದೆ. So
I have put up a temporary construction to safeguard the property.
ಅದು ಯಾರ್ದು?
This is only for the purpose of
issue of khata.
So if you have handed over the area to the GBA,
yes, my lords.
Please impede the GBA. We'll direct the GBA to pass appropriate.
But ಅದು ಅಪ್ರೂವಲ್ ಕೊಡುವಾಗ ಸೊಸೈಟಿ ಅವರು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಈ ಸೈಟ್ ಗೆ, because there is some concern over that particular site.
Khata was already made out in the name.
Yes. ಬೇರೆ ಪಕ್ಕದ ಸೈಟ್ ಗೆ ಆಗಿದೆ, ನಮ್ ಸೈಟ್ ಗೆ ಆಗಿಲ್ಲ ಅಂತ ದೇರ್ ಅಲಿಗೇಷನ್.
ಹೌದು, ಎಲ್ಲ ಲೈನ್ ಅಲ್ಲಿ ಎಲ್ಲದಕ್ಕೂ ಆಗಿದೆ.
ಅದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇರೋ ಸೈಟ್ ಗೆ ಸರ್ ಇದೊಂದು ಇದು ಮಾಡಿದ್ದಾರೆ, ನೋಟ್ ಮಾಡಿದ್ದಾರೆ, ಸೊಸೈಟಿ ಇಂದಾನೆ ನೋಟ್ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿಗಲ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದೆ ಅಂತ.
I have not put up ಇಲ್ಲಿ, I have
ಅಲ್ಲ ಸರ್, ಅವ್ರು ಹೇಳ್ತಿರೋದು ನೀವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ.
ಆಯ್ತು, ಗೊತ್ತಾಯ್ತು.
ಅವ್ರು ಹೇಳ್ತಿರೋದು ಏನು ಹೇಳಿ?
ಇಲ್ಲಿಗಲ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ, ಅದರಿಂದ ನಾನು ಕೊಡಕ್ಕೆ.
ಸೊಸೈಟಿ ಅವರೇನೆ, ಸೊಸೈಟಿ ಅವರು ಲೇಔಟ್ ಪ್ಲಾನ್ ಕೇಳುವಾಗ ಅವರೇ ಬರ್ದಿದಾರಂತೆ ಪ್ಲಾನ್ ಅಲ್ಲಿ, ಈ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಇಲ್ಲಿಗಲ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದೆ, ಇದನ್ನ ಬಿಟ್ಟು ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿ ಅಂತ.
Let them produce that document.
ಅದನ್ನೇ ಅವ್ರು ಹೇಳ್ತಿರೋದು.
ಅಲ್ಲ ಇಲ್ಲ, because when I bought the site was vacant, I have put up a temporary construction taking WhatsApp. ಅಲ್ಲ ಮಾಡಿದಾಗ ಇರ್ಲಿಲ್ಲ.
ಗೊತ್ತಿಲ್ಲ.
Plan approval ಆಗಿರೋದು. If society can come on record and justify this, then.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? ಆರ್ ವಿ ಜಯಪ್ರಕಾಶ್.
ಯಾರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ.
So ಆರ್ ವಿ ಜಯಪ್ರಕಾಶ್ appears.
ಅಲ್ಲ ನಾನು ಕೊಟ್ಟಾಗ ಅಟ್ಲೀಸ್ಟ್ ಬಿಡಿ ನನಗೆ ಆ ತರ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ.
Office is directed to delete the name of Vasanta for R1 and R2 and continue the name of Deepthi Ayatan for R1 and R2. Process ಕೊಟ್ಟಿದ್ದೀರಾ?
Process ಇನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ. I will furnish a copy.
R3 ಗೆ ಒಂದು process ಕೊಡಿ.
I will.
ಯಾಕಂದ್ರೆ ಜಯಪ್ರಕಾಶ್ ಅವರು ನಾರ್ಮಲಿ ಅಪಿಯರ್ ಆಗ್ತಾರೆ NTI and why has not come today?
I will furnish.
Learn counsel for the petitions directed to take out to pay process to issue notice to respondent number 3.
Milord, GBA also maybe have made a party.
No,
I will make a.
It is open for him. HC Sundaresh.
Sundaresh HC. Appear for petition this case. This is only a mandamus to consider my reputation for allotment of alternative site. A site was allotted in favor of the petition's vendor in the year 2000. Then Melad at Nana Bharati layout. Then Melad the lease, the sale deed was also executed in his favor.
Mr. Ready now?
Next week, instruction to BDA next week.
Yaar NR Girish has appeared.
Yes,
Girish.
Yes, ma'am.
Your Girish as colleague.
Junior.
Office director delete the name of Mr. G.A. Gopi for respondents and continue the name of Mr. N.R. Girisha. Learn counsel for the response 1 and 2 seeks time. List on. Yes. Somshekar.
14th August. 11:55. Somshekar KM.
Urgesh Charati.
Seeking in the nature of mandamus, my lord, allot a site number 317, my lord. By virtue of endorsement, my lord, they have issued an endorsement stating that, my lord, petitioner is entitled for alternative site.
I think 317 ಕೊಡಿ ಅಂತ ಯಾಕೆ ಹೇಳ್ತಿದ್ರಾ?
Your lordship, kindly see annexure E, my lord, themselves have referred for to current dimension report, annexure E. The deputy secretary, my lord, page 24, my lord, directed the executive engineer to submit report in respect of 317. Availability of site in this revenue site was acquired for formation of road. Then he submitted a report, my lord, annexure F. Allot yargo agilla, eno agilla adu, as it is.
Yes.
I seek information, my lord. Kindly.
If this site is available for allotment, why don't you give it to him?
EC no ಹಾಕಿದ್ದೀನಿ, ಯಾರಿಗೂ ಅಲಾಟ್ ಆಗಿಲ್ಲ, ಅವರೇ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. There is no allotted to anybody. Annexure G is a current dimension report.
Intimation letter it is issued by the BDA, my lord. I need to.
No, CD
Once I will go
report
through the file, my
ಕೊಟ್ಟಿದ್ದಾರಮ್ಮ.
lord. Once I will go through the file, my lord.
Learn counsel for the response 1 and 2 submits that the respondent number 1 and 2 have not interested the wakalat. Full stop. She also seeks time to secure instructions. Hence list on phones.